One.
Good morning. Recognizing quorum of commissioners, I call the September 19th, 2023 meeting of the Cannabis Control Commission to order. This meeting is being held remotely pursuant to Chapter 22 of the Acts of 2022 and is being recorded. Commissioners Camargo, Stebbins, Roy, and myself are participating in today's meeting. All votes taken today will be by roll call. We have a full agenda, to say the least, today, and I will generally summarize. First, we will begin with opening comments from my fellow commissioners and then myself, and then move into discussions on draft regulations regarding host community agreements, municipal equity, and marijuana establishment agent suitability. I anticipate this will be a live drafting session, and edits will be incorporated following discussions in order to be voted on. I'll ask that my commissioners wishing to comment or ask questions throughout today's hearing during any part of the meeting today raise their hand to be recognized. And with that said, I believe we'll go in alphabetical order today. We'll do reverse alphabetical order. So Commissioner Stebbins, if you wish to make any opening comments.
Thank you, Chair. Just appreciate the good work yesterday and look forward to hopefully finishing up today or tomorrow, but appreciate the great dialogue, conversation, and the great work of our team supporting us through this process.
Thank you, Commissioner Stebbins. Commissioner Roy?
Thank you, Madam Chair. I'll ditto Commissioner Stebbins. Looking forward to tackling wrapping up HCAs today and hopefully CIFs, and looking forward to tackling municipal equity and suitability. And these are all critically important topics. So I'm just excited. I want to thank Enforcement Counsel Lopez for being here yesterday to provide her expertise. And I want to thank Director Potvin for making a traffic-filled journey here to join us this morning. So thank you so much. And thank you to the entire team here. Thank you.
Thank you, Commissioner Roy. Commissioner Camargo.
Good morning. Thank you, and ditto to all the comments. Looking forward to getting to work.
Thank you, Commissioner Camargo. And I just want to start off by first thanking my colleagues for trusting me in this process, at least for the regulatory component of our work. I know that there's some added attention to the work of the Cannabis Control Commission. There might be some more viewers than we usually have for whatever reason, but I think that that's great and we welcome it, because what you are witnessing throughout these next few days is the core of our work. The decisions we make in the next few days will really outline and lay the groundwork for the industry going forward. And we already have seen what can happen in just 5 short years. So this is the first time we've really had any comprehensive changes since the creation of the Cannabis Control Commission in 2018. And I raise that pretty frequently because I want people to understand the significance of this moment, the work that went into this moment, what we're doing today, and the incredible amount of energy, hours, thoughtfulness by not only our team here at the Cannabis Control Commission, but external stakeholders as well, including the many advocates who have called for these changes for some time now. So I'll again extend my gratitude and thankfulness for everyone who was involved in this. And I look forward to really focusing on our work, the regulations, and I welcome anyone who's watching to really comb through our draft, follow us as we work through these regulations, and really see what we do and what we've been doing for some time now. So with that said, we move on to commissioners' comments and updates. With those initial comments, I'll turn things over. Host community agreements. So let's get right into the meat today. I'll now turn things over to our Deputy General Counsel, Michael Baker, to introduce the section on host community agreements. And if I recall, we are on page 71.
Yep, so it's 500.180, subsection 3.
Yes. Okay, so I believe we stopped before going into 3.
Mm-hmm.
So, yeah, so I think there was still some conversation around 7 and 8 above in subsection 2.
7 and 8.
Oh, J. subsection J and 7, 8. They're all right above.
71.
It's page 71, 7 and 8. 7 reading, a provision that obligates a marijuana establishment to set aside money in any escrow, bond, or other similar account for a host community's use or purposes. 8 reading, a provision that requires a marijuana establishment to make any additional payments or obligations, including but not limited to monetary payments, in-kind contributions, providing staffing, advance payments, or charitable contributions by a marijuana establishment to a host community or any other organization. Deputy Counsel Baker, I think you might be alluding to some of the comments from Commissioner Roy. Is that correct?
She had a couple things she wanted to bring up today.
Commissioner Roy, did you want to
Yes,
bring?
thank you. So we were talking about in statute that all responsibilities and stipulations need to be stated, and I was just wondering if we should reassert that language and add additional language that including but not limited to all contractual vehicles.
Was there a specific part of this section that you were thinking?
I will defer to your legal expertise for where you think would be most appropriate.
If I may,
Commissioner Camargo?
Commissioner Ward, can you just refresh our memory? You said vehicles at the end, like literally vehicles?
No, like a contractual vehicle
Oh, okay.
is executed between a municipality and a
Got it.
party. So it's been brought to my attention countless times that there are these contractual vehicles that are being executed, MOUs, MOAs. Right.
Yeah, thank you. So are you trying to add a new number on here, Commissioner Roy?
So what I'm trying to do is lift the direct language from 180 and then add additional language to that.
Commissioner Roy, do you mind restating?
Yeah, I was just going to type that out. So, Kyle, all stipulations and responsibilities. Right. Let me just type it out and I'll throw it in the chat.
I see Enforcement Counsel Lopez. Enforcement Counsel Lopez, please.
Good morning. Thank you, Madam Chair. So Commissioner Roy, putting some thought into where we left the meeting off yesterday and what you want to reassert. I would suggest that we consider putting a new section under subsection I, which is prohibitions, because what we're essentially talking about is a prohibition that states that a host community may not attempt to, circumvent these regulations by using other contracts to achieve some of the to basically circumvent the regulations. So we need to come up with the language, but I think the prohibition section probably makes the most sense, because the section we're in currently right now is speaking specifically to terms, conditions, or clauses that are prohibited in an HCA. And what your policy concern seems to be is the use of other instruments outside of the HCA to basically try to obtain payments or other promises that would be inconsistent with the law. So, so that would be my suggestion.
Thank you, Enforcement Counselor Lopez.
Commissioner Roy, what are your thoughts on that placement suggestion?
Yes, I agree. If everyone's in agreement, I think that's appropriate.
Commissioner Stebbins?
I'm just looking at the language now. I like Councilor Lopez's suggestion. I'm not sure if there's any difference here between starting it with any instead of all, but
No.
that's.
Commissioner Camargo?
I'm okay. I think the new section where Attorney Lopez is talking about makes sense.
Okay, I agree. I think we can move on. Okay, so Commissioner Roy, Commissioner Stebbins, Commissioner Camargo, are we okay moving on to subsection 3?
Yes.
Okay, I'll turn it back over to you, Attorney Baker.
One second. so we're just going to go down to the next section, which is 3 here, and I will read it.
Mike, turn your mic on.
We're going to subsection 3 here. So review and certification of host community agreements. The commission, through its executive director or director's delegee, shall review an HCA submitted by a licensed applicant or marijuana establishment and make a determination certifying whether the HCA in whole or in part satisfies commission requirements. The commission shall complete its review of an HCA within 90 days of receiving an HCA from a marijuana establishment. The commission may request additional information or send determination notices identifying deficiencies in an HCA. Submission of an amended HCA resets the 90-day period of commission review. All right. Under subsection B here, review of HCA submitted by licensed applicants. 1, all applications for initial licensure submitted on or after May 1st, 2024 must include an HCA that complies with 935 CMR 500 or a compliant HCA waiver. 2, the commission may request an additional information from a licensed applicant or a host community in connection with this review.
Attorney Baker, I'll pause here because we've had a number of comments about the date listed under B1. It's also for C1. I know we haven't gotten there yet, but I at least wanted to take a pause there so that we can have a discussion around this date and whether or not it should remain or if it should be an earlier date. And I guess I'll start by asking Director Potvin just for some input and insight about the date, rationale, and what we should be mindful of as we talk about this.
Thank you, Chair. The working group for host community agreements did deliberate on this date significantly. There was a lot of thought that went behind this. As these are new rules, very intense, very widely going to be widely affecting all populations in this industry, there needs to be, or at least the thought was, there needs to be time once these regulations are actually promulgated for the industry, not only for marijuana establishments and licensed applicants, but municipalities to know and be on notice what the rules actually are and give them a grace period, which essentially, if the regulations are promulgated in November, it would give them a little bit less than 6 months to get accustomed to it, make any adjustments to current HCAs that are in existence so that they can come into compliance. Having a sooner date would put them a little bit more under, would apply more time pressure. So 6 months, and again, these are essentially contracts. So some of these things cannot be redone or come into compliance overnight between these parties. The second part of that, the other side of that analysis is also internally for staff. Staff have to become comfortable with whatever the final promulgated regulations are. And as was discussed a little bit yesterday, once the regulations are promulgated, that is not the end of the policy cycle. Now we have to get into implementation. How are we going to receive this? Do we have to make changes to our electronic licensing system? Do we need to create a model HCA? Do we need to update guidance documents? Do we need to train staff on how to assess these? So within the working group, that 6 month period seemed like that was a reasonable amount of time, not only for staff internally, but externally, especially for industry and municipalities.
That is helpful. And I think that it's helpful to clarify the fact that the expectation is for people to follow the law today. That this date doesn't mean that we are not asking for compliant HCAs. I'll let you jump in if you, I can see you nodding. Go ahead.
I think I know. I think I know where you were going with this. The current Chapter 180 of the Acts of 2022 went into effect November 9th of 2022. It is law. This date of May 1st, 2024, that's in the draft regulations, is to allow for the commission to start enforcing it. That doesn't mean that the law is not applicable right now to parties who want to, that should be following it or taking, using it to their benefit. it is law. This May 1st, 2024 date is applicable to the commission's enforcement of these regulations with our participants, our marijuana establishments, our licensed applicants.
Thank you, Director Pop. Commissioner Camargo.
Yeah, so I have a lot of questions around this. So as of right now, you have the May 1st date. When does the work start internally, like from your perspective? Like when would the review actually start?
When would the review of an HCA and
Because we're right now we have May 1st, right? But like, is our team internally going to be ready, boom, May 1st? Or how would that work? How are you thinking operationally?
so there are a lot of different moving parts that are going to implicate different departments within the commission, not only investigations and enforcement. The date, May 1st, was based on a lot of input from the working group, and in our working group were different participants from different departments. The May 1st date, giving the staff 6 months to implement this, seemed like a reasonable amount. So based on this, the goal would be to start reviewing these on or after May 1st, but by May 1st is the goal. So if an applicant submitted an application after May 1st, the goal would be that all the implementation has happened. So now when they go into Mass CIP, they're prompted not to submit a certification of an HCA. They're prompted to submit the HCA or the HCA waiver. And then staff would be able to assess it based on these new rules that are being decided right now. So that's the goal.
Okay. And then just a follow-up question. So what would be, and I know this is a policy matter for us to decide, but would be good to hear from you in terms of a look back date, right? Because the beef right now is that the law went into effect on November 9th. Municipalities are still collecting impact fees for no impact for some of them. So when will the look back start? Will it be as of November 10th, 2022 for us?
So my recollection in these draft regulations is that there is nothing that addresses that look back. So hypothetically, if an application was submitted on May 1st, 2024, and they submitted an HCA that was, say, executed on 9/10/2022, or even earlier, they're submitting a new application. The new application with this requirement needs to comply with the regulations in place at the time.
And I'll add a comment, because this is for the initial HCAs, but then I know we have not gotten there yet.
Right.
C talks about at renewal, so all HCAs will eventually be reviewed because they're going through that circular process.
Exactly. I believe the understanding from the working group and what's been drafted is that any HCA that's submitted after May 1st, 2024, no matter when it was signed and executed, must now comply with the regulations, whether you're a new applicant or whether you're submitting a renewal application. And I believe that is a mandate based on the statute. But that is different. I do want to make a distinction between that and community impact fees.
Yeah, it's definitely two different things for sure. Yeah, but thank you.
Commissioner Roy?
Thank you, Kyle, for that explanation, and I was part of this working group. And to Commissioner Camargo's point, like, we are getting testimony that this window for some folks is going to cost an additional $500,000 that the municipality is still charging. And I understand it's the law, but not everybody has the means to take it to a court of competent jurisdiction. So it's kind of a tough position for some folks. So is there a way to still have the time you need, May, and this body could call for a look back? Is there a way to do both? Like, in other words, we didn't talk about a look back, but is there a way to give you till May, but have the look back till November?
And thank you, Commissioner Roy, are you talking about HCAs or are you talking about community impact fees?
HCAs.
Well, HCA's, as of right now, the look back period would be indefinitely.
Yeah.
Because it doesn't matter when it was executed, it depends on when it's submitted for
Okay,
review.
so then how about community impact fees? Is there a way for us as a body to have a look back on those?
I think I'll interject now, just because I want to make sure we have that conversation when we get to the community
Okay.
impact fees. So if we can just table it for now, and then we'll get to it when we get to that section.
Okay.
Commissioner,
Commissioner Camargo?
yeah, thank you. Commissioner Roy, so I spent all weekend, I even drew myself a map. Like, I'm a visual person, so I drew myself a map because it's two different things and it's two different hot topics. So, and that's why I kept asking Kyle about the look back, which you're asking the same thing now. And I think the easiest way for us to think about it is just, it's two different processes. So the May 1st date, it's like, I hear you, Kyle, and I know that the industry and municipalities, are worried about that May 1st date because folks are worried about, well, when does the look back start? So what I'm hearing you say is that whether we pick a May 1st date in this section or a January 1st date, right? Either way, you're going to look back to when the law came through, right? The situation that we have here that we need to decide as commissioners and sort of push back on you all is, is that May 1st? Because that means that you all will start reviewing on May 1st, which means anybody who's renewing, October, November, December, January, February, March, April, May. So we still have 8 more months, for lack of better words, that we're not going to review HCA's, even though the law went into effect last year, right? So that's the balance and the problem. However, we know that you all need time internally to get it together, because otherwise, once those HCA's hit, it's going to be too much on the plate, right? Plus, municipalities need to sort of get ready to understand what's happening. So I think, Commissioner Roy, to your point, it's the balance that we're going to have to figure out. And this is a chunk of Chapter 180. And I think for us as policymakers, we definitely have to think through and walk through this one and find the compromise with, the internal team, municipalities, and the industry. So two different things, May 1st versus, a lot of the commentary was like, well, can you guys balance it and start on January 1st? But I think that's for us to sort of discuss. It might put some more work on you guys start January if we pick the January 1st date. But I understand why the May 1st date. But I think that's the big balance, and that's the big topic here.
Commissioner Stebbins.
Thank you. Excuse me. Thank you, Chair. First of all, appreciate the discussion, and obviously this is the crux of what we've been hearing about. As I was thinking about this conversation, and I think it's important, as right now we're discussing HCA's review of HCA's for compliance. I know we're going to get to community impact fees, which is kind of the nut that created the change, right, for HCA's in the passage of Chapter 180. And obviously, every kind of minute we delay, I think to Commissioner Camargo's point, people are still paying that community impact fee tied to their HCA. And many question, the validity of the costs that they're paying. I appreciate the 6-month window. I think, we need to be mindful that this team not only has to, and I think we have been staffing up and being prepared to handle this when it hits. We also have some work to do on our end because we need to draft a model HCA, which might take some time, might take approval by this body. If you can, and I'm asking you, Director Potvin, looking back over coming up on the last year since the law took effect, we've obviously had a number of people that have renewed since then. Obviously, we handle like 100 or so. It seems like every meeting I read those. I'm trying to just piece in my mind what somebody who wants to go back and say, I renewed, but it was under the, how does a host community and/or how does a licensed applicant or a marijuana establishment, in your mind, view that renewal process kind of in this intervening period after the law took effect? Is it, maybe we went back to our host community and asked them to renegotiate? Does the host community say, until we get guidance, we're not changing our HCA? It might be anecdotal commentary, but I'm just trying to piece what a kind of regulatory clunkiness maybe this last year has been.
So I can say that I have heard in passing, especially with public testimony, but just in passing with inquiries that we get in the normal day-to-day operations of the licensing team in the investigations and enforcement department. It's not a one-size-fits-all. As we know, we have 351 cities and towns. There are probably some towns and some cities that are utilizing this time to come into compliance based on maybe legal advice from their counsel, to say, hey, we know what the law is. We know the commission's going to have additional requirements. We know what the law is and what the spirit of the law is and what the text of the law is. Let's amend it now. That's a possibility. There's also the real possibility that there are some municipalities that are saying, I want to wait until there are more thorough rules, because as we know from the working group and the draft regulations, with the authority that the commission has, there's expanded rules that go into a little bit more detail. So some council for some municipalities might say, let's wait until these rules are finalized. Those are the two big buckets, I think, that are occurring right now. And I don't think there's any, I don't think that necessarily implies any maliciousness or bad faith intention. It's just they don't want to keep on redoing these things because it is time consuming and it could be costly. Those are the two kind of big buckets that I see that are happening and that I'm hearing about.
Director Poffin, I'll throw out a question I have in my mind that I don't think I asked when we were in our working groups. So I will sort of throw out a hypothetical, like we're back in law school. All right, so May 1st is the enforcement date for our purposes. But let's say that there is a licensee that wants to submit their HCA that was already executed for our review. Is there a means to do that or a mechanism that we can use to review prior to renewal?
So prior to the May 1st date?
No, not prior to the,
Okay.
so I'm saying there's this gap of time in between their renewal and they've missed that May, so they executed this before the May 1st date. Do you understand what I'm?
I know exactly the hypothetical, and you are in great company because that was something that was asked last week. And I want to be careful on how I say this, but there was a scenario and an answer that was provided where there is a possibility. Again, processes need to be developed. This is going to be a new world for the investigations and enforcement team on a compliance front. With any requirement where a licensee is maybe we get a complaint about a licensee that is not in compliance with a certain requirement. If we got that complaint, our investigations and compliance team take that, move with it, look into it, we'll assess it, and if need be, if there is in fact violations, issue a notice of deficiency, ask for a plan of correction. If it's not, that might lead then to Enforcement Counsel Lopez's team for a possible enforcement action. So there is a scenario where I see that after May 1st, if we got a complaint saying, hey, my HCA is not compliant with the regulations, and they submit it to us, I do see a scenario where it could follow a new process or an existing process, but based on new policies here, where it could be looked into, it could possibly get into an investigation track, and it could go through establish plan of correction, notice of deficiency, and then maybe even possibly an enforcement action.
Okay.
That is, I think, a real possibility. Again, that would be something that needs to be discussed further with the Chief of Investigations Enforcement, Director of Investigations, but I think that's a possibility.
Do you, and I'm looking at my screen to make sure I'm not missing Enforcement Counsel Lopez, just wave if you want to jump in, but Director Potvin, do you believe that the draft regulations as drafted now, that allows for that to happen the way that okay, I'm looking at Attorney Baker and I'm seeing the
Just
nod.
a little bit further down.
Okay, I'm
right
just,
before community impact fee, there's a subsection D that is complaints alleging non-compliance. That's exactly what you're looking for.
thank you for stating that. Okay.
And there's also, Attorney Baker is absolutely right, but there's also existing policies under the 300 section. It's 301, 302, 303, where that gives the investigations team, the commission as a body, and obviously the investigations and enforcement team ability to assess compliance.
Commissioner Camargo?
So I'm thinking about communications, right, to the public internally, and making sure that when we kind of wrap this conversation that we're very clear, especially of this hypothetical scenario, because I think that sounds like it's a somewhat of a compromise, or, there's still, so my question was going to be, so what do we do in the meantime, right? If we keep the May 1st date, what do we do in the meantime? And it sounds like you're saying that's sort of an option that folks can still come and say, hey, my HCA is not compliant. So that's what I want to clarify in that.
After May 1st.
After May 1st. Okay. All right. So thank you for that clarification. Because if I heard it like that and I'm sitting here, I don't know what the public is hearing.
I should probably rephrase though. So what I was saying is for HCAs that are executed prior to May 1st that are not up for renewal.
Got it.
So there's a window, as a gap in time in between the execution of the HCA and the time that it would normally come before us for a renewal.
Yep.
We're saying that those can still be assessed.
Yeah.
You can still say, I
Got it.
want the CCC
Got it.
to review and assess to make sure that it's in compliance.
Yep, I get it.
I hope that's clear. I
Yeah.
hope, okay.
So someone's going to lose here, right? We're not, this is a hard balance. My other question is, so what, in the meantime, and I know we can all, I know some folks don't like creativity, but I like creativity. In the meantime, what do we do, right? If we stick to that May 1st deadline for all the reasons that we understand, what do we do in the meantime? Because we'll come back to section, the community impact fees, but specifically to this and reviewing the post-community agreements, what do we do? So I'm gonna sort of answer my own question and then sort of give it back to you. At some point here, I also want to sort of introduce some kind of process that if I'm a town and you're an operator and we're good, that I will turn in some attestation document or something that says, hey, we're good, right? I don't even need to wait for the May 1st date. We're good. In order, because my review is coming up, I don't need to do that, right? So I just want to, that's one thing, but I guess I'm trying to figure out what else can we do? And we heard this from testimony, there's specific folks in the legal field that are, working with folks in municipalities and sort of, there's a lot of false information right now, but also miscommunication, and the industry and municipalities, both of them have been waiting since the law went into effect for us to send either a smoke signal or a memo. And we're here today. So we have to really think this through to figure out, if it's a hard May 1st, it's a hard May 1st, but I got to go back and say, these folks are losing money. They're bleeding money in these community impact fees with no impact. And folks are going to shut down in the next 6 months. So so my question is, is there any creativity? Is there a way to push that date forward? I want to be supportive of the internal processes because I know the work that you guys do here, and it is not easy. And this is going to be a whole new world. Like you said, I don't even want to sing the Disney version of it, but it's going to be a whole new world. So help me to process this of what can we do in the meantime, if not a change of date.
I want to jump in just for a second, and then I'll let Director Potvin answer, because they are related HCA's community impact fees, but under the law, and this was the law even before Chapter 180 was passed, there needs to be documentation, essentially a receipt of those charges to make sure that they align with the actual impact. So that existed before. Now Chapter 180 sort of reasserts that and really specifies what's happening, but under these regulations, and we'll get to it, I don't want to get too deep into it, but there's a process that has to happen before those fees can be collected, because we need to make sure that there is an itemized receipt. There is in fact a community impact. So I'll pause there. And that's the reason community impact fees is another big chunk. It's a big conversation. So that's why I don't want us to get into it yet, because it can get a little clunky. But Director Poppins.
Thank you, Madam Chair. Commissioner Camargo, I hear you. And I know exactly where you're coming from. I know what you're representing, and I know there are real issues being faced by real people, real businesses right now with this, and they want action. Thinking outside the box has always been a part of what we as commission staff and as commissioners are been trying to do even before these draft regulations. I think it's a great way to think about things, is to try to pick something out and be kind of exploratory a little bit. Before I go into what, thinking outside the box is also not easy. It's kind of critical thinking. So I don't know if I'm necessarily going to have some answers for you right now that might satisfy where you want to go. But one thing that I do want to say is, in addition to everything else, my explanation about that 6-month period, there's a real possibility of, if we were to rush compliance and enforcement of this, there's a real possibility that we do not get to a level where we're doing things consistently. And as an administrative agency, we're required to not be arbitrary or capricious. We need to have a consistent standard being applied to everybody. These rules are essentially tantamount to contract law. That's not easy. It's not even easy for people who take contract law in law school. So I think there's a cautionary tale here that not only is for everything else that I said about this 6 months, we want to make sure we're applying these rules to everybody in a balanced and equal and consistent manner, so that we do not get into a situation where we are treating anybody differently, number one. So that's another kind of reason why we have to, I think that 6-month period of time is essential. But still, that's a consideration for you as commissioners. But with that being said, I don't know so much of what we can do in the meantime that's out of the box right now. I will certainly be thinking about it. I know others will be too. But once these rules are promulgated, again, that host community model HCA, that's something that needs to be created. That's something that needs to be deliberated. That's something that's going to be talked about. Updated guidance on host community agreements. That's something that's going to need to be revamped just based on these draft regulations. There is, and again, I don't want to volunteer other departments, but I'm sure our communications team is going to play a significant role in, when we are doing these documents, they always do play a significant role in making sure it is, one, reader friendly as much as possible, not as legalese as much as possible, and that it's being sent out through so many different mediums to try to get to the people who need it. So I think along these 6 months, it's not that, hey, these draft regulations get finalized in November and we don't talk about it for 6 months. I don't see a scenario where that's real. I think we're going to be talking about this going on, trying to demystify this along the way, trying to educate along the way. As far as what we can actually do that's substantive, that helps where I think where you want to go help people before that May 1st date, I don't know right now.
I will.
Madam Chair, if I may.
Enforcement Counsel Lopez, and then Commissioner Roy, but Enforcement Counsel Lopez, please.
Thank you very much, Madam Chair. Commissioner Camargo, thank you for raising these points. Thank you to all the commissioners for raising these points. As Director Poffin said, this is, the May 1st deadline, and what the date that we begin to review these agreements for compliance is a policy decision. It's completely your call, but to inform your policy decision, I would say that it's important to keep in mind that that date is there just as much for the host communities and the licensees as it is for us, because essentially we're giving people the rules of the road in terms of what the future compliant future is going to look like in terms of their relationship with each other contractually. We're giving them the rules of the road. If these regulations are approved, maybe, now, but officially in November. And it's really important that they have time to renegotiate these contracts so that they are compliant. They're all going to be in different stages of the renewal process. And so this is about really preparing everyone who is going to be impacted by this by giving them enough time. If we move the date too soon, then you're taking that time away from host communities and licensees just as much as the commission in terms of getting ready to actually have HCAs that conform with the new laws. And I do think we want to be mindful of that. I would suggest being mindful of that. But in terms of what we can do in the meantime, I think it's really going to come down to a lot of education and preparation. So once the final regulations, a final draft is approved and voted by this body, I would say that the gears already will start to shift towards education and preparation mode for the agency. I think we would want to start thinking about working on the model HCA, thinking about a CIF guidance, thinking about what Director Potvin noted about modifying the HCA guidance that we currently have. And we can do as many kind of communications to our stakeholders as is necessary to just kind of prepare them for what's coming in the meantime, to give them guidance so that they can take the most advantage possible of this 6-month period to be ready for, or whatever period you choose, to be ready for when our review and when our compliance standard actually goes into effect. And the last point I'll just note is that Commissioner Camargo, I think you identified or suggested a process where if there's no dispute and the two parties believe that they're all good, that they could just submit maybe a document or an attestation to that effect. I will say that the legislature did require the commission to review and approve each HCA. So that is now a statutory obligation that we have as part of our compliance monitoring functions. So that's something to keep in mind. But in terms of creativity, I defer to you as the policymaker.
Thank you, Enforcement Counsel Lopez. That's really helpful. Commissioner Roy.
Thank you, Madam Chair. Director Potvin, how many days in advance should an ME submit for their renewal to the commission?
The requirement right now is 60 days prior, at least 60 days prior, but as discussed yesterday, that was modified to at least 90 days. Yeah.
Okay, so the commission has 90 days to rule and opine, according to Chapter 180 on the new HCA, whether or not. So okay, 90 days for the ME to get us the renewal information prior to renewal. Then the commission has 90 days to rule and opine on its compliance, correct?
I don't know.
All right, let me use the statutory review, certify, approve.
Yeah.
Let me stick with the statutory language. Okay, so is that correct?
That's correct.
Okay. So theoretically, if we start to review, certify, and approve on May 1st, theoretically, we wouldn't really rule until August 1st, possibly, because we have 90 days.
That is a possibility, yes.
Yes, so that's almost a year from today. So I'm trying to be creative. If we begin to rule, certify, and approve on May 1, is it possible that the ones submitted on February 1st, 90 days in advance of when we begin to rule, certify, and approve, we could start backtrack that 90-day window to everything submitted February 1, because now we have the ability to stick with that May 1st for the ones that are in the queue.
So I think I understand these.
Okay, is it okay if I answer her question? Yeah,
No,
thank
I know
you.
what you're saying.
Oh.
You're saying it's like a map, but I know.
Okay, I'm just trying to be creative.
Yeah.
So I think I know what you're saying. This is not the first time we've come up with this type of scenario, because in past promulgations, there have been requirements. One example is energy. One example is it's been a couple of years, but there was another example of when we had to start enforcing something, and it was but what if it happened beforehand, it's submitted beforehand, it kind of carried over the date? Is it when it was initially submitted? Was it when it's being finally submitted or final review before it would come to the commission? We have faced that scenario. I'm looking at this language right now we'll just talk about well, I think it would be applicable not only to B1, it would be C1. So all applications for initial licensure submitted on or after May 1st, 2024. So let's say the application was originally submitted April 1st, 2024. At that point, we're not going to require the host community agreement. We're not going to assess the host community agreement. But based on this language, it's not saying initially submitted, it's saying submitted. So if it's a case where it got reopened, and this is where the awkwardness comes in, but also at the same time, this is compliance, is if it was we sent out a request for information and then they resubmitted May 2nd of 2024. At that point, based on this, in the enforceability and the requirements of this, and based on this rule, we would then have to ask them for their host community agreement. So that's, as written right now, is how that's one way that it could be interpreted.
Director Poppin, I want to make sure that I'll say for myself that I understand what you're saying here. So if someone submits an initial application, May 1st, actually, do you mind just repeating it? Just repeat it in a different way. I don't want to say it back to you. Yeah.
And I'm sorry, it's all in my head. So let me try to be a little bit more clear. So there's a situation where somebody submits a new application for licensure or renewal application on April 1st. So 1 month before we start enforcing this and even asking for it. We will just make sure that they have that HCA certification still at that point. But let's say they had other deficiencies in their application. Let's say, for example, their security plan wasn't compliant. And we sent them a request for information, please amend your security plan to comply with the regulations. And then they resubmit their application on May 2nd of 2024. And in the case of a new license application, we would have to ask them, one way to interpret this is that we would have to then ask them for their HCA and assess their HCA at that point.
So we're saying that the term applications means complete application. It means when it's completed.
Submitted. Whenever it's submitted.
Whenever it is submitted. Commissioner Roy?
And that's for initial application. What you just explained is for.
It would apply to renewal applications as well.
Applies to renewal as well. Oh my gosh, she's literally getting a whiteboard. Okay.
This is our meeting and we gotta figure it out and we all see and
Okay.
things differently. So yes, I have a whiteboard in the marker.
Stakes are high. Let's bring out all the tools.
So, Director Pottman, if the commission decided to tinker with the language on one?
So to make sure to make sure the industry is on notice and that the goalpost doesn't change for somebody in this period of time, that in that hypothetical, one way to make this clear as a matter of policy could be an amendment that says, like, for B1 and C1, all applications for initial licensure that are initially submitted on or after May 1st. So that first click of that submit button on a new application or a license application or a renewal application. So when the first submission. So that would be in the situation I gave you before where somebody submitted April 1st initially of 2024. They initially submitted April 1st of 2024. We would not apply that HCA standard to them throughout their new application or their renewal application, just for that one time. They would require their next renewal would be required to submit it at that point.
Enforcement Counsel Lopez.
Thank you, Madam Chair. I think now would probably be a good time, since we're including in this discussion renewal and not limiting it to initial applications. I do want to take this moment to let the commissioners know that we did receive public comment regarding whether or not HCAs have to be reviewed or have to be submitted as part of a renewal application. The public comment did include, a legal interpretation, and essentially what the public comment was stating was that the language of the statute says that the commission shall review and approve each host community as part of a completed marijuana establishment or medical marijuana treatment center license application and at each license renewal. And this public comment was speaking to the phrase "and at each license renewal," not necessarily meaning that while it has to happen at renewal of the license, not necessarily meaning that it has to be tied to or done as part of the review of the renewal application. And the reason why I raised this is because that public comment also noted that the language in that part of the statute proceeds to state that the commission shall not approve a final license application unless the commission approves the HCA and certifies that the HCA complies. But it does not have that same language for renewal applications. So this public comment did suggest bifurcating HCA review from renewal application review. And the reason why I raise it is because in terms of the actual legal assessment, I do agree with it. And the plain language of the statute does not necessarily tie the policymakers' hands to having the HCA review and approval at renewal happen within the renewal application process. So I wanted to share that with you because ultimately, of course, the legal team may have their own assessment. I did connect with members of the legal team on this point, and I'd be happy to, invite our acting general counsel to weigh in, but I just wanted to flag that before we continue these conversations, because there may be some room for you to make some other policy changes or developments. Attorney Carter?
Well, before, Attorney Carter, did you have additional comments and related to Enforcement Counsel Lopez's statements?
Thank you, Madam Chair. I would say that my analysis is similar to Councilor Lopez. We did discuss this matter, and I agree that I think the renewal process, it does not necessarily need to be folded in the HCA review. So I think that that's certainly a policy consideration for the body.
Thank you. Commissioner Stebbins?
Thank you both, Enforcement Counsel Lopez and Attorney Carter. So help me clarify this. I'm coming up for renewal. That first time of renewal, I need to have my HCA reviewed for compliance, but subsequent renewals, I do not? Or are you saying that at the renewal time of my license as a marijuana establishment, my HCA does not need to be reviewed?
May I respond?
Yes, Enforcement Counsel Lopez, please.
Thank you, Madam Chair. I believe, and Attorney Carter, please correct me if I'm wrong, but I believe what the public comment was speaking to is a bifurcation of the process. So the licensee does submit their HCA for review, but the renewal application is not prevented from moving forward pending a compliance determination on the HCA. HCA still needs to be reviewed and a determination made within 90 days, but that doesn't necessarily have to keep the application from progressing in terms of the actual renewal of the license. Renewal of the license doesn't necessarily have to be held up by the HCA review. And that way they can be separate reviews.
Commissioner Roy?
Thank you, Madam Chair. Is this opening because Chapter 180 is not in alignment with our processes here at the Commission? So reading from Chapter 180, that upon the first annual renewal by the Commission of a final license, we don't renew final licenses. So does that lend itself to being what you're saying and being creative? Because Chapter 180 is not in alignment. The Commission does not review final licenses.
I know that the legislature, I'm not sure that I can speak to that, but I think that I would defer to Director Potvin in terms of his opinion on that. But I do think that that could be indicative of, maybe there being just some distance from our process in terms of the language that was used to describe how our operations function.
Director Potvin.
Thank you, Madam Chair. EC Lopez, or Acting General Counsel Carter. So essentially, the interpretation that you're bringing before us today is saying that a host community agreement needs to be assessed in a new license application, but not necessarily a renewal application. However, we are still required to review and approve at each license renewal per the statute. So instead of requiring it in a renewal application, we would require it in a separate and distinct process every year.
That it could be a separate review process.
So a separate submission. So now a licensee who's annually renewing would have to submit 2 separate applications for review, one for their renewal application and one for the HCA.
I'm not sure it would be an HCA application. They would be submitting their HCA at renew, but it would be reviewed separately, not in connection with the renewal application.
So it would be 2 separate submissions that a licensee would have to submit to the commission annually.
It would be a bifurcated review process, so that the renewal application, if it's otherwise complete, then the renewal application could proceed.
EC, I like that better. EC Lopez. So you're saying, I want to make sure I'm understanding this correctly. It's so a licensee has one submission. They submit the renewal application, the HCA, it's all submitted simultaneously, but the review, our internal processes is where there's separate timestamps, time periods, because there's different reviews happening. I want to make sure I'm understanding what you're saying.
So in terms of the policy, that would be something that would need to be developed here by the body. But in terms of the actual, what the law states, the law does support if the commissioners wanted to explore a policy where you have a bifurcated review system that does not review the HCA contingent on or embedded within the renewal application, you could do that. That's what we are saying. Whether you do it and how you do it, that's the policy development that I defer to the commissioners on.
Okay. Attorney Baker, did I see your hand?
Sure, I think we like to do hypotheticals, so let's just do one really quick. So I'm a cannabis business. I am up for renewal on June 1st. I submit all of the documents required. I would still go through the normal renewal process as we have today. However, I think what Enforcement Council is saying is now we have 90 days to review the HCA and community impact fee in addition to that. So there could be a separation here if you so choose.
I see. And the purpose is so that we're not creating a bottleneck. So we're not, okay, got it. Commissioner Camargo?
Yeah, a couple of things I want to kind of just go back. Rebecca, I'll hold this because I want to just clarify on the law. But so I hear our conversation, and I'm glad that we're having the conversation in public because I think it's key, and we have all our team members here to help us think this through. What does this do for the May 1st date? Because I heard your argument in terms of what needs to be in place. So, I get it. So I guess where we're at right now, what does this do for that? And Rebecca, I'm hearing you say that we can have a policy discussion on this sort of like two-prong approach if we wanted to, but that's like a bigger conversation. Obviously we have to have it now and here, but it's a bigger conversation. So I just want to, because we're talking, so I just want to kind of bring it back to what does this mean for the overall? If that's.
I wonder, so our enforcement council's, I won't say it's a suggestion, but what you've laid out for that bifurcated process, that's more of an internal process that I guess my question is to our acting general counsel and deputy general counsel, if that's something that needs to be outlined and drafted in regulations, or if that's something that we can develop internally, separate and aside from the regulations. So I guess acting general counsel Carter, please.
If I may, Madam Chair.
Yes, please.
Yes, thank you. So how the commission interprets its regulations and develops processes around them is an internal discussion, that falls on us. But what I would say is the regulations are the rules that both municipalities and host communities and our licensees must comply with. So I think as it relates to clarity, I think that there needs to be at least an understanding, probably embedded in the regs, that the renewal process is one process, and then the separate process, parallel, as Councilor Lopez has alluded to, will be conducted separate and apart. So I would suggest that we put it in the regulations, and we can use some language, a form and a manner, as we think about sort of to Director Popvin's point as it relates to submission. I think how we want to build it out on Mass CIP, I think that falls within the commission's internal processes, but I do think that the reg would be an appropriate place to embed this.
Okay. Director Poppin. Director Poppin in the. Okay.
Thank you, Madam Chair. So I understand where Acting General Counsel and AC Lopez is coming from in their interpretation, which I believe is the statement, and please make sure I'm looking at the same thing that you're referencing. The commission shall review and approve each host community agreement as part of a completed marijuana establishment or medical marijuana treatment center license application and at each license renewal. And because it's not saying each renewal application, that's in that difference there in the language is why, one of the reasons why you're coming up with the fact that this could be a bifurcated process or a bifurcated review. Is that accurate?
AC Lopez.
It's both that and the fact that the provision continues on to say that the commission, to expressly say that the commission shall not approve a final license application unless the commission approves an HCA and certifies HCA compliance. That same language is not there for a renewal application, which kind of makes sense when you look at section 6 of our statute, which requires us to approve a renewal if certain conditions are met.
Thank you for that. So I guess I read that a little differently. I read that next statement, that next phrase that you just said, the commission shall not approve a final license application unless the commission approves the host community agreement. I looked at that as a gap filler for those who had a provisional license, had already been approved for a provisional license, where their HCA wasn't approved, but now they're coming up for a final license, maybe before renewal or after renewal or before renewal, and the commission cannot approve that final license unless the HCA has been approved. But I guess there's some I think a little conflict there, because the first sentence shall review and approve each host community agreement as part of a completed marijuana establishment license application. So it's saying that you have to approve it then, you have to approve it at a final license. So there's some conflict there, but that's why I thought that statement was there. It was as a gap filler for where people are in the process and when this law went into effect. However, again, I'm not gonna, I trust in your legal opinion, also in General Counsel, Acting General Counsel Carter's legal opinion. I would say as part of a process argument, that could be really confusing. And it's also, I think the communication strategy around, hey, well, we're gonna set you up for your renewal, but we're still assessing your HCA. And now you have two separate things going on. In addition to when we get to community impact fees, you have now three separate things that licensees have to address. It seems administratively burdensome and could be confusing for compliance. So I put that out there for, at least from a process, a real life possibility. But ultimately, I do still defer to Acting General Counsel and EC Lopez.
Commissioner Camargo?
Can we take a break? 5-minute break?
We can take a break. Okay, let's see, it's 10:18 now. Let's say we'll take a break until 10:25, just to give some, a good amount of time to do whatever needs to be done. So we have a motion to recess until 10:25. Commissioner Camargo, do I have a motion? Commissioner Roy, do I have a second?
Second.
Okay, I will now do a call the roll. Commissioner Camargo?
Aye.
Commissioner Roy?
Aye.
Commissioner Stebbins?
Aye.
The chair votes aye. We are recessed until 10:25. All right, perfect. Recognizing a quorum of commissioners, we will now continue our meeting. Okay, so where did we leave off? We left off, Attorney Baker, do you mind? 3B1, that's right. Our discussion around the May 1st date for HCA review, the initial licensure submission. Okay. Are there any additional comments? I know Commissioner Camargo, you've been putting any things on the whiteboard. I don't know if you wanted to walk us through your thinking.
No, I mean, I just put some stuff on the board so that we can look at it. I know that there's an interpretation of the law in terms of what Rebecca's saying in terms of the process. So I'm just trying to figure out, I'm just trying to think through that. Also, like just had a question, and I know this relates to impact fees, but could relate to the May 1st date as well. So would an earlier implementation date for community impact fees conflict with the May 1st HCA review date? So would an earlier implementation date for community impact fees conflict with May 1st HCA review date?
I'm looking at Director Potvin, EC Lopez, if either of you want to opine.
If I remember correctly, I think the assessment of community impact fees, the date on that was for enforcement purposes. I think it was May 1st, 2025. Because we're not at that section yet, though, Commissioner, I'm not positive.
Got it.
I don't want to rule it out.
Mm-hmm.
Can we, can you ask that question again?
Mm-hmm.
When we actually go through the dates for the community impact fees?
Mm-hmm.
Okay. Commissioner Roy?
Director Potvin. It's laid out with two scenarios, either bifurcate the process or slide it before May 1st to an earlier date than May 1st. Out of those two scenarios, if the commission were to ponder those two, either bifurcate the process of the renewals of the HCAs, or instead of May 1st, create an earlier date of what is less burdensome of the two, which is less burdensome on staff out of the two scenarios.
Madam Chair, if I may.
Yes, Director. I have a follow-up question, but first I'll let you answer Director Potvin.
So I look at those as two different situations. So if we're talking about a bifurcated process that gets enshrined and promulgated through the regulations, that's going to be the process moving forward over time.
Correct.
That process, that bifurcated process itself, to me, can seem problematic right now just because I'm reacting to it for the very first time.
Right.
And it does seem an additional administrative burden. But that's the issue, the potential issue I see with that. That's separate and aside from moving that May 1st date. I don't think they're connected. And I understand like it might be, hey, let's pick one or the other. However, I still see the rationales being brought forward by investigations and enforcement still apply to that 6-month period, that May 1st date. The bifurcated process, I do think is separate and distinct from that. But that's just, I think they both have their issues and they're both separate. So I would still, at least the May 1st date, for all the reasons said, I think is what's been recommended by the working group. I think that gives enough time. But the interpretation, as Acting General Counsel and EC Lopez says, that is one way to interpret it, is a policy decision for the commission. I do see that presents some administrative burdens, not just for staff, but just more requirements and more deadlines and more due dates for licensees and applicants.
Director Potvin, you've gotten ahead of my question because that and maybe it would be helpful to take a step back because it seems like we're addressing two different concerns right now. One is the HCA review date, when that begins, when we commence that review process. And the other is about the separate creating systems for renewal, where renewal continues, but the HCA review happens separate but simultaneously almost. So I think it would be helpful if we talked about one issue first and then went into the next. So the date is where we started, and that's where this conversation sort of evolved from. So let's resolve the date, and then we can have a conversation about sort of the systems at play for renewal for that HCA review at that point, if that's okay with my fellow commissioners. Okay, Commissioner Stebbins?
Thank you, Chair. First question, right, about the date.
Yes.
I think what staff has presented, I think where we have been operationally as a commission kind of building to in terms of some new people that we brought on board to meet the obligations of Chapter 180 and the new regulatory scheme. I understand the arguments. I hear about the planning and the work that still needs to continue. So based on that, I'm comfortable with the date.
Okay.
As to the second question, the bifurcation, without having dived too deeply into it, I do have some concerns about muddying the process, muddying submission times, muddying submission dates. I also, for my own personal level of confidence, I'm curious about questions about whether that still allows somebody to continue to operate if their essentially renewal is maybe not quote unquote complete. So I do have some questions about that. I'm also, I feel the pulse in the room. I feel the temperature of my colleagues. We're all trying to be innovative. We're all trying to resolve some of the situations we know that exist out there between host communities and licensees, where I think licensees have a strong argument to make that they feel they are paying costs that are unnecessary. So I appreciate the interest in trying to address that issue in kind of throughout this discussion. I'm also mindful of the fact that, and I want to talk about this as we kind of continue to move through the discussion, not only about HCAs, but also about community impact fees, of recognizing those relationships between a host community and a licensed applicant or a marijuana establishment or MTC where there is a good relationship, and that the process is beneficial and in some cases might be rewarded for that. And in realizing, well, I'll stop there, but I hope I answered the first question and kind of just shared my thoughts on the second question.
I think I'm in a similar place. I'm with you there, Commissioner Stebbins. Kyle, Director Puffin, thank you for really explaining the mentality, the thought process that went into that date. I appreciate, initially, I was at a different place. I will say that out loud. I came in and I thought, for all the reasons that we heard through the public comment period, that this needed to be an earlier date, maybe January, so that it would alleviate some of the pressure and the burden on licensees. But I can understand in the way that you sort of outline things. So that's where I am on the first issue. The second, in terms of the dual process, with the renewal, I think it's important to signal to the industry that renewals will not be contingent on our CCC HCA approval per se. And I mean that in terms of the timing, so that people are still able to operate and continue to function while, if we need to still evaluate an HCA and determine its compliance. I'm looking at you, Director Potvin, so if you want to give some feedback, I welcome it too.
I understand I think I understand the concern is essentially non-compliant HCA's, the commission, or at least from your perspective, you don't want a business to not be able to be renewed if they don't have a compliant HCA.
Yes.
I think that's a perfectly laudable goal. I think I understand where that's coming from. I don't know if it's necessarily consistent with statute.
What part?
The part where the commission shall review and approve each host community agreement as part of a completed marijuana establishment in MTC and at each license renewal. So I think there's an implied requirement that in order to be renewed, you have to have a compliant HCA. However, that's one opinion. And obviously you've heard different opinions here, and I understand the policy goal from where you're coming from. If that was the case, I think the question is then, when does it need to be a compliant HCA, if not at each license renewal? So.
Okay, I hear you. Commissioner Roy, so again, we're asking the date, so I want to know if your opinion on the date, and then the next is on the dual process.
Okay, my question, Director Potvin, is around the HCA's themselves. So do you know anecdotally if some expire after every year, couple years, or are they all in 5 years? Or do you know anything about that anecdotally?
Anecdotally, there's not a one size fits all.
So some expire a year, some could be 2 years, some could be 5 years.
Yes.
Okay. And according to statute, the purpose of an HCA is to establish the conditions in which the ME operates within a community. So right in statute. Let's see. Host community agreement with a host community setting forth the conditions to have an ME located within the host community, which shall include but not limited to all stipulations of responsibilities between the HC and the ME or MTC. So the purpose of the contract is to set forth the conditions in statute. Is that accurate?
The stipulations and responsibilities.
And set forth the conditions in statute. Okay, so since they're all over the map, and some could expire in a year, some could be operating with, if we bifurcate, could it be a plausible scenario? It is a plausible scenario because I know what's happening now. There are some HCAs that are expired and that MEs are operating with expired host community agreements. So I guess my concern is does that lend itself to more confusion if we bifurcate since they're all over the map? And the purpose of the actual host community agreement is to set forth the conditions, and void of that, you no longer have that. The conditions are no longer set forth if it's expired. And we're in this window of bifurcation that the stipulations, responsibilities, and conditions, there are none. There are none that exist.
So the requirement that you're talking about, I think this might lend additional credence to the need for a compliant HCA to be at renewal, which is 94G Section 3D1. A marijuana establishment or MTC seeking a new license or renewal of a license to operate or continue to operate must have an HCA. That's essentially brings out all the conditions and responsibilities and stipulations. Checking this on renewal to make sure one is in existence, I think is essential for them to continue to operate, which is, to my understanding, a statutory mandate.
Requirement.
Yeah.
That was the point of my question.
Yeah.
Commissioner Roy, do you have an opinion about the date?
If I had a magic wand, I'll be honest, I would move the date to January 1. But I don't have a magic wand, and I'm trying to be respectful of your needs of your team. So That's why. I mean, I understand what you're saying. And honestly, though, if I had a magic wand, I would slide it to January 1, but I don't. And I want to be respectful for what your needs are and your team.
Madam Chair, if I may.
Yes.
I thank you for that, Commissioner, but I do want to reiterate, it is not a purely selfish reason for just the licensing team and investigations and enforcement. It's all of investigations and enforcement.
Right. The whole
But it really, really is also significantly and sincerely for industry and municipalities to know what the playing field is and know what the rules of the road are. Give them time to adapt. It is much more wide-ranging than just one team within this commission.
Thank you. Thank you for that clarity. Yes, it's for everyone here that's involved in that process and for stakeholders and news. I get that, and I'm trying to be respectful of that too.
Thank you. And I just, my own 2 cents, if I had a magic wand, I would be right there with you.
Right. Thank you, Director Poffin. Enforcement Counsel Lopez.
Madam Chair, if possible, I would like, can we recognize Acting General Counsel first? Because I think he showed his camera before.
Okay. Acting General Counsel Carter, please.
Yes, if I may, Madam Chair. One of the things, and I don't want to derail the May 1st conversation because it sounds to me like we are moving to consensus amongst the board. But as we think about sort of a bifurcated process that was discussed, one of the powers that the commission does hold under section 4 of 94G sub A sub XI is the power to condition licenses. So I don't know if that may be an avenue we could potentially explore at renewal. That a license may move forward with the condition of a compliant HCA, but maybe that could be an avenue for us to for the board to contemplate as well.
Acting General Counsel Carter, do you mind repeating that?
Yes, absolutely. So one of the powers that the commission has under 94G section 4A sub XI is the power to condition licenses. So as we think about one of the concerns that we've heard, right, is making sure that current operators are able to continue is an avenue that we may wish to utilize a commission power, which is to condition licenses. So historically, we have not conditioned at renewal, is my recollection, but that may be an avenue to contemplate as well.
Commissioner Stebbins, I'll let Commissioner Stebbins opine before I go to Enforcement Counsel, just because I think it's in response to our Acting General Counsel's statements.
It is. Thank you, Acting General Counsel Carter. So you would only make that suggestion of it allows a licensee to continue to operate without final approval of the HC. So you're suggesting we could add that condition if we decided to go the bifurcated route?
Yes, that would be my suggestion, that the commission does have the, oh, excuse me, if I may, Madam Chair.
Please.
Yes, it is my suggestion that the commission does have this authority already. So it's a policy discussion for the board if that is something that you may wish to utilize.
Enforcement Counsel Lopez.
Thank you, Madam Chair. So just to try to maybe play this out a little bit more in terms of what this bifurcated review would look like. So essentially, someone submits their renewal application and their HCA, and then the renewal application they're split in terms of review. The renewal application is reviewed under all of the, for all of the necessary information that is currently required. And in part of that review process, by splitting out the HCA, the renewal application, wouldn't be prevented from moving forward depending on whether or not the HCA has been approved and signed off on, with a approval determination from the commission. So 90 days before the renewal date, that application is submitted, the HCA is submitted, the application is reviewed under the normal course. At the same time during that period, that 90-day period, the HCA is reviewed. At the end of the HCA review, that 90-day period, there is a determination. And let's say that the determination is that it's not compliant. Then the notice gives the licensee options in terms of what they're going to do next. By bifurcating it, the licensee can respond to that notice with those options. Are they going to do a waiver? Are they going to amend and resubmit? Are they going to, proceed with some of the other options that this commission may consider further on as we continue the policy conversation, whatever those options are. At the same time, the application still can proceed to the commission for renewal. The renewal of the license can still go before the commission, and it's not prevented from going before the commission because an HCA determination has been made that's not compliant yet. And that would be the point where the commission considers the renewal application and could approve the renewal conditioned on the licensee doing, submitting a compliant HCA within 90 days, still following the process that we've laid out for the HCA determination, which allows that resubmission, allows for an amended resubmission, allows for an HCA waiver, allows them to elect those options to get that compliant HCA to the agency, but doesn't necessarily prevent the renewal in order for that to happen. So the condition would allow them to continue exploring those options and electing those options. I hope that helps kind of spell out how that would, what the actual workflow would be. But apologies if that wasn't very, if I didn't paint a very clear picture, but I figured I would try.
That was helpful. Thank you, Enforcement Counsel. Commissioner Roy?
Thank you, Enforcement Counsel Lopez. That was helpful, and I drew out a chart as you were talking. But just a question for our obligation and responsibility as commissioners. If we're approving a renewal that's without an HCA, are we approving something that's incomplete at that point? And is it part of our statutory responsibility as commissioners to review, certify, and approve? I see the ED in regulations or his designee, but is it our due diligence as commissioners? We are to also approve this. It's part of so if anybody can answer that question.
I'm happy to provide an initial response. So we will, at the point that the renewal is before the commission, we will have reviewed and made a determination on the HCA. Under our established process with the regulations, we give the parties options to get their HCA into compliance if it's not in compliance. This is essentially the policy question for you is whether or not you would proceed with denying a renewal application because the HCA conversation hasn't finished happening. Because our determination notice says you have options, continue to explore your options. These are the options you have. But if we are either holding up the renewal and administratively extending the license date until that conversation has happened, or you're denying the renewal application because they haven't had a chance to finish that conversation about how they're going to get the HCA into compliance, or you are allowing the renewal conditioned on them finishing that conversation and getting the HCA into compliance. Those are the policy options before you. But in terms of your obligations, as Acting General Counsel and I mentioned, the language of the statute certainly requires the commission to play a review and oversight role at renewal, but it doesn't necessarily tie that oversight role to the renewal application. So the two things can happen at the same time, essentially, but without the renewal application not getting before the commission until the HCA conversation is completely figured out. If that makes sense.
Commissioner Roy?
I just have a follow-up to that. So in statute, the commission shall review and approve each host community agreement as part of a completed MTC license application and at each license renewal. Does that word commission so it doesn't mean us, the five of us? It does not?
So I will let Acting General Counsel speak to delegations and how that that
Thank you.
process plays out in terms of our normal regulatory affairs.
Acting General Counsel Carter, please.
Yes, if I may, and to answer your question, Commissioner Roy, so the review does fall within the body, which is sort of the process that EC Lopez outlined. Now, the fact finding, the notice requirements that are sent out, et cetera, that is for staff and the options that may be identified, but it will be presented. Ultimately, the final decision maker on all licenses does fall with the commission. I think that ultimately how this body wishes to interpret the statute, I think is sort of what we're trying to do right now. So that will ultimately be your decision.
Commissioner Stebbins?
Thank you, Chair. As I'm sitting here, I'm feeling this conversation kind of move in a different direction. I think I think it's a good direction, and I'm beginning to think of it now as don't want to leave a existing marijuana establishment or MTC at time of renewal kind of hanging out there, a question of whether it can actually legally operate because this HCA review and compliance has not been completed. So I appreciate that. And again, thanks for the conversation. It's kind of helped me get to that point. So I do think looking at the bifurcation of the process, the suggestion by Acting General Counsel Carter in terms of our ability to condition a license essentially to continue to operate while the HCA one might be under review. It might be in a case of it's been reviewed, but we've deemed it non-compliant and the parties are going back and trying to work out the whatever work to kind of bring it back into compliance. So I understand that might be clunky, but I also think we need to think it through in a way that it's easy for the folks complying with this regulation to understand. And I'm also obviously interested from an operational perspective how we might go out and achieve this. Again, I've moved from, we're trying to make the process simpler, but now I'm seeing a potential result at the end of the day. And right, this is why we have this sausage making conversation. This is, okay, the reg looks good on paper, but we got to think it through operationally. Especially for somebody who's already opened their doors. I don't want them to be caught in a state of limbo of, can I open my doors tomorrow and have my staff come in because my HCA is not completely gone through the review and approval process. So I'm weighing that, but I see Director Potvin smiling. He may want to weigh in.
And you know what, I think it would be helpful if we heard some of your input from an internal operations perspective. So Director Potvin, please.
The policy initiative here, the direction that I also think I agree with Commissioner Stebbins, where it seems like we're trying to find that the equitable solution for people and businesses that could be found in this position. The policy initiative is definitely one that I appreciate it. That is ultimately for the body to decide from an operational standpoint. Just my honest kind of foresight, it will be clunky. It could get a little messy. It could get very confusing. But with that said, I say that as just being honest, in my honest opinion. The policy goal should take precedence. However it shakes out, we can make it work. It might be clunky. It might not be. It might be confusing. There might need to be communication strategy, that kind of growing pains. But if that's the way that the body ends up going, staff will figure out a way to make it work.
Commissioner Camargo, I don't know if you had any.
I have a lot of thoughts.
Okay, well, I'll let Commissioner Roy
Yeah.
opine first. Okay, Commissioner Roy.
Thank you. EC Lopez, if I understand you correctly, even if we bifurcate, it's not going to come before this body until they'll come together before this body. So even though we bifurcate, it's still, we still have to wait till we can have it all together at once. Is that what you said? Before we renew to vote to approve a renewal, both parts would come to us together.
Thank you, Commissioner. Madam Chair, if I may respond?
I might have misheard you, so that's
Please,
why I did it.
Enforcement Counsel Lopez, and I see our Acting General Counsel also has raised his hand to respond as well. So first, EC Lopez, please.
So the HCA review is happening on the staff level. And if it's bifurcated, that staff level review will happen at the same time as the review of the renewal application, which is also happening on the staff level. The renewal application, when that review is done, both reviews will be done at the same time, right? Because it's both happening 90 days before the expiration of the license. So the renewal would still advance before the body. What would also be part of probably that executive summary is an update on where the HCA review is. The HCA was reviewed and complies. Then everything is fine, you continue on. If the review finds that there is non-compliance, then there would be that information in the executive summary as well, which would give the commissioners the ability to condition renewal on compliance, a compliant HCA being submitted, within the next 90-day time frame that they have, or sorry, within a certain amount of time period, and you can set the time, but whatever they choose to do, if they were to send us an amended HCA, we would have another 90 days to review it to see if it's compliant. That process would work itself out, but you would condition renewal on a compliant HCA being provided by a certain date. And then staff would continue its review of that HCA and its compliance monitoring of that HCA. And also its compliance monitoring with respect to the condition. Does that answer your question?
Yes, it does. Thank you very much. Very helpful.
Acting General Counsel Carter.
Yes, I was going to say something very similar to Councilor Lopez, but I did just want to provide a little historical context as it relates to conditions. And I know Director Potvin can speak to this as well. But one example we could contemplate that is not necessarily analogous, but may be helpful for your contemplation is we have had situations on the medical program where certain components have not been completely vertically integrated. So we have conditioned that a final license may move forward, but within 180 days, the entirety of the license must be vertically integrated. So we have used conditions before in a few different ways. So I think that the commission has utilized that power before. So I just put that example on the table for a little bit of context.
Commissioner Camargo.
Thank you. So I have some other thoughts and questions around this, but I want to ask some specific questions to Rebecca and Andrew's comment, and Kyle, your comment as well, in terms of we're the policymakers. You guys are going to make it happen at the end of the day. You guys are talented, qualified, and work, like I always say, more than 40 hours at this place. So, I know that whatever we put into play, you guys are going to make happen. It may sting a little bit, but so I just want to say that. So I understand that. I want to bring this back to the May 1st date, because the process that we're talking about sounds clunky, makes sense, could have a positive impact. It is thinking outside the box a little bit, and it is thinking, we've had this long conversation around, okay, if not this, then what? So I think I want to bring it back to, will that process, clunky, maybe difficult in the beginning, would that have an impact? How much of an impact will that have as it relates to the date, but also how much of an impact would it have long term? because if it's a short-term solution, and the date won't change, then we have to, we got to put a vote on the table, right? So I'm going to bring it back to the date, because I think what's really important here is that, it's going to be, 8 to 18 months before people figure this stuff out or get to their first renewal, a lot, both municipalities and for operators. So I just want to bring it back to the impact, long-term versus short-term versus the May 1st date for us.
Commissioner Camargo, who are you? This is directed towards EC Lopez.
Well, I don't know, I'm saying it out loud, but I think for, I guess internally, operationally, right? Because the choices here are, we change the May 1st date to January 1st, right? Or we change it to, March 1st. Does it make a difference 2-3 months? For us internally, it probably does. For folks outside a municipality, the date's going to impact everyone. No one here is going to win, right? There's going to be a little bit of winners and a little bit of losers. So I guess my question is, we're talking about this process right now that's on the table, and as it does sound beneficial, and I'm sure that folks who are listening are like, that sounds good. Yeah, we can do with that. What's the short-term and the long-term impact, I guess is what I'm asking, because once we put this in the regs, it stays in here. So is it only going to be helpful for the next 5 months, and then after that, it's like not impactful?
And Commissioner Camargo, I just want to make sure, because I checked Commissioner Stebbins, Commissioner Roy, so in terms of the date, what I'm understanding from you is that you're not, you still want to have the conversation to figure out the date. So we don't have consensus just yet on that.
I mean, listen, this is 3 votes gets us a policy on this document, right? So like, I'm okay if it doesn't go that way, but to answer your question directly, I'm not good with the date, but I'm torn, because I'm not good with the date, but I understand why the working group put the date together. I understand the argument in terms of just being prepared. Like I've been here 2.5 years. I know the operational piece that's going to take place, and the last thing we do is want to mess anything up in the process in terms of legalities and communications and guidance memos, model HCA, like there's a lot. So I get it. I'm just, again, this is where, the 3 people can, shut me up in terms of the date. But so I want to just answer that question.
No,
but also,
I didn't ask it to shut you
no,
up.
No,
I
know.
It so
I know.
We have clarity.
No, I know.
Where your position
is.
Okay.
But I also want to see if we can talk about the sort of the comment that I made as well.
Before I go to Commissioner Stebbins, is there a response to, Acting General Counsel Carter?
Yes, if I may, Madam Chair. One of the things that I'm hearing from Commissioner Camargo is continued commissioner participation and oversight. I think, to her point, this is the beginning of a new process, and there will obviously be a need for learning, for education, and for potential change. We are going to put a process forward, but I am confident that this group will learn and adapt. And if there is a need to change policy further down the road, the commission does have that as an ability. So I hear Commissioner Camargo's point that it goes in, and yes, it does. And there is this sort of transitionary period, but this body will be able to go through the process. And if there are process improvements, I think that is always within the purview of the body to make.
Commissioner Camargo.
Andrew, thank you for that. I guess, I don't know, do you guys feel comfortable in having the conversation in terms of long-term versus short-term impact with what's on the table in terms of the bifurcated process? That's. Or we don't even.
I think we might not come to a resolution on this today.
Okay.
That's what I'm taking from this. But first, I want to hear from Commissioner Stebbins. I know you've been waiting patiently. So Commissioner Stebbins.
Yeah, and again, this is, I certainly don't have the operational expertise as some of our colleagues sitting here at the table, but as I'm envisioning this is a policy, and and with all due respect to Acting General Counsel Carter, I don't want to come back to this. I don't want to correct this because that makes it sloppy, that makes it clunky, that sows more confusion, that doesn't give host communities, license applicants, MTCs kind of a clear vision as to what the roadmap is. As I'm hearing it, as I'm hearing the conversation around it, and this is, we might have different senses of what short-term and long-term is. It's getting through this initial timeline of renewals, which may be a year or so, but that's really the safeguard. I look at that as one commissioner, is that's the time zone of, do you have that compliant HCA, but not leaving a marijuana establishment or an MTC kind of hanging out there, confusion about ability to operate. So again, I'm not the operational person, but and again, we think of timelines in cannabis years, so that could be longer. But I'm thinking of what is the time frame, year or so plus, that we finally get everybody who comes through on that yearly renewal to have that compliant HCA, and just making sure that this HCA review of ours doesn't trip them up, doesn't hold them up from continuing to operate in a legal manner, while there might be this side effort or bifurcated effort to make sure that the HCA is in compliance.
Director Poppin.
Thank you, Madam Chair. I think one thing about like what I said, it could be confusing, it could be clunky, along the same lines, I think, as Commissioner Stebbins is saying. The short-term reality is the conditional approach. There is going to be a volume issue and a monitoring issue by a limited number of people. And while we will try to make it work, I don't know if it will work. I don't know if it will work as intended. I don't know if there will be compliance tracking issues. When we're talking about the population of licenses that need to be renewed as of a couple of weeks ago, we're talking about 1,200 licenses. That bifurcated process could be a significant issue on compliance monitoring by a particular team within investigations and enforcement. However, like I said, the where you're trying to go as far as the policy goal, I think without changing anything as it exists right now in the draft regulations about the renewal process and maybe not going down the road of bifurcation, we still haven't gotten to the section about equitable relief. And maybe that's an avenue or an area in which we could fully flesh out of the box thinking to make sure the population that you want to make sure is protected. That might be an area in which that could be addressed there.
Okay. My fellow commissioners, I would believe it's safe for us to get to that section and then see if that in fact, answers or gives us something there that we're looking for. We still have not reached consensus with the date. So Commissioner Camargo, did you have any additional questions? Do you want to vocalize some more of your concerns?
Thank you, Madam Chair. I mean, I don't want to repeat myself. I think I think everybody knows where we're at, but I respect the process and I respect the voting power that we all have as commissioners. So I've said my piece, and I don't know how we'll move along in the section, if we want to take a vote on the date or if we want to wait towards we kind of hit that section. So it's really, up to you.
Acting General Counsel Carter, I see your hand up, so I'll let you jump in, please.
Thank you, Madam Chair. Yes, if a member of the body would like to make a motion as it relates to the May 1st date, we could take a vote whether to include the language or to remove it. If a commissioner wants to make a motion to change it, I think that would probably be the most appropriate way to move forward, and then we take a vote that way.
Madam Chair.
Commissioner Stebbins.
Sure. Thank you for that. I would like to offer a suggestion. You know, we're still going through this process. We're fine tuning it. I hear what Acting General Counsel Carter suggests. And we might get some clarification around this particular question. The May 1st date, subsequent to having this conversation in this section about redress. I would like to suggest that we're going through these regs kind of sections by sections by sections. At some point, I expect probably tomorrow we'll have a final version, red line version of all the changes that we've made. I would suggest at that point that we go through and kind of vote on sections individually. We'll have sections where we'll all be in agreement. That will be pretty easy. We may also have sections, and again, this might be one of them where a commissioner might have a disagreement they want to express through their vote. So I would just offer the suggestion to you, Chair, or our colleagues, to let's see what a final version looks like. As we go through the rest of this, this might have some impact on previous sections that we've already discussed. But at the end of the day, when we get ready to approve a final set, I would encourage us to vote section by section, just so there will be easy areas of consensus. There might be, as we're running into now, a place where there isn't consensus. And I think each commissioner should have their ability to express their disagreement through a vote, but not doing it at vote for the whole package. Well, I agree with the whole package, but at this point, maybe, again, just offering the idea of segmenting it out when we have a final version to look at.
Yeah.
Commissioner Camargo.
And Commissioner Stebbins, sometimes I don't finish my thoughts, but just so that we're on the same page, and my point was, I just meant sort of on the date, not vote on the whole thing. I just meant to like,
Yeah.
just,
No, no, no,
okay. I wanna make sure we're
I heard
clear.
it.
Okay, but thank you.
Commissioner Stebbins, I understand what you're saying. My only hesitation is the time constraints that we're under.
Mhm.
And if we do not have consensus and we haven't voted on a section and we keep continuing, then we're opening it up for more discussion towards the tail end. And I guess I'm mindful that we have limited time and I don't want us to run out of it.
No, and if I might. Okay,
Yes, Commissioner.
thank you, Chair. No, I hear you and I agree with you. I'm just saying, and, you know, to Commissioner Camargo's point, and I appreciate her position on the establishment of this all-important deadline or all-important date within our regs. But we're going to have some conversation about other items further in the regs, which may have an impact on this. So I'm just expressing a reluctance to say, should we vote on this right now? And obviously appreciate the discretion of the chair that you're looking for consensus. But I think at the end of the day, just figuring out what we want to block all together and take a vote on it and move on, because that might also help us figure out where there might be disagreement, allow each of the four of us to express our concern about one provision or another and tackle that. But that way we would also be able to shift a whole bunch of work off as saying, nope, we voted on this, set it aside, let's go back to maybe the problem spots.
I think I might want to offer what may be a healthy medium.
Okay.
So maybe we go through the section for HCAs, and when we get to the conclusion of this entire section, we've identified this as an area where we do not have consensus. We take any action that might be.
Sure.
If there's still no consensus, then we have a vote, but we do that once we conclude the HCA section, so that, you know, it happens today, we kind of put a bow on it, and then we continue into the next section for under municipal equity, so on and so forth.
Right. And I think that's a healthy suggestion. I would be mindful of, we vote on this section around HCA's, we get to social equity, we get to.
Well, I don't mean the entire section. I mean just that component.
Okay. I like that idea. I also, at a break, I want to be mindful of what kind of statutory obligations we need to have to vote on essentially the entire package for final promulgation.
Do you
So
mind
I hear
explaining
you.
a little bit more?
I'm sorry?
Do you mind just elaborating a little bit more? Just
Yeah, and legal counsel may be able to, at some point, we need to take a final vote on final package of regulations, small business impact statement, and everything else to essentially usher ourselves into the next regulatory step, if I'm not mistaken.
I think,
Sorry.
Acting General Counsel Carter.
Yes, Commissioner Stebbins is correct as it relates to presenting sort of the filing forms, which will be sort of after the substantive discussion on policy. We will then shift to sort of the mechanics of filing regulations. So there are requirements set forth by the Secretary of the Commonwealth's Office, their regulation division. So that will be sort of the final conversation that we will have, or the body will have, in order to make a final motion, authorize staff to file the regulations, and sort of close the books on this particular filing.
Now, Commissioner Stebbins, I want to make sure I understand you correctly.
Yep.
Your suggestion is what? Just kind of restate.
Sure. Again, we have a whole bunch more work to do. I have some things that I'd want to put out for discussion for us as a body around community impact fees. So I'm thinking of, again, and I think this aligns with your point of, let's approve things, set them aside. We've done that. We've agreed to it, taken a vote, however the results work out. And then as Acting GC Carter reminded us, we have an obligation at the end of all our work to take a vote on the entire package. I'm just thinking so that we could move some pieces or come back to some pieces that we have kind of, and I think this is aligning with your suggestion, kind of some individual votes on groupings of regs or sections of regs, so that we, to your point, we can say we did it, we set it aside, we put the bow on it, we're ready to go on to the next section. So looking for those opportunities, I guess I leave it to
Oh, no, so
your
what you're saying
discretion.
is a little bit different, because you're saying even when we have consensus, we still take action. Because my line of thinking was, we only, when we get to a point where there's sort of a difference of opinion where we cannot reach an agreement,
Mhm.
then that's when we would have a vote.
Right.
Otherwise, we continue with our process and we would vote at the tail end.
Absolutely.
Is that what you were thinking? Okay.
In we're getting on this.
Okay. I just want to make sure I
No.
understand.
I think we're coming into. I think we're coming into alignment is how I envision and how I hear you're envisioning it. And it's, if we feel we want to need to take a vote because we feel we've wrapped something up, that's great. Let's do that and move on. And I appreciate what I think I hear you saying, that if we run into a trouble spot, then there's still some discussion we might have, which might impact the discussion around the start date. But that, it sounds like you're open to, we'll have votes to eventually kind of move on from a section of discussion, just so we can draw some resolution to it and move on.
Yes. Commissioner Roy?
Okay, I'm slightly confused. So we're operating by consensus, as we've done. If we have a point where we disagree, that's when we take a vote?
Essentially, but it's when we reach a point where there's no more questions. There's no more, we all understand sort of the context. We've
Okay.
received all answers to our questions. We've evaluated and we've landed at different places. Yes, then we take a vote.
So if we're at if the deliberative process has been exhausted around a topic and there's disagreement,
Yes,
we take a vote.
yes.
Okay. Now, if something is deadlocked, okay? So if something's deadlocked, that means the draft stays as it is, or can somebody explain what happens in a situation of deadlock?
I'll look at our acting general counsel, Carter, please.
Yes, if I may, Madam Chair, and Commissioner Roy, thank you for that question. So yes, you are correct that the draft language would stand because that is what has been previously voted on. So a 2-2 vote, the motion does not carry. And then in this particular instance, if there was a commissioner who wanted to change the date, I would suggest that they make a motion to potentially strike the date, insert a new date, and then the body vote on it. And then that way the decision is made. The discussion that I'm hearing between the chair and Commissioner Stebbins is a timing one. So ultimately I defer to the body as it relates to timing. But when it comes to process, that is how I would suggest the board operate.
Thank you. Commissioner Roy?
And to follow up, so I understand, so say we finish the deliberative process on host community agreements and CIFs, to Commissioner Stebbins' point, will we vote on that topic?
No. That goes into the final vote for the entire package.
Okay, so what is the commissioner to do if they are not in favor of a section? What is the option for, it's just yes, aye, or no? Like, so by voting on each section, a commissioner could voice their opinion vote on each section. So you cannot agree with a section of this, and what do you do at the end?
You would take a vote on that section that you don't agree with.
But I thought we're just voting it as a whole document. I thought that's what I heard, I'm sorry.
Maybe I'm, Commissioner Roy, do you mind stating your question?
Sure. Okay.
Start this right.
All right, sure. So I think there are a couple of scenarios here.
Okay,
We just vote on the final package.
right.
Deliberative process is exhausted and we take a final vote. I guess my concern with that is if one of us did not agree with a section of this, what are your options? So you have to vote no against the entire document, even though you agree with 90% of it, you'd have to vote no against the entire document, which I guess you're gonna have to do anyway, but if we vote each section, then it's on the record that someone was in support of or not support of a certain section. For the record and for the minutes, it would show that, reflective of that.
I think that my explanation encompasses that scenario.
Oh.
And I'll use Commissioner Camargo as an example right now with the date. There's disagreement about the date. And that's why we're having this conversation. So that's when we would take it up because there's no consensus.
Okay.
She does not agree with it. So then that is when you would offer a motion, or in this case, if it was you would offer a motion, and then we would vote on it as a body.
Okay. Okay. Just one last question.
Sure.
So if a commissioner doesn't agree, does that commissioner need to propose an alternative, or can they just?
You would do a motion, so an alternative, or if you wanted to strike it, are you saying?
Strike it, yes, like
then that's also a motion.
part of the
That's in
motion, yes,
your power.
okay.
Yes.
If I may,
Yes,
Commissioner,
please, Commissioner
just because
Camargo.
we're using the example, but in this example, the reason I'm bringing it up as well, and I brought it up earlier, is that right now, I can just put a motion on the table right now as we speak and say, boom, 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 I move to strike May 1st. This is an example, not a real motion, that I move to strike May 1st to make it January 1st. And I put it on the table.
Mhm.
Because of this section, we're kind of like going around, and because we only have till Thursday. I can vote yay, you guys can vote, I can vote no, you guys can vote yes. Then in this section, it stays May 1st, and then we can keep moving forward. But at the end of the regulatory process, I still have the decision to vote for the whole thing, because I believe in the whole thing, or I can vote no, regardless of anything, right? So you have the ability to be able to, vote at the end, but also I think because we have the power and the authority per section, because this is how we're trying to figure out, we could sit here and do consensus all day, but we may not, it may take us another week or something. So that's just an example. So.
Thank you. Commissioner Stebbins?
Yeah, thank you for my colleagues' thoughts. And I think we're all coalescing around the same idea of where we have agreement, where we don't have agreement. I think, Chair, to your point, calling for a vote or seeking a motion, or Commissioner Camargo's point, each of, the four of us have the ability to put forward a motion at any time. I was just thinking about a process and, obviously deferring to the chair, and appreciate her position in terms of we will get to votes.
At the end.
And obviously mindful, as Acting GC Carter said, at some point we need a vote on the whole package and the in the additional filing documents.
If I may,
Commissioner Camargo?
yeah, just to be fully transparent, the reason I have not put a motion on the table right now as we speak is that I know the votes are not there. It sounds like people are okay with the May 1st date, right? So this is a process right now, but I want to continue to hear, I think to Kyle's point, the rest of the section and the equitable remedies and other stuff that possibly can help this May 1st. But it sounds like you all are in agreement on the May 1st date. Maybe not, maybe, okay, maybe not. So I don't know. So, but I'm just being fully transparent here because this is the only time we can have this conversation. So, but for me right now, the only reason I haven't put the motion on right now is because I do want to go through the rest of the process and figure out and hear the other stuff. But
And I heard that, and I heard Commissioner
Yeah.
Stebbins as well, and that was the rationale behind, okay, let's read the HCA section.
Yeah.
But then before we continue on, we have to revisit that date.
Sure.
Because we need to have some direction on if it remains,
Mhm.
if it does not, so that is the idea.
Thank you.
You're
It's good exercise.
Any other?
Clarification.
And no one, and can I just say this, Madam Chair? Can I just say, like, I know this is a process and it's awkward, but this is a big deal. So we cannot be afraid to put motions on the table and get them voted and get no's on them. So just for all of us, I think we need to practice on putting those motions forward and moving forward. So just a comment.
Okay. Deputy Counsel Baker.
All right, so
I think we have to go back to
I need to go
something.
back.
Okay.
We do have to go back.
Okay.
And, this is pertaining to EC Lopez's two different comments from before, so we just want to make sure that we get consensus on these before we move forward. This is under subsection 2J and then 5. If you go there, it starts with a provision that categorically deems a host community's claimed impact fees to be reasonably related, or that otherwise excuse a host community from calculating impact fees based on the actual operations of a marijuana establishment. So that's in the current draft. However, I believe there was a conversation yesterday where EC Lopez suggested wording that added at the end of subsection 5 here, language that says a provision including or otherwise deeming good faith estimates, unquantifiable costs, generalized expenses, or prorated expenses as a CIF.
Is that language?
So
Yeah, so Attorney Baker, where can we find that language?
sure, so I think what we were just speaking on was subsection 3. And so if you just go up to the section prior, under J5.
And was this, so I went to the chat from yesterday's meeting, and it's the last comment that Rebecca, okay, so I'll read it again. Proposed language, a provision including or otherwise deeming good faith estimates, unquantifiable costs, generalized expenses, or prorated expenses as a CIF. And Commissioner Roy, was this okay, this is what you had offered, okay. Okay, and I believe we had consensus on this, but I'll look back around.
Yes.
So we have consensus.
No motion needed.
Commissioner Simmons, did you have a question?
Just for clarity, and I see that language in the chat, and I think up above Rebecca, Enforcement Counsel Lopez also added in additional language for 2 subsection I6, and we all agreed on that language as well. Okay, I know it. Okay, all right, thank you. Just matter of clarification to move.
Enforcement Counsel Lopez.
Thank you, Madam Chair. Just for clarification, and thank you very much to Acting Deputy General Counsel for identifying the language from yesterday and keeping us on track. That's much appreciated. I just wanted to clarify. So this new language, a provision including or otherwise deeming good faith estimates, I believe the discussion left off with that being a new subsection 9. I just wanted to make that, okay.
Attorney Baker.
Sure. So I have one more that we have to go back to in this section. I think I'm going to put it in the chat now. So this would be, again, a new subsection here.
In the same section?
Yes, under J.
Okay.
Actually, I'll let Enforcement Counsel correct me if I'm wrong on that. Is it I?
I think this is what I had just mentioned.
Okay.
Rebecca's comment
It's
from
I
yesterday that she
Okay, so I'm just
dropped
going to
it.
read it. Just
Attorney Baker, can you just clarify where it would appear in the regs? Just so I can look in the.
that's actually the question that I had for Enforcement Counsel.
Okay, Enforcement
Okay.
Counsel Lopez, please.
Okay,
Sure. So this, let me just.
I actually have it here.
So yes, this would actually be in subsection I. So right now we have prohibitions, in subsection 2, general requirements for host community agreements. If you go to subsection I, which is prohibitions, there would be a new subsection 6 after number 5, which would read, no host community may rely on other written instruments, contracts, or agreements to impose terms or conditions on a licensed applicant, marijuana establishment, or medical marijuana treatment center outside of an HCA.
Thank you. Attorney Baker.
All right, so it sounds like there's consensus on this language.
Let me look at my fellow commissioners.
Easy enough.
Okay.
We're going to keep it going then back to where we were before.
Okay.
So again, now we're under subsection 3. We had just went through B here, so we're going to keep going.
I think we didn't finish B. We've got as far as B1.
1.5.
I'm going to read until the chair stops me. So under B2, it reads, the commission may request additional information from a licensed applicant or a host community in connection with its review. 3, the commission shall send a notice of its HCA determination to both the licensed applicant and host community within 90 days of receipt of an HCA. 4, if the commission determines that a licensed applicant's HCA does not comply with 935 CMR 500-180, then the HCA determination notice shall state the following. The factual basis for the commission's finding of noncompliance, including identification of noncompliant terms, conditions, or provisions of the HCA, if applicable. B, the party's option to correct the noncompliance and submit an amended HCA. C, the party's option to submit an HCA waiver that complies with 935 CMR 500-180 subsection 5. And D, either party's option to discontinue relations as host community and licensed applicant.
I'll stop now. Commissioner Stebbins.
Sure, thank you, Chair. D really frightens me. And I think it was the subject and topic of a lot of the comments and feedback that we got. I look at that language and welcome, obviously, the working group's input or thoughts on this, but I look at that as really leaving a licensee in limbo. One, their ability to continue to operate. 2, what does this mean for the host community, which now has a legally operating business within its municipal borders. And again, I want to, and obviously, as we go through the rest of these regs, we need to look for ways to reward good behavior. And I hope this would not, I would hope this would be maybe standalone examples or very small number of examples that would run into this problem. But I'm really concerned about this provision in the regs.
Which is there one particular or the whole list?
D. Either party's option to discontinue relations as host community and licensed applicant.
Commissioner
The last
Camargo.
one.
Commissioner Stebbins, I agree with you. So my notes here were, do we need this specifically just because I have a comment on the next page and we'll get there, but as it relates to a host community's option to discontinue relationships with a marijuana establishment, municipality shall notify a marijuana establishment if it no longer intends to continue, blah, blah, blah. So I think that D concerns me as well. And I don't know if we need it here. I guess my recommendation was to strike it, but then when we get to page 72, I wanted to have a conversation around entertaining what does the discontinue relations mean and how is that process? How do you break up? I mean, we've all been in relationships. So, how does it start? When does it start? Do you get the house? Do I get the kid? So, I think that pertains to D. So I wanted to just add that.
Commissioner Roy.
Thank you, Commissioner Camargo. I'm in agreement with you to strike D altogether. And I have for 5 language to propose that I lifted from the Office of the Comptroller, where the municipalities are bound in municipal contracts with the policies and procedures of the Comptroller.
Commissioner Roy, before you go to 5.
Yep.
Let's reach a resolution on D, because I think that.
But it might impact D, keeping it or
Oh, I
not.
see.
It could be related if I'm permitted to read the, okay. It's reasonably related, thank you. So I'm going to read 5 as it stands now. If a host community discontinues relations with a marijuana establishment, comma, here's the language I'm proposing. It must demonstrate good faith and fair dealing when initiating any notice of termination, suspension, or amendment. A host community must be able to demonstrate that there exists a good business justification or legal necessity that supports the contract change.
And that's Commissioner Roy, if I may.
Commissioner Camargo.
Can you clarify that? So you're saying that's instead of D, or you're saying in 5?
Well, there's a couple of scenarios. If we strike D altogether, we could add the proposed language as D or as a continuation of 5. I can read it again if you, or I can drop it in the chat.
Can you drop it in the chat?
Yep.
Yeah, I would ask if you could drop it in the chat and read it again.
Yeah, of course, I can do that. Okay, so I'm going to read it again. If a host community discontinues relations with a marijuana establishment, it must demonstrate good faith and fair dealing when initiating any notice of termination, suspension, or amendment. A host community must be able to demonstrate that there exists a good business justification or legal necessity that supports the contract change. And I'll drop that in the chat.
Enforcement Counsel Lopez.
Thank you very much, Madam Chair. I just wanted to take this moment to just to identify, it seems that there are 2 policy conversations here. I think it's the first policy conversation, understanding the policy concern seems to be revisiting and reassessing the extent to which that relationship can be terminated or what the options are for the parties in these situations. It seems like the first policy conversation is what are the options available or what is the ability to terminate when we're talking about a host community and a licensed applicant. And then the second conversation, what is the ability to terminate? What are the options that are on the table when it comes to a host community and a marijuana establishment? I don't know if I just want to put that out there because I'm not sure if the commission is adopting, wants to adopt the same policy for both, or if they want to explore adopting different policies, but that's just something that might help kind of structure the conversation.
Commissioner Stebbins.
Thank you, Chair, and thank you, Enforcement Counsel. Hearing in a policy conversation, if you go back to the top of 4, if the commission determines that a licensed applicant's HCA does not comply with 935 CMR 500.180, then the HCA determination shall state the following. I hear that and read that as it's really the commission's choice as to what we put in the determination. And I would suggest that we not be somebody who offers up that option as part of our determination.
I'm in agreement with you. That is a notice from the
Right.
Cannabis Control Commission.
I agree.
You were, so, and Commissioner Roy?
No, I'm good.
Okay. So, and we would, I think there's consensus to remove the language in D. Okay. Commissioner Roy, the language that you offer, do you still wish to offer the language?
If we're going to keep 5 as a body, then I would propose to adopt that language. And I didn't create this language. It is from the Office of the Comptroller, which the municipalities are subject to the policies and procedures of the Comptroller. So if we're going to keep 5, then I would respectfully put forth that we adopt this language or a version of it.
I don't know if this is the right position for this language. 5 speaks to failure to have either a compliant HCA waiver, to the failure to submit a compliant HCA or HCA waiver.
I'm looking at the 5 on mine is different than I have it. I'm looking at if a host community discontinues relations with a marijuana establishment, then a marijuana establishment may submit a request for equitable relief. I wanted to insert that somewhere in there.
So I think that's the next section that I was, that I brought
So
up.
I jumped ahead.
Okay,
Page
okay.
72.
So let's just table it and then bring it back up. Okay, so we can all follow.
Catching that.
Okay,
Wrong section.
I think we can continue. Attorney Baker.
All right, sounds good. So I will keep reading after D, which there's consensus to strike. So the next would be provision 5 underneath, failure to submit a compliant HCA or compliant HCA waiver with an application for licensure may result in an application remaining incomplete pursuant to 935 CMR 500-102.
I'll pause right there. Commissioner Stebbins?
Sure. And this goes back to the very long conversation we had about license renewal, review of HCA, and offering conditions to a license, again, to allow somebody to continue to operate. I just want to make sure that this language here doesn't conflict or be in tension with that.
So Madam Chair,
Director Potvin, please.
thank you.
Sorry.
Just answer.
Okay.
Okay, never mind.
Are you?
Yeah, I'm good. No, I'm
What just happened?
I don't
like,
know.
it was almost reading Director Poppen's.
a break?
Dialogue.
No, but I still realize this is under the license applicant section.
Yeah.
Right? Is that what we both agreed on?
Okay.
Telepathically? Okay.
Okay, are we good to move on?
Good to move on.
All right, Attorney Baker, please take it away.
Okay, so now I'm on C, review of HCA submitted by a marijuana establishment. Okay, all renewal applications submitted on or after May 1st, 2024 must include an HCA that complies with 935 CMR 500 or a compliant HCA waiver.
And that's what we're putting a pen in, but you can continue. Yes.
Thank you. So C2 reads, the commission may request additional information from a marijuana establishment or a host community in connection with its review. 3, the commission shall send a notice of an HCA determination to both a marijuana establishment and a host community within 90 days of receipt of the HCA. The determination notice shall identify whether the HCA in whole or in part complies with 935 CMR 500-180. If the commission determines that a marijuana establishment's HCA does not comply with 935 CMR 500-180, then the HCA determination notice shall provide the following. A, the factual basis for the commission's finding of noncompliance, including identification of noncompliant terms, conditions, or provisions of the HCA if applicable. B, the party's option to correct the noncompliance and submit an amended HCA. C, the party's option to submit an HCA waiver that complies with 935 CMR 500-180 subsection 5. D, a host community's option to discontinue relations with a marijuana establishment. A municipality shall notify a marijuana establishment if it no longer intends to continue as a host community for a marijuana establishment. On receipt of a notice of discontinuance as a host community, the marijuana establishment shall notify the commission. And E, a marijuana establishment's option to request equitable relief from the commission in the event that a host community declines to continue as a host community. Good.
I do.
Okay, we'll pause there. Commissioner Camargo?
So for D and E, so I'll sort of give my thoughts first and then we can kind of discuss it a little bit. So I just, my own thought here was delete D. If we didn't delete D, then we have to sort of create it. What, you know, what does this mean? What's the process? So, and I'm sorry, I had this conversation last week. I did speak to Rebecca and Kyle about this because I don't have language right now. And I know Commissioner Roy, you have some language. I don't know if this is the place for it, but you know, for me, it's like when I read this, option to discontinue relation with the marijuana establishment and municipality shall notify marijuana establishment. They no longer, if it no longer intends to continue as a host community for marijuana establishment on receipt of notice, the you know, so this protecting both municipalities and operators, you know, we have to be careful with this, whether it's either delete it or rewrite it. Again, this is just my own personal opinion here is what is, you know, what's the process for discontinuing? So we all heard about this. We all heard comments. You know, our municipality is going to use this as power to just, you know, pull the rug from under, you know, a company and say, hey, we no longer want to be in partnership with you or, you know, however it works. So that's my main concern on this. For E, not needed. If we strike D as well, but so those are like my bigger scope kind of concern for that area.
E is not needed, but can you elaborate some more? What?
I'll go back to that one. I'll stick to D for right now. I apologize. Yeah, I'll stick to D.
So the section we're on is our notice.
Mm-hmm.
So it's the commission's HCA determination notice for non-compliance. I just want to put that out there so we understand what these subsections relate to.
Thank you.
Commissioner Roy, you had input on this as well.
Yeah, so on 5, what I was proposing,
Oh, okay, so hold on, because we're not at 5 yet.
but we're at 5.
We're at 4. We're at 4D.
Commissioner Ward, maybe read it because I think it may.
I thought we just read that, no?
No, we're at,
I read down to E.
so we're.
All right, I'll wait. I'll pause. I'll wait.
Can I? I'm sorry.
Commissioner Camargo.
Commissioner Roy, I take 2 minutes to sort of read it, but also I think your comment kind of also relates. I think maybe I'm wrong.
But
No.
this is about our notice, so it's what we are notifying. It's
So
what the
not-
commission is stating. I think Commissioner
Let's go back.
Roy,
Maybe
and
I'm
we'll get
confused.
to it.
Okay.
I think you were saying something that is a requirement, it's an action for host communities as opposed to action by the commission.
Commissioner, I'm sorry, Madam Chair.
Yeah, Commissioner Camargo?
Yeah, I'm sorry. Let me just go back for a second. So you're saying, we're saying that D&E is under,
4.
yep, under 4. Oh, sorry.
It's a non-compliance
Yep.
determination notice
skipped.
by the Cannabis Control Commission.
So let me just read this for 1 second because I completely skipped the number 4. I was reading another section, so. Okay, so yes, it's to me here says then the HCA determination notice shall provide the following. And I understand that this is, and maybe this is just my train of thought. I understand that this is notice, so that D is notice. But I guess what I'm thinking is, what are we allowing the host community agreement to do to get to D as they're resolving or discontinuing the relation? So I understand that this is notice for us, But I guess my concern is like, what comes before this notice? Ooh, my throat is free.
Enforcement Counsel Lopez.
Thank you, Madam Chair. I actually I don't have an answer. I wasn't going to respond to Commissioner Camargo's point. I had a separate point to raise, so I will just wait until
All right, so
we're ready for that.
Pause. Commissioner Camargo. I think I'm a little confused about the concern. So do you mind just rephrasing it?
Yep. So, just kind of read my notes out loud. This section gives the host community the option to discontinue relations in the event of a non-compliant HCA. This creates.
So I'll clarify. It doesn't give. We're not giving the option. We're notifying them of their option. And I'm looking over at Director Potvin, but this is a little bit separate because it's contract law. It's something that already exists, regardless of if you put it in the notice or not. But did you want to continue before?
I just want to make sure that my thought is clear. Okay. Because what I'm thinking, in order for them to give us, and maybe I'm wrong, it's just I'm thinking out loud here. In order for them to give us notice that they're going to discontinue the relationship. Is there anything else in our regs right now? I can't think through all the regs right now, but is there something that allows the municipality and the operators to go through in order to discontinue the relationship?
So you're asking if there's an additional step that needs to occur before discontinuance?
Yeah.
And so I think that does align with Commissioner Roy's suggestion that we will. So maybe. Okay, Commissioner. Okay, it does. I understand what you're saying. You're saying that it shouldn't just be that.
You're telling me
you're just stopping and then that's it. You're saying that there should be an additional step prior to the discontinuation.
Right, because we're saying here, yeah, send me the notice that we're discontinuing. Cool.
Right.
But what's happening on the back end? Right. The municipalities and operators, like, am I giving you a 90-day notice? Am I going to give you just, 2 weeks notice, 30 days? You're the landlord, right? Like the municipality is the landlord of these businesses in their cities, right? So this to me says, and I could be reading it wrong, right? Like I need clarification. I'm just concerned that what's the back end to this notice for us?
Enforcement Counsel Lopez.
Thank you, Madam Chair. So in terms of this section D and the discontinuation and potential desire by the commission to revisit it or strike it, I will note that we as an agency would certainly have legal grounds to remove this from the notice on the basis of unreasonable impracticability. So we as an agency cannot adopt regulations that prohibit the operation of an ME or make operation unreasonably impracticable, which means instituting compliance measures that would subject licensees to unreasonable risk or require such a high investment of risk, money, time, or any other resource or asset that a reasonably prudent business person would not operate a marijuana establishment. So putting that option on the table via regulation of being able to just walk away is something that could conflict not only with our obligation to adopt regulations that are not unreasonably impracticable, but the host community also, even in the local control section of the statute, has an obligation not to adopt local ordinances or bylaws that are unreasonably impracticable. So that is something to consider as well. And with respect to the commission has room as policymakers to identify other options that they would want to offer to the parties in this situation. Some of the public comment that was received included ideas such as allowing the parties to proceed under an HCA that conforms with the model HCA, which might be considered on an interim basis until they reach an agreement. But another consideration for the commissioners is introducing a component of mutuality to ending the relationship. And the legislature did provide us some groundwork to explore that with the waiver process. So in the statute, the legislature gives the host community the power to waive, the discretion to waive the host community agreement, but the ability to waive still requires the host community to submit a written waiver to the commission that is executed by both the host community and the ME or MTC. So in that sense, the legislature is essentially saying the licensee needs to be on board with this plan as well. And the commission could consider adopting a similar sense of mutuality in terms of the ending of the relationship. That the relationship, if the parties desire to end it, that's their choice. But the commission could explore the idea of host communities submitting a mutual abrogation agreement that is executed by both the host community and the ME or MTC to maintain the spirit of what the statute was trying to achieve and to avoid a scenario where the regulations are unreasonably impracticable.
Commissioner Stebbins.
Thank you, Chair. And thanks, Enforcement Council. I'm coming back to, again, this section, similar to the previous section, is what does the commission notify? What type of notice do we send out to both the host community and, in this case, the marijuana establishment and the MTC? Again, I'm of the position, I don't want to encourage this. I think it's obviously up to both the host community and the marijuana establishment that they might understand their own legal rights under contract law in Massachusetts. But I think in E, I think needs, if we're going to address E, I think E needs to kind of move down into the next section. So here again, I'm comfortable with taking both of these out. Again, we want to give them options that we can, our processes control, and again, hopefully speak to good behavior between the two parties. So here are your other options, as the commission has the authority to regulate.
Thank you.
And again, not to try to espouse a route that they have the right to go down, but I don't think we need to endorse that or make that part of our regulatory determination.
I think we might need an additional section here before 5. It'll probably be the new 5, and I'll throw this out because this is where we're live drafting. I'm thinking on. So I agree in not including the discontinued language in the notice, but I do believe we need to provide some parameters around what happens should a discontinuance occur. So a section that speaks to in the event of discontinuance. And I liked our enforcement council's your suggestion to enter component of mutuality to ending the relationship. And I also think that this additional section would be a good place for the language, Commissioner Roy, that you have recommended around sort of the threshold that needs to happen. But I will just let that breathe and put that out there and see if there's any thoughts. Commissioner Roy.
Thank you. Just on the notice of the discontinued notice in the options, we really don't talk to the model HCA or the interim. Is that something we would want to list as an option in the disc as Enforcement Counsel Lopez laid out 1 through 4? Is that something we want to consider as a body in the determination notice that is an option?
So Commissioner Roy, you are recommending that we include in the notice that you can come into compliance by utilizing the model HCA? What am I, Commissioner Camargo, Commissioner Stebbins, do you have any thoughts on it?
I have a whole other different thought. It's break for lunch in this section, but I think you're right. I can't think right now. One, I need a bio break, but also I'm hungry. But I think that this section needs some more conversation.
Commissioner Stebbins.
Sure. Before we break, and I want to be the last person to stand between all of us in a break, but to pick up on Enforcement Council, Lopez's comment and Commissioner Roy's comment, I'd be willing, and we can come back and talk about it, going back under Section 3, which is review and certification of host community agreements. But I apologize, I was remiss. I'd written up this language and happy to introduce it after our break, but something that would maybe make compliance with our model host community agreements something that would drive efficiency and maybe perhaps drive better compliance. So I'm happy to make a motion to take a break, but I wanted to just put a pin in that conversation because both folks raised it, and happy to pick up the conversation there when we come back.
So Commissioner Stebbins, your suggestion is to, I just want to make sure when we come back, we're at the right section. What section were you?
It goes back, it's page 71 in the hard copy, but 3, kind of where we started off today, which is review and certification of host community agreements, that section 7.
Okay.
So, and my apologies that I had this language draft and should have spoken about it at that point.
Okay, so let's see, the time right now is 12:05. And this will be our lunch break. So let me look across, is 12:45 enough time to eat, to do whatever you need to do, and then come back? Is that Commissioner Roy?
Yeah, I just want to bring to everyone's attention, we received during our deliberations an email from Director of Government Affairs and Policy, Matt Giancola, that there's a batch we haven't, there's not a batch, but there's some feedback. There was an oversight, we haven't seen it. So maybe at the lunch, just friendly recommendation, try to take a look at what we haven't been able to see.
In that case, 1 o'clock.
For that feedback.
Actually, I agree, so we can look through it. Okay, so we'll let's say we break until 1. So Commissioner Stebbins, do I have a motion to recess till 1 o'clock?
So moved.
Commissioner Camargo, do I have a second? Second. Now for the roll. Call the roll. Commissioner Camargo. Aye. Commissioner Roy.
Aye.
Commissioner Stebbins.
Aye.
The chair votes aye. We will reconvene at 1 o'clock. All right, good afternoon. So we are back from recess. Before we continue from where we left off, I had I guess a logistical question about tomorrow. Because our notice says that we are hybrid. So if our acting general counsel, at the beginning of this meeting, I noted that we will be meeting virtually, but the notice says hybrid. So tell me what the requirements are.
If I may, Madam Chair.
Yes, please.
Yes, so as the notice has been hybrid, that means that is how the meeting can occur. So we can have either commissioners in person or participate remotely. But I would recommend that some be on site, as that is what the notice states.
Okay, that's helpful. Then in that case, tomorrow's meeting we should plan to be in person. And then on Thursday, if that is an acting general counsel, you can correct me if I'm wrong, but for Thursday's notice, it is virtual.
Yes, that's my understanding as well.
Okay, all right, perfect. Okay, with that said, I will turn things over to Attorney Baker. If you don't mind just repeating the page we're on and the section, and we can get right back to it.
So, thank you very much, Madam Chair. We are currently in section 180 and subsection 2. I believe it's I, but I will defer to Commissioner Stebbins, who I believe raised an issue before we went on break.
That's right, Commissioner Stebbins.
Yeah,
Commissioner Stebbins, do you mind telling us the page?
Sure, my apologies. Going back to page 71, kind of where we started our discussion today, subsection 3, review and certification of host community agreements, that section.
Okay.
I have some proposed language for 3A, which is right below that. And I'll read the language first, and I'll be happy to drop it into the chat, and hopefully we can have a conversation around it. But 3A reads, currently, the commission shall complete its review of an HCA within 90 days of receiving an HCA from a marijuana establishment. The commission may request additional information or send a determination notice identifying deficiencies in an HCA. Submission of an amended HCA resets the 90-day period of commission review. This following part is what I'll drop into the chat, but again, want to entertain some discussion and feedback around, which is the commission shall complete its review of an HCA expressed exactly in the form of the commission-approved model HCA within 30 days of receiving an HCA from a marijuana establishment. So I'll drop that in, and if you give me a chance, I'd be happy to kind of share my thoughts on this with each of you. So again, going back to an earlier statement that I had, and obviously under Chapter 180, we are also given the opportunity for this commission to create a model HCA is a helpful tool for obviously potential host communities and applicants and marijuana establishments or MTCs. What I'm suggesting, again, to kind of encourage that good behavior, is if a community and a marijuana establishment, licensee, applicant, or MTC submit an HCA to us exactly in the form of the commission-approved model HCA, which again, I would expect, and obviously I'm interested in hearing from Director Potvin on this, would hopefully speed up the review of an HCA by the commission. And if we were to encourage that review within 30 days, it might be enough of incentive, enough of a leverage that we start to move some host communities and some applicants or licensees over to our approved model to, again, help the process become a little bit more efficient.
Director Potvin.
Thank you, Madam Chair. I can definitely appreciate the intent behind this, Commissioner Stebbins. Just a couple of notes for consideration for you and for the commission. The requirement to review an HCA within 90 days, that's a statutory requirement. The commission also has current policies around the review of applications in general: priority review, expedited review, general review. When staff review an application, they don't just check one requirement. They have to review, they can't review it just in a vacuum of that one requirement, because there may be other pieces of the application that are conflicting with the HCA potentially. When we get an application in, the process right now is to classify it so that we can identify that priority expedited general review. If we also then add in this requirement of the 30 days, there can be some conflicting nature and a possibility of not meeting this requirement. If we have to, say for example, we have 10 priority applications awaiting a first review or a second review, a supplemental review. And the number 11th is a general applicant that is waiting before those first 10, and they all have non-model HCAs, but that number 11 does. I don't see, I see the potential of not being able to comply with this. So we're having competing timeframes going on. The reason why the 90-day, besides the fact that it's a statutory requirement, is that we already have an internal requirement right now as it stands to try to get to these applications within 60 days, which we've been doing within a week or two anyways. However, now you're adding the HCA requirement, which is going to make the review of the application, not only that requirement, but the application much more in-depth and timely and time-intensive. So I would have a concern about the competing policies here, and there also being confusion of how we get to it, and also the potentiality of setting maybe staff up to not be able to meet this requirement. I don't want to set anybody up to fail, but I get the policy goal behind this. I don't know, it seems like it's going to conflict at times and obviously sometimes not be able to be met. So we always will endeavor to try to meet the standards, but this does present a possible issue.
Commissioner, Commissioner Stebbins.
Yeah, and I appreciate that. And again, what I appreciate about what we're doing here today is not only looking at the regs and thinking about them in the biggest, grandest form, and they meet our policy objectives, but obviously balancing that with what are the operational realities of being able to complete the work. I go back to the, again, Chapter 180 refers to a model host community agreement. Obviously, there was an impetus for that. There was an impetus to hopefully drive good behavior. But if we're not putting compliance with that model host community, if we're putting that compliance with the model host community agreement on the same level as an HCA that our team has to review for compliance with our new regs and compliance with 180, I'm trying to just understand that what the benefit of that model host community agreement would mean on the back end on your licensing team and the review of that HCA, other than it goes quicker, which is what we all want. But again, trying to drive that good behavior is tough if they're both on the same level.
Madam Chair, if I may.
Director Potvin.
Yeah, that you're 100% right. And I see what you're saying to drive the good behavior. What's one of the benefits is that it's going to be presumed to be compliant, which means that there's not going to be back and forth on that issue. They're not going to have to then go back and forth again with the municipality. That is a benefit that yields from this. But I think that with the goal here of what you're trying to do actually could potentially prolong the process for many more applicants. The reason being is now we're doing an additional assessment of an HCA by itself, which means that we're going to do the assessment of the HCA and then we're going to go into the application and then they may conflict because we have to identify in order to meet a 30-day requirement. It might actually be more detrimental long-term into a bigger population than it might have an adverse effect of what your intention is.
Okay.
Commissioner Roy?
I thank you, Commissioner Stebbins. That's creative. I didn't think of that. And thank you, Director Potvin, for the explanation. But I just want to, so statute says the commission shall complete its review of a host community agreement not later than 90 days. So that's the extreme, is 90 days. And we're talking about bifurcation. And if we had bifurcation, then it wouldn't get caught up in the rest of the review process if it was in its own lane. And it's not, we don't have to wait till 90 days, but that gives us the cushion of 90 days. So if it's in its own lane and not caught up with the rest of the application process, would that help, and that would reward the model behavior for the model HCA?
So
Director Potvin.
Thank you. I think there's the bifurcation that was referenced earlier was for renewal applications, not new license applications.
So just for renewals?
That is an interpretation, I think that's proposed for just renewals. I don't think that interpretation that has been stated previously applies to license applications, like initial license applications.
So what if that standard could apply just to renewals?
The bifurcation?
No.
Oh, no, the 30 days?
Yeah.
I think, I honestly think there's a higher probability of not meeting that standard on renewals because of volume. There's 1,200 licenses, 100 renewal applications. It's going to be, so 100 renewal applications a month where we're going to have to assess HCAs within 90 days. The 90-day requirement itself is going to be hard to meet.
Commissioner Stebbins, what is the issue you are addressing with the language that you proposed? I just want you to state it just so I can sort of understand this a little bit better.
Sure. My intention, and I see Enforcement Council has also dropped in some rewording of my language for our consideration. My goal here is one, making the process more efficient. Trying to, again, going back to Chapter 180 and saying that this body shall create a model host community agreement. Obviously, it's one we want communities and their partner applicants or licensees to follow. And we're trying to drive that good behavior so that we don't get, as we were just about to discuss before we took a break, into all of those kind of options if there is an agreement on a host community agreement. So trying to drive compliance, try to make the process more efficient, trying to drive that good behavior, trying to avoid some of circumstances of what could happen if there is an agreement. And since we need to propose this anyways, trying to drive some value out of it, even though if it's not 30 days, I hear Director Potvin's point of the benefit, and we should find a way, and this gets back to the operational question, we should find a way of communicating that to our applicants to say, here's the benefit for you. Use our model HCA. In all likelihood, we won't come back to you. We won't delay you further by another 90-day clock getting set when you have to amend an HCA. So again, that was my intention. That's kind of why I put forward this language. And it, it's helpful to have Director Potvin's feedback on that. So I hope licensing team heads aren't exploding in the back room, but I hope we all have the same goal. It's how we reach that goal, which might be the bigger question.
That's really, it's helpful. Thank you for breaking that down, because now I'm thinking this through to figure out if there's anything here that might address your concerns. But thank you for explaining that a little bit more. Commissioner Roy?
Thank you, Madam Chair. Director Potvin, what if the universe was really narrowed down? And what I mean by that is, and we're not to this section yet, so I'm jumping ahead, but what if this was baked into in the municipal equity section? And what I mean is, the commission shall complete its review of an HCA that conforms with municipal equity and the commission's model host agreement within 30 days. So it's rewarding a municipality for equity and using a model host community, and it narrows the universe down to a much smaller influx of these that you would get.
Madam Chair.
Director Potvin?
I also see the purpose of what you're trying to accomplish. It still would have the same negative effect, if not greater, because now we have to now in addition to analyzing the HCA alone, we also have to then also pinpoint the people that are applicable to the municipal equity group. Mm-hmm. So now it's an increased analysis that will still have an impact on the overall population of applicants and licensees.
I'll ask a question. So there's a few things that popped in my mind. Commissioner Stebbins, I believe I understand the intention behind your recommendation, and that is to really for people to get more utility from the model HCA and for them to utilize it more, and that way, subsequently alleviate the burden on our internal processes here at the Cannabis Control Commission. I was looking for language here. We've had a lot of conversations in the working group. So I was looking through because I thought that we at least had a conversation around a presumption that's given to the model HCA. And I think that there's just a lot. I want to figure out sort of where that is here, but I believe that might lend itself to where you're thinking, Commissioner Stebbins. And Director Potvin, I will look to you in case you knew which, if you remember the conversation, if you recall this.
Thank you, Madam Chair.
Yeah.
I do remember that. That's my recollection too. And I don't remember at this point if we've seen it yet today or yesterday. But it kind of going off of a suggestion to Commissioner Stebbins' overall goal that I think might get to some additional benefit if somebody uses a model HCA is in, I believe it's 500-102, the municipal equity group identified with the municipal notice and response requirement after an application is deemed complete. The requirement right now is that we give municipalities 60 days to respond. That there's been a proposal that if you are a social equity business or majority ownership of economic empowerment and social equity participants, that we give municipalities a 30-day period to respond. So they move through the process faster and they don't have to wait as long towards provisional licensure. I think an additional benefit that you could propose or consider is that if the applicant, regardless of those statuses, uses the model HCA, that they also, with their municipality, get a 30-day turnaround because it seems like they're already in agreement. That could be an added benefit that I think could work in the existing licensing process that would not cause any backlog or any timing issues at all.
So that was my next question to you, was sort of the impact that may have on the internal operations, the process that we have here, you're saying that it would not have an impact?
It would not, and the only benefit I can see is that licensed applicants are moving faster towards provisional licensure. More applicants are moving faster towards provisional licensure.
And Director Potvin, do you mind giving that citation one more time of where of that language?
Sure, I know it's 500-102. Five hundred 102 1D. So 1D, 1 and 2. So
Page 42.
Oh, thank you. 42. Okay.
So you could, in this situation, if you were so inclined as the commission and that proposal was, there was some appetite for that type of policy addition here, I would just recommend a D3 to address that population of applicants with model host agreements. In that situation, that is 30 days that the municipality is giving for a response.
Commissioner Stebbins, do you have any response?
Sorry, just taking a minute to try to read through it and figure out how we would adjust the language. Madam Chair.
Yes, Commissioner.
I'd like to explore, and we can kind of continue on, but I'll be happy to withdraw it from where I suggested it be added, and might take some time to see if we might put it back into 102. Does that make sense?
So the one distinction, though, that I want to make sure it's clear is like the action, the onus is not on the CCC. In this case, it would be on the host community in their response to the CCC.
Yes, but the onus is on the municipality, but I think we, as a matter of policy, if it was adopted, we're taking a proactive step to only give them 30 days. So if they don't respond within that 30 days, instead of waiting another 30 days, which is another public meeting or 2 public meetings, it's a proactive action to make it quicker.
I see. Commissioner Stebbins.
Would this not also benefit the host community by shortening that timeline, saying you've done good work, you've followed the model HCA process? It gives them the opportunity to respond faster and move faster on their end.
They have that opportunity now. Some municipalities, when we deem an application complete, and we send out that municipal notice, some municipalities come back the same day. So they always have that ability. But if it's a big municipality or a small municipality, depending on available resources, they may not get to it, they may not be able to get to it. So it shortens the period of time. It's like, oh, maybe I should get to it within 60 days, but if I don't in 60 days, the biggest benefit is to the applicant.
Okay. I might want to give some consideration of how we might make that optional for the host community instead of forcing it on them. Might be an opportunity we can think about when we get to the social equity part of our discussion. Again, if it's a way that they want to feel that they're fostering opportunities for social equity businesses. I just throw another pin, but let's put a pin in that and think about it when we get to the social equity stuff.
I hear you, Commissioner Stebbins. The municipal equity section, there's already, so this speaks to social equity businesses, so that's already contemplated and drafted within the regulations. But if I'm understanding you correctly, you were thinking about beyond that universe to general applicants. Is that correct?
I was in my initial proposal and kind of where it was falling in the regs, but happy to withdraw that based again on the feedback from Director Potvin and not meaning to muddy up the process for everybody else. I get that. But I want to keep the option open of maybe exploring where we can fold that into social equity and maybe have to go back to 102. Again, if there's an advantage for the licensee and a mutual advantage for the host community, again, to kind of help fast track something, make our work easier on our end, and it might help a host community comply with their social equity goals and objectives.
So this is for social equity businesses.
Thinking about it now, yes.
And it's already here. So that's why I just wanted to make clear that's here within our draft regulations. That's what 500-102.
And my suggestion being, I think, knocking it from 60 days down to 30 days for the community.
Well, it's 30 days here.
Which is, may I?
Sure.
Which is there. So the additional benefits, because the 30 days, so the 60 days applies to all licensed applicants right now. The Municipal Equity Working Group suggested that there's an exception to that for social equity businesses and businesses that are held with majority ownership of economic empowerment and social equity, that the response time for the municipality is now 30 days, or it's presumed to be compliant. With the recommendation or the proposal that I was throwing out that was kind of tying in, it would capture an additional population. More likely than not, it would capture general applicants. It would capture businesses that may not have majority ownership, may only have 10% social equity. So there's the population of like our equity participants, that's already captured for the 30 days, but the additional businesses that don't meet those qualifications right now have a model host agreement that was utilized would also benefit. So it's extending the benefit of that 30 days based on the model host agreement.
Okay. Thank you for that clarification. Chair, if you would just allow me to kind of keep mulling on this, but
Okay.
we can move ahead.
Enforcement Council Lopez.
Thank you very much, Madam Chair. And thank you, Commissioner Stebbins, for raising this topic, and Director Potvin for speaking on the model HCA and kind of the value that it's supposed to bring to this process. So I do remember for the HCA working group that we did discuss that the model HCA, if an HCA is submitted that conforms with the model HCA, it would be deemed compliant. And while I do believe that was part of our policy recommendations, it either didn't make it to the draft regs or got lost along the way in terms of the version of it. So I would propose that we actually state it. I've dropped some proposed language in the regulations. I would propose a new section 500-180 subsection 2C. So in subsection 2, that's where we introduce the general requirements for the host community agreements and our review process. Subsection A speaks to a licensed applicant's obligation to submit a compliant HCA. Subsection B speaks to a marijuana establishment's obligation to submit a compliant HCA. I would propose a new subsection C that states that an HCA submitted by a licensed applicant or marijuana establishment, which is determined to conform with the Commission's model host community agreement, will be deemed compliant for purposes of this section.
Thank you, Enforcement Council Lopez. I also was looking for that language because we did speak about this at length, and I believe we were in agreement in the working group as well. Director Potvin?
I'm 100% remembering that same way, but I think one of the sticking points too with the HCA working group was that deemed compliant versus presumed compliant. I remember having that conversation over and over again. Am I correct on that?
Yes.
And I don't know where we landed on that.
Commissioner Roy, do you remember this?
I think we didn't want to box ourselves in with deemed. We wanted to do presumption because it gives us a little bit more wiggle room.
Yeah, because again, I think that's maybe where we ended up going because of that conforms with the model host agreement, but maybe they're changing a word from shall to shall not. Mm-hmm. And I think we
may, or yes.
Technicalities, but again, we're talking about the fact is, does the model HCA is it conforming with the intent of the commission in drafting this policy? Is it complying with the regulations? So I think it was, to give ourselves some latitude, it was the presumed.
And I think
Commissioner Roy?
our thoughts are, remember, we had a lot of meetings. No one's literally going to just cut and paste. So therefore, there are going to be their own responsibilities and stipulations in there. So in that, the devil lies in the details where that might not be deemed compliant. So no one's just going to lift it and I doubt that. And I think we kind of agreed on that. They'll take a form of it and use it as a template.
And we did have conversation, Madam Chair.
Yes, Director Potvin, please.
We did have those conversations, and, again, knowing this full well in so many different things that we do here at the commission is that one size fits all is not applicable.
That's what I'm saying.
And we talked about this at length. This is contract law, and there's municipal attorneys and law firms and corporation councils that are going to say, I want to change this word. So I just think it's likely that will happen. So I think giving us some latitude and making sure that the intent of the overall agreement, okay, yes, this still conforms.
Yes, I'm
So we're
glad
going
this
to
is going
presume.
good. Thank you again, Enforcement Counsel Lopez. Thank you, because this was important, and we did have a really comprehensive conversation about this. We talked about it at length, so this is really important.
And this was essentially the benefit of, the statute gives us the permission, the commission, the permission to have a model HCA. But I think that's where the working group went a step further of, here's the benefit of doing this.
That's right.
Which it incentivizes compliance.
So let me ask Commissioner Camargo, Commissioner Stebbins, what are your thoughts? I guess Commissioner Stebbins in particular, because you were asking sort of about the benefits of the model HCA. So do you feel like this addresses some of those concerns?
We're talking about,
The presumption language, so that let me take one step back before I ask that. Because we are presumed versus deemed. And the working group, and I'm looking at Commissioner Roy, just to make sure we landed on presumed. And as Director Potvin laid out, that the rationale was because of, the changes that were likely to occur. Are there any problems with the word presumed?
And if I'm hearing you, Madam Chair, and Commissioner Roy, in terms of how this was brought up, and I'm so glad you took the opportunity in the working group to address it and think it through. I think, to use Commissioner Roy's words, the wiggle room, in case we come back and do see that something wasn't just completely cut and paste, change the name of host community, change the name. Obviously, we invite that if that works for mutual parties. I would like to see this added. I liked the use of presumed. It might be enough to just kind of model that good behavior or encourage that good behavior. Okay. Seeing it in regs, seeing it in kind of the eventual communication tools that'll get rolled out. We obviously want to extend and highlight the benefit of using what we will all agree upon is a compliant host community model agreement. So I like Enforcement Counsel Lopez's suggestion about going back in and adding this language.
Okay, so do we have consensus about adding this language into our regulations? I see a head nod.
I mean, it's a consensus.
Okay. And Commissioner Roy, go ahead, Commissioner Roy.
I agree. I just feel it's important that I highlight, because we use the word compliant and compliance and good standing. And I read through the testimony we just received today, a few hours ago. And I just want to bring up, and I think it's germane, or it may be for another conversation, but one of the points from the municipalities, the MMA, good compliance standing must be defined. Section 500-182E states that, quote, approval of HCA's must be conditioned on a host community being in good compliance standing with the commission relative to any HCA to which the host community is a contracting party. They're asking clarity on this point is necessary.
Julie, can you repeat the?
So I'm looking at the email we got. This is, if you open the Word document on the email we received a couple of hours ago.
Can you just read the section?
Yeah, 500-182E.
So that section reads, approval of HCA's may be conditioned on a host community being in good compliance standard with the commission relative to any HCA to which the host community is a contracting party. And Commissioner Roy, do you mind, again stating the issue? Okay.
Yeah, so their question is around the term, quote, good compliance standing. And they're saying good compliance standing must be defined. Section 500-182E states that, quote, approval of HCA's may be conditioned on a host community being in good compliance standing with the commission relative to any HCA to which the host community is a contracting party. Clarity on this point is necessary.
If I can, Madam Chair, and it's a good point. I actually think I raised it yesterday because this is talking about what host communities, for a better term, are on the bad list, and trying to understand what standards we would say a host community is on that non-compliance list. I think the language that we're talking about here is just using the word compliant and just talking about it in a sense of that host community agreement agreed to by a host community, agreed to by either a licensed applicant or a marijuana establishment. We're presuming that compliance. So I think it's, Commissioner Roy, your point is being used in a little bit different context, but I hear what you're saying because I had this question yesterday about how do we define that host community being on the good compliance list.
Director Potvin.
Thank you, Madam Chair. I understand where the municipalities are coming from. So I think Commissioner Stebbins is right. There's a presumption that a municipality is in good standing. And then if you go down to section 3D is where complaints alleging non-compliance with that chapter, and it outlines a process and to investigate complaints against municipalities or licensees or applicants, and a process to allow maybe the non-compliant party there to rectify the issue after they're put on notice. And if they fail to rectify it, then the presumption of being in standing or being good compliance standing, that presumption is rebutted, and then they are not in good standing. So it's not, I don't know if it necessarily needs a definition attached to it, because there's a presumption that they're in it, and then there's a process to put them and have that presumption rebutted, where now they're not in good compliance.
Commissioner Roy.
And you don't feel it's appropriate to put it in the glossary?
It's definitely an option. It's a policy decision for the commission. I don't think it necessarily is needed because there's consequences to that non-good compliance that are already listed in section 3D. It could probably be defined in the definitional section. Just my one comment would be, let's ensure that it is consistent with 3D.
Director Potvin, do we use that term in other, do we apply it in our existing regulations outside of the HCA context?
Good compliance standing. There's similar language, but I don't know if it's necessarily that on point. Obviously, we talk about certificates of good standing.
Right.
We talk about in our leadership ratings, we talk about compliance leaders. I think that it might be mentioned in there as well.
Right.
But I'm not 100% sure about the good compliance standing that is listed in 3D for HCAs and host communities.
Okay. Commissioner Roy?
Do you think there could be language proposed about a definition of it? Like, we want to encourage this behavior, but not box ourselves in. I see what you're saying, like, we can't, like, I think Enforcement Counsel Lopez says yesterday, we don't want to really box ourselves in, right? So I'm sensitive to that. Is there a way to, we want to encourage, reward, highlight good behavior and good standing, compliance standing. Is there language that could be proposed based on what you said for the definition section?
Madam Chair?
Director Potvin, sure.
Thank you. That's definitely, it's an option. You can definitely propose language for a definition that what good compliance standing is for, as it relates to this. It's an option, but the one thing is we would just have to make, I would counsel that it would just, should be consistent with the substantive part of the section of which it lives to make sure that it's jiving. It's not a disconnect, but ultimately that's a decision for the body.
I will let, so I see Enforcement Counsel Lopez on screen. Did you want to offer your opinion or any comments?
Thank you, Madam Chair. I would just say that this is a policy decision for the commissioners. There is no legal impediment or issue with creating a definition for good compliance standing, other than just some of the enforceability components that I identified yesterday. But if that's a term that the commission wants to define, it's well within your authority to do that. And I'd be happy to work with the legal team to identify language or assist with drafting.
From a legal perspective, and I'll ask any of the lawyers in the room, is there any utility to defining this? Is it necessary? Do we need to define this term? I know that we received the comment asking that we define this term, but I'm wondering if that is actually necessary. Andrew's, oh, okay. Acting General Counsel Carter, please.
Yes, thank you, Madam Chair. I think I'm in alignment with Councilor Lopez, which is to say that, well, and probably Director Potvin as well, I'm not sure that it's necessary, but if this is a step that the board wishes to take for clarity or for other purposes, I think that we certainly could. The only thing I would flag as well is we will have to make sure that we are capitalizing it throughout the document if it's used in other places, just to make sure the regs are properly filed.
So my initial thoughts are, when we start defining and we're injecting terms into that definition, it limits us, and that's something I'm thinking about. But did you have any comments, Commissioner?
No, I agree. I understand what they're saying. I appreciate the ask for clarity. I'm just thinking legally good compliance standings would be interesting as a definition. And I don't know, I don't see it as a need right now, but I understand why you're asking.
Commissioner Roy?
I just think it's slightly unfair to the municipalities because loss of a host community's good compliance standing for purposes of 935 CMR 500-182E, publication of a host community's lack of good compliance standing in a form and manner determined by the commission. So we're going to publicize municipalities for not being good standing, but we're not going to define what good standing is.
Well, according to Director Potvin, you are in good standing until you do something that is not in compliance. So our regs do list out the things that are prohibited and the things that would lead to no longer being in good compliance standing. So, and I'm paraphrasing what you said, Director Potvin, but essentially everyone's in good standing until you do something that's not aligned with our regulations.
Madam Chair, if I may.
Yes, Enforcement Counsel Lopez, please.
So I believe, and if Director Potvin already touched on this, I do apologize, but I do think that we've given the municipalities an understanding of when they might be at risk of losing their compliance, their good compliance standing. So they are presumed to have good compliance standing. If there's a complaint regarding their compliance or lack of compliance with the regulatory requirements that is substantiated, they will receive a notice of deficiency and an opportunity to take corrective action to correct the non-compliant conduct. If they refuse to correct the non-compliant conduct and they fail to take those corrective measures, what that may result in is loss of their good compliance standing. That is the loss of good compliance standing. You have your good compliance standing, but if we reach a point where we've notified you of the non-compliant conduct and there is a refusal to correct it or a failure to correct it, that is when you lose compliance standing with the commission. So at that point, there will have been a dialogue with the host community.
Thank you, Attorney Lopez. Attorney Baker, did we get to that section yet? I know
No.
So why don't we take a step back? Let's read through and then get to that section so we can all be on the same page. Okay.
Madam Chair.
Oh, I was going to say, are we all in agreement of Enforcement Council's new proposed language for 182C that was dropped into the chat?
I believe we reached consensus, but I will ask again. So the proposed language from Enforcing Council Lopez, which is also the language that we agreed to in our working group, it amends 500.180 subsection 2 subsection C, and it reads: an HCA submitted by a licensed applicant or marijuana establishment which is determined to conform with the Commission's Model Host Community Agreement will be presumed compliant for purposes of this section. So I will look to, okay, Commissioner Roy, are you okay with that language? Commissioner Camargo?
And that's replacing the sentence in C.
No, it's new language that will be in addition.
Oh, in new subsection C.
Yes.
So everything else would just get
Under 1, under 2.
new letters.
82. It will go underneath.
Madam Chair, would it be helpful for me to clarify?
Yes, please, Attorney Lopez, please. Thank you.
So if we look at subsection 2, you have subsection A, which is speaking to a licensed applicant seeking a new license to operate a marijuana establishment. Then you have subsection B, which is a marijuana establishment seeking renewal of a license. Currently, subsection C then goes into the minimum acceptable requirements for an HCA. Before doing that, we would have a new subsection C that makes very clear that the model host community agreement, if an HCA conforms with it, is presumed compliant.
So does that mean we're striking what's there now?
No, it means that moves to D. So we have a new C.
Okay, new
The existing C becomes D, and I'm looking at Enforcement Council Lopez just to, okay. So with that being said, for the placement, for the language, Commissioner Roy, you're okay with the placement as well?
Yes.
Commissioner Stebbins, are you okay with the placement as well? Okay, Attorney Baker, we have consensus on the language. Okay, so we can continue.
Thank you, Madam Chair. So I am on page 72 under section 3, subsection 3C5. And I believe Commissioner Roy had some language around this topic.
Thank you, Attorney Baker. So let me go back to the chat. Now we're up a little bit here in the chat.
Commissioner Roy.
Commissioner Camargo?
Yeah. Commissioner Roy, I'm sorry, before you even get started.
Yeah.
I know we were here in this section. Where did we leave off with D and E? Was that, did we put a pin on that?
That's right, Attorney Baker, that's where we left off, was D and the language for the notice. Okay. And just to clarify, Commissioner Roy, your comments are for number 5.
Correct.
Okay,
I think we talked a little bit about it might have been a little bit related, but.
go ahead, Commissioner Camargo.
Yeah, no, I'm just kind of bringing us back because I think this is where we left off before we went to lunch, but then Commissioner Bruce Stebbins brought something else. So I think
I just don't know for clarity where we left off here.
Right. So I believe this discussion was whether or not to remove this discontinue language.
We talked about taking out D and E.
And we talked about D and E. So let me open this up. If any of my fellow commissioners wants to provide any comments, voice any concerns, if you have any questions. Commissioner Roy?
I think Councilor Lopez, if I understood her right, said that we can strike it because we don't want to impose anything unreasonably impractical in the regulations. So I think that's what I understood.
Enforcement Counsel Lopez?
Absolutely. Thank you, Madam Chair. So where we had left off with this, I had mentioned the option that the commissioners have to strike it as being unreasonably impracticable. Also, the commissioners having the option to explore whether, as a matter of policy, they would want to introduce mutuality of ending the contractual relationship as a matter of policy, and then also, whether or not they wanted to explore other options for the parties, like, for example, allowing them to proceed under an HCA that conforms with the model HCA for an interim period of time, or whatever other policy options you as the board find would further the purposes of the act, but also maintain our statutory obligation not to adopt regulations that are unreasonably impracticable.
Thank you, Enforcement Counsel Lopez. I'm glad thank you, Commissioner Camargo, because you just jogged my memory to where we were in this discussion. And I offered a suggestion around creating, essentially not replacing 5, but above 5. The procedure that must be followed in the event of discontinuance.
That's right there.
And I remember that language, Enforcement Counsel Lopez, that when you spoke about the entering the component mutuality, and that this might be a good section for that. And then Commissioner Roy's language. Thank you, but first, before we get into, let's table that. For D and E, before we continue into the next discussion with Commissioner Roy's language, do we have consensus in striking D and E? Let's see, a yes from Commissioner Ward, okay. So Attorney Baker, D and E, we have consensus to strike the language there. Okay. Now, Commissioner Roy, I will give you the floor to walk us through your language.
Sure. So in light of the fact that we struck D and E and now we're on 5, I wanted to amend the existing draft regulation as stated by inserting language that I procured from the Office of the Comptroller, who oversees the policies and procedures oversee municipal contracts. So having said that, if a host community discontinues relations with a marijuana establishment, it must demonstrate good faith and fair dealing when initiating any notice of termination, suspension, or amendment. A host community must be able to demonstrate that there exists a good business justification or legal necessity that supports the contract change, period. A marijuana establishment may submit a request for equitable relief to the commission. Now, that could be moved separately, but I inserted it where that last sentence was, and we can move that last sentence, but that's where I had inserted it right there.
Director Puffin.
Thank you, Madam Chair. I guess the natural question that I would pose is, what if it's not done in good faith? What do we force them to stay in a contract? And if so, is that something that is, essentially is a legal question for maybe our acting general counsel or EC Lopez, but what's the result of having that as a policy?
Commissioner.
Yes, so I would also want to ask the comptroller why they have that as a policy, and maybe if it does go to a court of competent jurisdiction, the fact that this is in regulation and they did not demonstrate good faith may actually provide more compelling argument in a court of competent jurisdiction.
So you're saying it would provide more grounds?
Yes,
to give
that's
them.
what I'm saying.
Did you drop that language in there?
It was
It's
dropped at 11:50.
yesterday, 11:50 a.m. yesterday.
Thank you.
That's interesting. I'm thinking it through myself. I'm sorry, Director Potvin, you had any more, or Enforcement Counsel Lopez? I think I can see you reading now, but if you wanted to provide any comment as well.
Madam Chair.
Director Potvin.
So I understand, or I think I understand the goal behind it, but I still see a gap between the goal and the end result and what happens in between. Like you bring up a court of competent jurisdiction, which we've talked about before as far as the legal enforceability of Chapter 180 right now and how it's not a feasible thing for many people to go to court for something like this. So just in this aspect right here, I see the same problem, but I guess I'm seeing the gap where what does the commission do with that before it goes to court? So how do we treat that scenario?
You mean in appeals process where they come before us?
So in a situation like that where they come and say, hey, this contract was ended and now we have to vet it and the ending of the relationship and maybe there was no good faith. I guess we just want to account for how we're going to react and treat that or enforce that and what the results or the end result, well, the intermediate result with us, what does that mean does that mean that we are going to, if we think the contract ended in bad faith, are we going to like maybe on its own treat it as if the contract is still in existence or not? I see a couple of different permutations that could happen, but what's the goal behind that and how would we treat it?
The impetus behind this is I met with so many licensees. I met with about 50 of them. David, you were there in Uxbridge. David's in the audience here. You have an outdoor grow in Western Mass that's 50,000 square feet. And that town says, I don't want to comply with the new law. I'm not negotiating with you. How does that person who spent their life savings pick that farm up off the ground and move it to another town? They cannot. And the way it stands now, they don't have to, the municipality doesn't even have to demonstrate that they tried to negotiate in good faith. They just didn't negotiate at all. And so I'm trying to say, this is an undue burden on our outdoor farmers in that equitable relief of a change of location fee waived is not equitable relief.
Director Potvin.
Commissioner Roy, I've heard the same stories and I 100% agree with you. The only thing I'm asking is based on that, I feel like that's the first part of the analysis. If we find that, what do we do with that? How do we treat it?
Attorney Baker.
Sure, I'm just slightly confused on the language, Commissioner Roy, because I think as it stands right now, if they wanted to amend an HCA, they would have to work with the party to do that. So
I agree with that.
Based on the language.
No, so we could strike suspension and amendment and just leave it at termination or dissolution. But I just lifted, as I've said many times, I just lifted that language, but I agree with you on that.
Enforcement Counsel Lopez.
I just will note for, just to inform the policy conversation that's happening right now, that the obligation to engage in contractual negotiations and good faith and fair dealing is an implied warranty of every contract. So if there was a breach of that implied warranty by either party would have redress and the ability to seek redress through the court system. So I just wanted to note that for the policy conversation, just so that you're aware.
I wonder, so, This is similar to how we landed with that discontinue language in the first place. It's like we know that that's a matter of the law of contracts, and to Enforcement Counsel Lopez's point, I wonder if this language could be provided in one of the notices that the commission gives to the MEs. So I wonder, instead of, I understand the concerns around enforcement because we can only do so much and some things fall outside of our wheelhouse. But if there is sort of that lack of knowledge and resources where, let's say, a licensee might not be aware of this, of, the implied warranty of contracts law, I don't think that that's common knowledge. I think an attorney would say that, but it might be helpful to provide that proactively. Commissioner Roy.
Director Pop, you asked, what do we do with that information if we discover? This could lend itself back to stripping them of their good compliance standing. This could be one of the parameters which we strip them of their good compliance standing, and that's how we can utilize that information.
So we would then make a determination on if a contract was entered into in good faith. I'm saying, based on what you're saying, the commission would be required to make a determination on whether contracts were entered into in good faith.
Only if they are terminated.
Right. But we would still, so I'm, Attorney Baker?
Sure. The language as it's currently drafted would say the host community must be able to demonstrate that.
I understand that. Thank you, Attorney Baker. Commissioner Roy, you made a statement about our ability to hold a host community. Do you mind restating your statement, and I can just make sure that I'm understanding you correctly?
What I just said to Director Potvin, how we could use that information?
Yes.
Okay, so he said, Director Potvin posed the question, well, if we have that information and it's determined that they didn't, what do we do with it? And I suggested how we could utilize the information is to strip them of their good standing compliance. And that has ramifications, because if they are stripped of that, it gets publicized, number one, and number two, they cannot negotiate for further licenses. So it does have a.
I guess, so my question, I did hear you correctly. So the question, because the way that I hear things is in steps, right? There's steps that happen.
Right.
There's a determination component there. Who is making that determination about whether or not it was entered into in good faith?
I would say that's part of the hearing process that afforded to both parties.
By who?
But that's what I mean. So by whom? Director Potvin.
Just for clarity, is the good faith that we're talking about here is not so much the entering into the contract of good faith, it's the dissolution of the contract or the non-renewal of the contract, whether that was a good faith or a bad faith in the example that you gave where the municipality says, I'm just not renewing it because I don't want to comply with the law. So it's not so much the entering into the contract, it's the separation of the parties and whether that's in good faith or not. And your suggestion, I think your recommendation, Commissioner Roy, is to put that in as a component of how you can determine a municipality not to be in good standing. But I think the other thing, because we're on section 5 still, where it's the relationship discontinues. I think the equitable relief there is not so much that any relationship discontinues because of bad faith. It's just any relationship that discontinues. So it captures a bigger population.
Surrenders.
Bigger population, even if it's in good faith, the dissolution, they still, the licensee might still have some relief, some equitable relief options, whether the dissolution happens in good faith or bad faith. But the bad faith aspect, that goes to the good standing component that's later on. I don't know if that makes sense or.
So you're saying.
I'm doing the same.
No, it makes sense. My question still stands. I still don't, but I see Enforcement Counsel Lopez. I will let you jump in with any comments or questions. No, you're nothing. Okay. Attorney Baker.
Thank you, Madam Chair. I would say that based on how we've thought about the process, it would probably be at the staff level to make that determination and then come up to the commission, similar to how licensing decisions are made. But that's my assumption.
Thank you. Director Potvin.
Thank you, Madam Chair. Consistent with past practices, anything in the regulations, like the section about non-compliance and deeming a municipality not compliant, it's referencing the commission. And normally, unless there's an express delegation or an express delegation through a vote down to the executive director and or his delegee, that decision-making power could ultimately still rely with the commission. So there's a delegation component here, and I don't want to go too deep into the other side of the aisle that would be acting general counsel. But just knowing about past practices and delegations to the executive director and on certain things over time, that's my understanding of it. But I will definitely defer to acting general counsel Carter.
Acting General Counsel Carter, before you step in, I'll bring us back. Commissioner Roy, restate again your suggestion.
Yes.
I can make sure I want to make sure I'm addressing the actual suggestion.
And before I do, Director Potvin said you didn't want to conflate it with surrendering of licenses, right? You don't want to conflate that?
Madam Chair.
Sure, Director
And I will restate.
So I surrendering of a license versus the dissolution of a host community agreement, I don't want to conflate them. I think they're separate items completely.
I agree. One of the areas of concern from the MMA is, of note, there is no process for the yielding up or surrendering of a license in our draft regs right now. In the draft regs.
Commissioner Roy.
I'll get back to your question. Okay, so I just wanted to put that on the table and then, okay. So you want me to read the language again? Yes. Okay. If a host community discontinues relations with a marijuana establishment, it must demonstrate good faith and fair dealing when initiating any notice of termination. A host community must be able to demonstrate that there exists a good business justification or legal necessity that supports the contract change.
Okay. And from this, we went into a conversation about the utility to the commission. And your suggestion was that we use that if someone is no longer, let me actually go against my own rule. Where is that language?
The good compliance language?
Yes.
Non-compliance, so it'd be under non-compliance, so page 72, towards the bottom, D. Person files a complaint, the commission substantiates an allegation of non-compliance.
Okay, so
three.
You're saying
D3.
D3.
And then you go down from there.
But so the record, so what you are recommending, I'm paraphrasing just to make sure I understand this. We use this language, and if we find the commission that there was no demonstration of good faith and fair dealing with initiating any notice of termination, then that could then what? So you're saying then B, C, and D? You're saying, what is your?
Where would it fit in
yes. Just so what is it trigger? That's what I'm trying to figure out. What does it trigger? What is the thing that you're saying happens? I don't want to.
I would say that somewhere around where host community is deemed non-compliant, lack of good compliance standing. So somewhere that would trigger a lack of good compliance standing. So,
Madam Chair, if I may.
yeah.
Yes, please, Enforcement Counsel Lopez.
So one thing that might be helpful, I believe what I'm hearing Commissioner Roy say is that she would like to impose a good faith requirement on host communities before the ending of the relationship. Now, the commissioner has also put in the chat options that the HCA determination would include, which involve a mutual agreement to end the relationship. So if there's a mutual agreement to end the relationship, that may relieve some of the potential policy concern. If it does not, then another option is to impose a good faith requirement in the regulations in terms of in a section of a subsection of 3, and then it would be a regulatory requirement that would fall within the complaints and investigation process. So remember, the complaints, any person can file a complaint alleging that there's not compliance with an HCA requirement. So you can make good faith an HCA requirement, but I think the first question is, if there is a policy shift to expecting mutuality in the ending of that relationship, is the good faith requirement still necessary?
Commissioner Roy?
I believe it is, because I don't think you'll always have mutuality. I don't think this is what I'm hearing from licensees. So if I have to make a motion on this, I will. I just think it's extraordinarily important that we have this in there.
Well, let's see, Commissioner Stebbins, Commissioner Camargo, do you have any thoughts, any comments? Commissioner Stebbins?
Thank you, Chair. Again, I'll go back to my original approach. I'm concerned about this section. I worry about the discontinuance of a relationship. And I think, as Commissioner Roy has talked about, what that does to somebody who is invested in a piece of property and how we continue to view a license of a legally operating business, short of having a compliant HCA. There may be terms within an HCA already between a host community and a party that talks about what steps might be taken by both parties. I mean, that's a little bit, for me, a little bit of an unknown here. Hopefully enough folks have thought through what they want to have on a host community agreement. You're going to do this, I'm going to do that. If we agree to, as Commissioner Camargo says, break up, what are the rules, who gets the dog, everything else like that. That may already be baked into an HC, and we don't know that because we don't see those until now, or until this step. I look at, first of all, I think going back to our regs, I think it might be helpful for us to drop the language that we had in 4D, maybe move that down into 5. Because I think that just one that would cover us in terms of notification. I do agree it was probably in the wrong spot and should not come out with our notice, but it might fit under 5 more appropriately. But I do like the discussion we're having around some type of teeth to, unless you can prove this kind of good faith in dealing, and it might be helpful for the commission to be aware of that would help us determine whether a host community is still in good compliance. So I like kind of having that teeth to it, that, might protect a licensee at the end of the day.
Commissioner Camargo?
This is just a clarifying legal Chapter 180 question, but is this required by Chapter 180, like this section 5 that we're in right now?
The whole section?
5A, B, C, and D.
The equitable relief section. So,
I'm sorry.
no, that's okay.
Well, I guess not the whole section, but I guess some of the conversation we're having right now around what Commissioner Stebbins is alluding to. I'm not talking about D&E up top, but just sort of the larger conversation.
Do you mind restating that?
So I'm just kind of curious, like we're having, and maybe I'm getting lost a little bit, but I'm hearing what Commissioner Stebbins is saying. I'm hearing the language that Commissioner Roy wants to include. And I know that we striked D&E. So I'm just curious, like from this conversation we're having right now, what is required by Chapter 180?
Are you asking about for the discontinue language?
Correct. Thank you.
I am looking, okay,
Sure.
Attorney Baker.
I don't think that there's specific language that says the commission has to do X, Y, and Z, but is there anything?
Director Poppins.
Well, I agree with you, but the only thing I would say is it's probably the inverse of that, which has existed in 94G and maybe got spelled out a little bit more. It's that a marijuana establishment or MTC, in order to get licensed to operate or continue to operate, must have an HCA.
Yeah.
So that's where the discontinued, it's not specifically discontinued,
Yeah.
but it is to account for that continue to operate, what happens when the reverse exists.
Yeah.
So I think that's what the working group was trying to account for here, is that requirement. It does seem like there's a statutory requirement to have one of these things in existence to continue to operate.
Thank you. Commissioner Roy.
In our working group, remember we talked about carrot and stick and so the hammer, and we laughed about a jackhammer, like, right? Remember the jackhammer? Okay, so the naughty list, right? That's a way to the stick approach where we publicize those who have lost their standing, their good compliance standing. On the flip side, we can also have the carrot for those communities that are in good standing. We are able to provide that information as well, right? So people that are just entering the queue or looking for, could be social equity cohort, deciding where should if I do pursue this, what communities are more friendly than other communities? So that's the carrot. And then with the stick, I just feel like if communities, and we heard it, I think Brookline, we heard it in testimony. This is real life situation that could happen. Where a community say this is no longer feasible, we're not even going to negotiate. And somebody that has a grow or a $15 million cultivation, that's a hardship and a half. And the fact that they won't even, there's no good faith to even try is, and so I guess my point, people were practically, I don't want to say in tears and sound dramatic, but it was dire that I have a family farm. Our whole life investment and savings are in this family farm. I can't pick it up and move it to the next town. They won't even negotiate with me. Is that cause for losing good standing with the commission? It's hard to answer.
Director Potvin, I don't know if you're looking because you have a, oh, you're like.
You and I doing me and Commissioner Stebbins thing right
Yeah, I think so.
Like an illegal analysis right now.
Be afraid, be very.
Be careful what you say.
Madam Chair.
Director Potvin. Well, I guess because it's a delicate balance. It's a delicate balance that we're trying to strike, both in our working group and right now in public. So everyone who's watching can hear how complicated this gets, because we have a certain authority that we do want to maintain. We do want to make sure that we are creating something that helps those licensees, like the outdoor cultivator that you mentioned. But then there's also the authority and the ability of municipalities, and then we have contract law. So this is the balance. I will pause. Director Potvin, did you have a comment? If not, it's okay, but I wanted to see if you did have one.
You're my spirit animal right now.
Okay.
That's exactly what I was going.
Okay. So, Commissioner Roy, what is your request? What action do you request?
I feel this is not an undue burden because this is from the Office of the Comptroller, and we are applying it to the cannabis industry because when they enter into municipal, the cannabis industry is unique because alcohol industry, they don't have to enter into these contracts, but with municipalities. So the cannabis industry requires a municipal contract. If the municipality is not willing to negotiate at all, what is, then they're supposed to live under these rules, the land of the law of the land for the office of the comptroller. I wholeheartedly would love a good faith regulation in there because definite, no.
That's provision.
Provision. I think without it, there is uneven
I hear you.
leverage.
I hear you. I'm not opposed to the language. The thing that Director Poffin, you made my mind start thinking is just what is the recourse? If there's something here where a host community does in fact discontinue the relation without demonstrating good faith and fair dealing, and that's why we landed in the other section, was just figuring out, so then what happens? Director Poffin.
Thank you, Madam Chair. So right now, the Section 5 that we're talking about is if host community discontinues relations with a marijuana establishment, that ME may seek a request for equitable relief. There is.
I'll pause because there's a possibility that, again, this might be a number 5 and that become number 6.
Okay.
But okay, now continue.
So I understand the good faith aspect of this, but just generally right now, as it stands, whether the discontinuance was in good faith or bad faith, all of them, if the discontinuance happens, still has these equitable relief. So again, and I think that's maybe, Chair, this is where you were going, is a 6, if the host community discontinues the relations in bad faith, maybe that's where there's maybe additional equitable reliefs. Is that where you were going, Chair?
Thinking about that, I haven't gotten to what, yes.
But, and that may capture if this, then that, in the Commissioner Roy's example, where we were trying to get to what does this mean?
Yes.
So that it could be additional heightened equitable reliefs if bad faith is found.
If I could hug you, I would hug you right now. Thank you, Director Poppin. But I was using the word trigger. I'm like, hey, what is this trigger? What is the recourse? This, then what happens? So you said that much more eloquently. So thank you, Director Poppin. Commissioner Roy.
What would be an adequate equitable relief?
You know what?
To a 50,000 square foot farm outdoor grow, what would be adequate?
Let's get into the equitable relief section.
Okay.
Let's read it. So let's pause. Attorney Baker, can you read through the equitable relief section to see what we have here?
Sure. So I'm currently at 183C5. If a host community discontinues relations with the marijuana establishment, then a marijuana establishment may submit a request for equitable relief to the Commission. A marijuana establishment's request for equitable relief must identify facts, information, and any documentation to support why a marijuana establishment should be considered for equitable remedies. A marijuana establishment shall ensure that a request for equitable relief includes a host community's notice under 935 CMR 500 183C4D. B, the Commission will conduct a paper review of the petition and make a recommendation to the Commission. C, the Commission may exercise its discretion whether to grant one or more of the following equitable remedies to a marijuana establishment. 1, extension of a license expiration date without incurring additional prorated fees. 2, waiver of a change of location fee. 3, other equitable relief as determined by the Commission. And D, if the Commission grants or denies equitable relief to a marijuana establishment, the agency will provide notice of its decision to a marijuana establishment and a host community. A host community or a marijuana establishment may seek relief from a court of competent jurisdiction.
Enforcement Counsel Lopez.
Thank you, Madam Chair. I wanted to note that in terms of the conversation that we were having, I think everyone here understands that that we can't make a host community stay in a contract any more than we can make a licensee stay in a contract. But the commission does have the ability to impose requirements on how they end that relationship, which goes back to this good faith, bad faith discussion. I will say that a good faith requirement, just to set expectations here, that is a challenge to prove in terms of, let's say we got a complaint of bad faith. Sure, we would investigate that, but substantiating that would be difficult, except in the most egregious of circumstances. So I just want to kind of set expectations there that this isn't just an easy thing where you can just look into someone's mind and say, oh, you're operating in bad faith. It likely would be something that we would be able to substantiate and then kind of, enforce in those in rather egregious circumstances. But with that said, in terms of a point that Commissioner Camargo raised before, the commission does have the authority to impose requirements on how this relationship ends. And so, it's the commission has a vested interest in making sure that the relationship doesn't just end and the ME is expected to just pick up and move its operations in 30 days. We have a vested interest in making sure that there's a proper wind down of the business, that the property is, that the marijuana product is properly accounted for, and that all is done in compliance with the regulations. So it might be worth the commission speaking to, Commissioner Roy had identified 4 options that an HCA determination notice could include. I don't think we circled back to that or identified that in terms of where the board is on that. But the 4th one, in terms of ending the contractual relationship, does speak to instituting a wind down process to enable that compliant transfer of the license to another suitable location. And that is related to equitable relief and could potentially be baked into equitable relief as a component of the equitable relief measure or section. But I will just say as a caution that we want to keep number 3, which says other equitable relief as determined by the commission, because we want to leave room for the commission to respond to particular challenges that the parties may face as part of the termination of this relationship.
Madam Chair.
Commissioner Stebbins.
Thank you, Madam Chair. So if I can, just to kind of clean some of this up, and I promise I'll stop going backwards a little bit, but back under subsection 4, where we removed D and E,
Page 72.
yeah, top of page 72. After the party's option to submit an HCA waiver, I think Commissioner Roy, you dropped into the chat option. We should be able to suggest an option is to sign an interim HCA that conforms with the model HCA to be relied on in the interim until the parties come to an agreement. So I'm asking that we put that in as the new letter D under subsection 4. I would also suggest D is a standalone. I think this spoke to your point, Commissioner Concepcion. D is the new number 5, and that should be a standalone. That's more to notification. And then I think where we have 5, which is if a host community discontinues, that should be a new number 6. Under that, I do have a question under C. I need a little more definition to I, which says extension of a license expiration date without incurring additional prorated fees. Either from my colleagues or from our team can have, I'd welcome a little bit more of a.
that, the last one?
So this is under C, the commission may exercise its discretion whether to grant one or more of the following equitable remedies to an ME. I'd like a little more clarification of the intent behind I, or the purpose behind I, and some clarification to that.
Commissioner Camargo.
Everybody see where I am. Sorry.
Yeah, thank you. So I want to just kind of go back a little bit. So Rebecca, you said a lot in the comments that you said, and sort of my thinking was like, what, where, who, is this required by Chapter 180? And then you talked a little bit about this is a policy decision for us. So I appreciate that. And you talked a little bit just about the wind down process that I was talking about as well. So I think you said a lot, and I don't know if we unpacked everything that you said. But then now, Commissioner Stubbins, just to kind of be clear, what you're saying is in section 4, you're saying bring back D.
If I might.
Yes.
Sorry, just for clarification, so 4 speaks to, going back up to 4, which starts at the bottom of page 71. If the commission determines that a marijuana establishment's HCA does not comply, the HCA determination notice shall provide the following. I like the idea of adding after the current letter C, D, which is option to execute and sign an interim HCA that conforms with the commission's model HCA to be relied on in the interim until parties can come to an agreement. Again,
New language that Commissioner Roy put in,
what's that?
the new language.
Wait a minute, no. He's saying something different. Commissioner Stebbins, so you're saying D would provide in the notice that the parties have an option to enter into a model
Right.
HCA agreement
Right.
in the interim. So
Right.
they could execute
As
another
option for an existing establishment or MTC. You want to keep trying to negotiate. In the meantime, you have the option of giving us an agreement based on our model HCA, and that will kind of cover everybody in the interim.
Commissioner Camargo.
Where's that language?
In the chat.
It's in the chat. It's
I just redropped it. The last one, I just redropped.
One-
I see it.
So 51, number 151, it's 3. So I'm suggesting making that the new letter D under 4, again, is an additional option we can offer them. Again, suggesting that new number 5 be created, which is the language from 4D, which we agreed to take out of 4. And that's getting to that notification to us and to the establishment, the host community wants to discontinue the relationship.
Commissioner Stebbins, are you, so would you amend that language to strike the first sentence? So I'm looking at D, and are you, because the notice would provide that a host community's option to discontinue relations with a marijuana establishment. A municipality shall notify a ME if it no longer intends to continue as a host community for a marijuana establishment. So are you recommending, I want to make sure I'm understanding you correctly, that we eliminate that first sentence that states a host community's option to discontinue relations with a marijuana establishment, and then go right into what a municipality's obligations are when they choose to discontinue?
Thank you. I'll clarify my thought on that. Again, creating that as a new number 5. So that's outside of the notice that we're going to send the parties.
And how would it read?
A host community that chooses to discontinue relations with a marijuana establishment shall notify a marijuana establishment if it no longer intends to continue as a host community for a marijuana establishment. On receipt of a notice of discontinuance as a host community, the marijuana establishment shall notify the commission. So that's kind of a standalone. It's kind of making sure all parties get notified. And then I think again, we kind of scratch E because I think E picks up where a new number 6, beginning with if a host community discontinues, then a marijuana establishment may submit a request for equitable relief to the commission.
Commissioner Camargo?
So and I had talked about this one before in terms of creating some kind of timeline or guidance. So with this new sentence and the old language, does this still, I don't know if I still see the problem where it's like, what's the timeline and what are we creating? What are we doing on the back end? What's happening on the back end? I had talked about that earlier today. So if we sort of put that back in there, what does this mean? I understand what it means in terms of, they shall give notice and all that, but what are we triggering on the back end for municipalities and operators as it relates to a timeline or, Rebecca, I think you had mentioned it earlier, a wind down process.
Do you have a recommendation?
I don't have language, but I think the concept of if we're adding this back, I think we're going to need some language around the wind down process. Because that was my whole reasoning why I sort of recommended that we strike it. That's why I was asking, is it required by Chapter 180, all that stuff. But, if we put it back in there and I see the language that's in here, I'm just thinking again on the back end and the wind down process. So we're telling them that this is an option, that obviously they can do this. Commissioner Roy, to your point, right? Folks are going to possibly get some notices that this is happening, but what does that mean? Are we going to give them guidance? And maybe I don't know if it's in a guidance, it's in the notice, but are we going to provide some kind of wind down process? And
I wonder if we can do a hybrid of Commissioner Stebbins' suggested language for the new 5 and Commissioner Roy's language, the good faith language as well, because I do think that drives the point home. It doesn't necessarily address the winding down procedure though, so that would still need to be created. But I think we're getting to something that is a little more meat there.
Can you bridge them?
That's what so Commissioner Stebbins, can you repeat your language?
Sure. So as it constitutes the new number 5,
Yes.
a host community that chooses to discontinue relationships with a marijuana establishment shall notify a marijuana establishment if it no longer intends to continue as a host community for a marijuana establishment. On receipt of a notice of discontinuance as a host community, the marijuana establishment shall notify the commission.
So maybe before that last sentence, we inject, if a host community discontinues relations with a marijuana establishment, it must demonstrate good faith and fair dealing when initiating any notice of termination, suspension, or amendment. The host community must be able to demonstrate that there exists a good business justification or legal necessity that supports the contract change. And then following that is the marijuana establishment shall notify the commission. Commissioner Roy.
I love it. We can strike amendment and suspension because that's addressed in other areas of the regulations, and just leave it to termination. Any notice of termination, which I rewrote somewhere. Attorney Baker brought up a point. We already have procedures in place for the amendments. So this is just around dissolution.
Looking around to
But
see
I
if there are
love that.
any
I
thoughts.
love-
Does this get to?
It does.
Yeah, okay.
It does.
So for clarity, the host community would be notifying us that they've taken all these necessary steps and measures. And we're also asking for notification from a marijuana establishment as well. Is that the way I read it? Or
Great
heard it?
thoughts coming together. It's pretty.
Commissioner Stebbins, your question is who's notifying us?
Yeah, who's notifying us essentially with the understanding, the detailing, the information that Commissioner Roy is seeking?
Well,
Just from where
as I
you-
stated it, this isn't what's been thought through completely, so we can flesh this out a little bit more. But the way that I read it, it would fall on the ME to notify us.
That's how my understanding too,
Okay.
based on that last sentence.
I'm looking at Commissioner Camargo. Call you myself.
She's over here in this lonely island over here.
Closer.
No, I'm actually, I think I'm getting sick.
Okay.
But just don't forget about the wind down process.
No, we're gonna get to, I think.
Right,
We'll get to
right.
that.
All right, okay.
Right. Director Potvin, can you lend us your opinion on,
Give us your blessing.
please? Like, what is your opinion?
Or give us a break.
We have so much to do.
Thank you, Madam Chair. Just a couple of thoughts is, that D&E that was stricken and now seems to be
Brought back to life.
brought back to life and it's
Just
breathing
D.
again. Just D.
He's dead. Just recollection from the working group and just to give the historical context of why those are in there. It's obviously not to promote the idea of municipalities and host communities, municipalities and marijuana establishments to dissolve their relationships. It's there to basically be included in the notice of, if this happens, just know you have equitable relief options that you can seek from the commission. So without that, how do they know, right? How do you know? Thinking of a Whitney Houston song at this point. How do I?
Right, so,
You think we don't need a break?
but, so with that being said, that's why that was in there, so just consideration behind that. But I think the merging idea that you are coming up with, Chair, between Commissioner Roy's idea and Commissioner Stebbins, I think that's a good idea, but to go a little bit further, still, what happens if good faith is not found? Here's your equitable relief, maybe a heightened list from the one that's in the current 5D.
Yeah.
That other section. I'm just saying, like, still what happens if you do merge that and you do have that good faith, and what happens if good faith is not found? In that case, what that? So I would just caution to what's the catch?
If I may.
Enforcement Counsel Lopez, and then we'll,
Okay.
Commissioner Camargo. Enforcement Counsel Lopez, please.
Thank you, Madam Chair. Just dropped language in the chat to make sure that that's reflecting the new subsection 5, or if there are changes that the commissioners want to make to that language to make sure it captures what your public policy.
I'll read it out loud. A host community shall notify a marijuana establishment if it no longer intends to continue as a host community for a marijuana establishment. If a host community discontinues relations with a marijuana establishment, it must demonstrate good faith and fair dealing when initiating any notice of termination. On receipt of a notice of discontinuance as a host community, the marijuana establishment shall notify the commission. A marijuana establishment may submit a request for equitable relief to the commission. Commissioners, well, first, Commissioner Camargo, did you still have a comment?
Well, I did have a comment, but it was about some examples for the more equitable reliefs. So I'll wait, remedies.
Commissioner Stebbins.
Thank you, Council, for dropping this in. I guess what I was envisioning, and I think what we wanted to see, was some documentation around that demonstration of good faith and fair dealing. The way this reads now is host community, you have, if you decide to discontinue a relationship with a marijuana establishment, you must demonstrate good faith, fair dealing. Who are you reporting that effort to? Is what I'm thinking we're missing.
Okay. I hear you. You're, okay. The documentation aspect is like that does seem to be a key component. What is your suggestion?
Or they can provide it to the host, to the marijuana establishment. The marijuana establishment gives us all that.
Right.
But we're asking for some essential statement that we did all that, we tried to do this in good faith and fair dealing, but we have to discontinue our relationship, kind of here are our reasons why. Is that something that goes to the marijuana establishment and then they send it to us? It's kind of like we want their attestation that they've done good faith, that they were dealing in a fair way. How do they represent that to us?
Commissioner Roy?
So on receipt of notice of discontinuance, you're going to get a receipt of notice of discontinuance that they will have to therefore submit to the commission.
But if I'm understanding you correctly, Commissioner Stebbins, and this might be really helpful for licensees, that they need to be notified by a host community, basically the reasoning for the discontinuance in writing, and it must demonstrate that it was done in good faith. Is that an accurate sort of, okay. Enforcement Counsel Lopez?
One question I have is, and this is a policy decision to be made, but I'm just thinking in terms of workability and enforceability of this. Is the policy objective to have it's hard to document good faith or to document that someone has good faith, but is the policy objective that no host community may discontinue relations in bad faith? And perhaps if that's the policy objective, we could just say that instead of this demonstration, which is kind of brings a burden of proof element into it to either be figured out between us and the host community or between the host community and the marijuana establishment. It could breed more litigation, more conflict, more dispute, but maybe just imposing that requirement of no bad faith. And then again, if we receive a complaint, we look into it, we will see if we can substantiate it. But the expectation is still there, the message is still sent. And also the licensees, if the contract ends in a way that they believe is a breach of contract for either party, or that they believe it violates the implied warranty of good faith and fair dealing, they also have options outside of the commission to explore for figuring out that conflict. But from an implementation standpoint, I think the introducing a burden of proof for good faith will complicate this.
Commissioner Roy?
I feel that in Massachusetts or in probably every other state that the municipalities are held to a different standard from a regular two-party contract. And therefore, it's the burden to demonstrate good faith is easier than, let's say, just two contracts between two people. So in other words, a host community must be able to demonstrate that there exists a good business justification or legal necessity that would support termination. Municipal, like, they're held to a different standard than every other contract in Massachusetts. And therefore, the burden to prove that there was a lack of good faith is maybe not as difficult.
Commissioner Stebbins?
Sorry. Yeah. I'm not a lawyer, but sometimes I'm sounding like I pretend to be. Yeah. Looking at this language, if a host community discontinues relationships with a marijuana establishment, it must demonstrate good faith and fair dealing when initiating any notice of discontinuance. I think we could view that as a reminder of their obligations under, the Inspector General's requirements, again, reminding them of their obligation. And then you just move right on to, on receipt of a notice of discontinuance, the marijuana establishment shall notify the commission. So it's that that sentence that starts with this: if a host community discontinues relationship with a marijuana establishment, it's our way of kind of reminding them what their obligations are. And maybe it isn't so much as producing a statement or a declaration, even though they may want to do that to kind of protect themselves under the law, but it doesn't become something that we're looking for in that notice of discontinuance.
Wait, I don't know what you're proposing.
I'm saying we can leave the language in, it just may not produce anything to us that I think to Enforcement Counsel Lopez is going to produce a document or something.
But it's there when it's egregious as well, and we can enforce the removal of the good compliance standing, and it may give a licensee grounds in a court of competent jurisdiction.
Right, and I think when we do get to discussing the good standing piece again, we're going to base that, I would assume, on a number of factors. And it may be it's based on you just discontinued a relationship and didn't tell us why. I don't know. I think the language is here and it's okay. Just being mindful of what our expectation should be as to what we're going to get.
Yep.
I have a question for, Enforcement Counsel.
Just a final, yes, thank you, Madam Chair. Just a final note. I would just say that in general, it would be in terms of holding, like enforcing accountability with this policy objective, it would be easier to ferret out bad faith than good faith. Bad faith, you can get a sense of bad faith from the conduct, from the actions, from correspondence, but good faith is just a little more challenging. So that's the last piece I'll throw out there for your contemplation.
Enforcement Counsel Lopez, I agree with you in terms of bad faith as opposed to good faith. I wonder, do you have any thoughts on language? I want to sort of assess out what this would read like to make sure we're not losing like the spirit of what we're trying to accomplish.
I have proposed language that I will put into the chat.
Thank you. Attorney Baker.
Thank you, Madam Chair. I just have one friendly amendment to one of the sentences on here. It just reads on a receipt, and I don't know if Enforcement Counsel will come up with different language, but it says on a receipt of a notice of discontinuance as a host community, and I would just maybe recommend from a host community there.
Thank you, Attorney Baker. Noted and incorporated into this next draft. Good catch. So I have the language here, and it's just a little more, I would say it's a little more workable, again, from an enforceability standpoint. But what essentially it says is a host community shall notify a marijuana establishment if it no longer intends to continue as a host community for a marijuana establishment. Host community may not discontinue relations with a marijuana establishment in bad faith. On receipt of a notice of discontinuance from a host community, the marijuana establishment shall notify the commission. A marijuana establishment may submit a request for equitable relief to the commission.
Commissioner Roy.
I like good faith better. I mean, that's dishonesty or fraud in a transaction.
Is there any other thoughts?
So someone would have to commit dishonesty or fraud.
Commissioner Camargo.
Yeah, I mean, you're asking for thought. I don't practice law. I'm not a lawyer, but I think the good faith, I think it goes back to what Rebecca has been saying in terms of that being challenging, especially to able to defend that, right? Good faith determination. So I hear you, Commissioner Roy. But it could be difficult. I guess those are just my thoughts since you asked.
Commissioner Stebbins.
I'm okay with the way this reads now. I hear Enforcement Counsel Lopez's concerns. Again, I'm looking at this as it's a reminder. It's obviously it's a notification requirement that we're making sure is in place. And, it also is sending a message of, we hope the host community is not discontinuing their relationship with the marijuana establishment in bad faith.
So Commissioner Stebbins, I'm glad that you made that statement because I want to make sure we're all viewing this the same way. This language, the recommendation on the table is to assert it into subsection 4, so continue to having this in 4, or are we having a conversation about a separate, new 5 before the 5 that's here? Because you mentioned notice is under 4. I just want to make sure we're all sort of on the same page. Is your recommendation to inject this language into the notice provisions under 4? My
recommendation was to put this as a new number 5. This is not, I don't want to be on the hook in our notice to say, here's an option to just break up your relationship. Again, I think that's between the parties. I think it might be contained in the HCA, which, as we all know right now, we don't see, so I don't know what separation agreement or terms might be. I think it's not in the commission's best interest for us to say in a notice, well, you have the option to go break up. That this kind of moves this down to a standalone, which, okay, after all this, if that's what you decide to do.
Right.
We need some notifications so that we know you're going to wind down or you're just moving in different directions. So I like this as either a standalone 5 or this kickoff to the redress section that we're going to take up.
Enforcement Counsel Lopez.
Just one more point on the language that is being discussed and proposed by Commissioner Stebbins as standalone 5. A host community, I originally wrote a host community may not discontinue relations with the marijuana establishment in bad faith. I would actually suggest shall not discontinue relations with a marijuana establishment in bad faith, but that is for the board to decide if they would like to adopt that more restrictive language.
Commissioner Roy.
Just for the record, and I appreciate all the arguments in favor or against. I feel bad faith does not go far enough, and that is involving dishonesty or fraud. And I feel that good faith and fair dealing goes far enough to make sure that someone just doesn't say, I don't want to comply with the chapter 180, and therefore I won't even come to the table. We have people that won't even come to the table. Now, that's not bad faith. Refusing to come to the table is not bad faith.
Commissioner Roy,
refusing to come to the table.
Where's the source? You're defining bad faith in limited terms. So I guess I'll ask you.
Okay, well, maybe I'll defer to legal if they have a more expanded definition of bad faith, and that might help me.
Enforcement Counsel Lopez.
Absolutely. Commissioner Roy, you bring up such an important point. Bad faith, the commission defines what bad faith is. We have the authority and the discretion to interpret our laws and our regulations. So if bad faith for this body means active efforts to kill the contract solely because the town does not want to honor the new laws, that we can interpret that to be bad faith. We decide what bad faith means. There's no limited definition that we're working with, and that's part of the compliance standard that would be developed over time once enforcement of these regulations plays out.
Commissioner Roy?
Could bad faith also constitute inactivity to engage in any type of negotiation?
Inactivity.
She said an activity would be, could you restate that in it?
AC Lopez, please.
Thank you.
So actions that are taken to circumvent the law or to, ending the contract for the sole purpose of avoiding having to honor the contract or honor the obligations under the new law. You asked about inactivity.
Or inaction. I may I rephrase that. Is inaction considered an action?
Inaction.
Well, the action here that we're focused on is the discontinuation, right?
Yeah. Mm-hmm.
So the discontinuation of the contractual relationship.
Hold on,
That's the
Enforcement Counsel
action.
Lopez. Commissioner Roy, what do you mean when you say inactivity?
So inaction, so my primary concern in meeting with so many licensees is that there will be inaction to come to the negotiation table, to sit down at the table to renegotiate or negotiate. And does bad faith encompass, in other words, good faith would cover that, right? Good faith, but would bad faith, I guess it would if we're determining what it is. Good faith and fair dealing would be covered for someone from inaction to come to the table to negotiate because they don't want to comply with the new law.
I don't know if I'm clear on this because we're talking about discontinuance. The action here is discontinuance. I don't know if I'm completely understanding. Director Poppin.
If there is,
Sorry, hold on. Commissioner Roy.
if there is discontinuance, it must demonstrate that there was good faith and fair dealing. If there is in the original language proposed.
Director Poppin.
Thank you, Madam Chair. Commissioner Roy, what I think I'm hearing is, first of all, discontinuance could be the dissolution or the voiding of a contract based on a term that's in the contract. So the contract ends, the HCA ends. There could also be an HCA that's good for 2 years and the municipality through inaction chooses not to renew it. And I think that's one of the situations, the inaction, where the relationship dissolves. That inaction, I think if you're looking at it, could be in good faith, it could be in bad faith, it could be neutral. They are just choosing not to renew it. If they're doing it and there's evidence that says we're choosing not to do this, to renew this contract, because we don't want to comply with the law, that could be bad faith. But I don't think de facto on its own, every situation of dissolving a relationship or choosing not to renew it is always going to be the case of bad faith.
I agree. It would neutral be mutual.
No, not necessarily.
Okay.
No, just because of the adversarial nature of the contract where maybe a licensee wants the municipality to renew it and the municipality has maybe valid reasons or neutral reasons not to renew it, that's the freedom to contract there. That's that line in the sand where the HCA working group, as you know, was trying to navigate very carefully is that freedom to contract, because otherwise there could be an implied pressure that there is no freedom to contract. You must renew this. Otherwise, we're going to find you in bad faith.
So back to this proposed language, this new standalone 5. Okay, I'll go back up so I'll read it again. A host community shall notify a marijuana establishment if it no longer intends to continue as a host community for a marijuana establishment. A host community shall not discontinue relations with a marijuana establishment in bad faith. On receipt of a notice of discontinuance from a host community, the marijuana establishment shall notify the commission. A marijuana establishment may submit a request for equitable relief to the commission. Do we have consensus on this language? Attorney Baker?
Can I just offer a friendly amendment if there is consensus to this? That doesn't change anything, but just the wording on the last sentence. So
Go ahead.
I would say, could we potentially change the last sentence to read something like, a marijuana establishment may submit a request for equitable relief to the commission upon receipt of a notice of discontinuance as described in 935 CMR 500-186, which would just reference the next section. I think that would be helpful in getting to your intent.
I agree. Now,
I will.
wait, hold on, because Commissioner Roy, I want to just check in to see where you are.
Okay. I'll be in consensus if it will be considered in all of the evidence brought forth. An unwillingness to negotiate will be part of the consideration process under bad faith.
Enforcement Counsel Lopez?
Commissioner Roy, we certainly, whenever we as a department are developing a compliance standard, we certainly look to the meeting minutes to make sure that we have an understanding of the policy intent of the drafters. I cannot commit today to what that compliance standard will be, but what I can say is that we will always look to the public meeting record to understand what the policy objectives were and what the considerations were behind the passage of those public policies.
Thank you.
Commissioner Roy, do we have consensus?
Begrudgingly.
Okay, with that said, I think this is a good time for a break. We'll do a 10-minute break. No, honesty is good. This is important. You're right. You've been saying that this is important, so let's do it.
I tried.
Okay, it's 3:06. I'll add a minute. Let's recess until 3:17. We'll do 10 minutes. Okay, Commissioner Stebbins, do I have a motion to recess until 3:17?
Yes, so moved.
Commissioner Roy, do I have a second? So we'll call the roll. Commissioner Camargo? Commissioner Roy?
Aye.
Commissioner Stebbins?
Aye.
The chair votes aye. We are at recess until 3:17. Run to the meeting. Thank you. Okay, so the commission is back from recess. Before we jump back into things, I think this is a good time to sort of manage expectations for the day, sort of get a feel about the next steps, because it is now 3:22. My goal was to at least get through the HCA regulations today. And I thought possibly we're going to municipal equity, at least begin them, but if we can at least get through the HCA's, that I think we would be on good footing. But being mindful of the time, I'm going to pose this question again. It was posed yesterday. I'm going to ask my fellow commissioners if they would mind if we went to the sections with edits as opposed to reading every section. So this is a temperature check. This is all of our, we share this responsibility together. So I just want to see if there is consensus for that. If not, then we can just proceed the way that we have been. But I wanted to put that out on the table, just understanding that we have some time constraints. Commissioner Roy.
Would you feel it's satisfactory progress if we're almost done with the HCA document itself, right? And then we pivot to community impact fees, like we're close. I feel like right?
Well, technically, community impact fees are part of the HCA.
No, I mean, but the document, not the fees, like the HCA itself. So
Yes.
we're almost
Yes.
there, right?
Yes. Mhm.
Okay. And then how many pages on community impact fees? There's a lot.
There's a lot.
There's a lot.
Almost 3.
I think my expectations were to go until 5, but that all depends. So could we stay longer? Are you, let me look at my Commissioner Stebbins, Commissioner Roy. Can we just get through HCA's today? I'll also look at the attorneys in the room, Mercedes, past 5. Okay, but back to my original question though. So with that in mind, are you saying to continue just going through everything, or would you?
I think what would be helpful, if I may, what would be helpful is maybe, thank you, is figuring out what, at least I have a few items on what's left of HDAs, and then obviously the big ticket item on community impact fees. So that's for myself. So if you want to go through sections and just say who has major edits here and there, I think that's helpful. I don't see the need to read every single line, but I also know Commissioner Roy's argument for reading every single line. So either way works for me.
So I think there was a huge value what we did because we picked up things that weren't highlighted and we tweaked them. So selfishly speaking, my major edits have been done. So, but I don't want to have anybody else miss an opportunity. So I guess it's, I don't know if you take a vote or just check in. I'm agnostic on it.
Commissioner Stebbins?
I'm happy to kind of keep going through it, but I've already looked ahead to kind of where parts and pieces, questions I might have are. So.
Attorney Baker, are you able to sort of go through a section, section by section, as opposed to going line by line?
Sure.
Does that make sense to you? Do you understand what I'm?
Yeah.
Okay.
So we ended off bringing a new section, subsection 5 there,
Yes.
which in turn then changed section 6 underneath. So to keep going, there's section 6 and subsection 6 and subsection 7 there.
Attorney Baker, I don't mean to interrupt. Actually, I do mean to interrupt, but apologies, because I know you were getting ready to get right into things. I see Enforcement Counsel Lopez. I see your hand, so I wanted to just recognize you and hear any comments you have.
Thank you, Madam Chair. This is a question with the language that was just approved. It does, I think the legal site proposed in the amendment needs to be checked. It says upon receipt of a notice of discontinuance as described in 935 CMR 500.186. I think that's meaning to refer to a subsection, but I would defer to Attorney Baker to clarify the legal site that he was intending to include there.
Attorney Baker?
Yes, sorry, that should read D instead of 6. Because it's just underneath where we were.
Yeah.
And if there's consensus, I can change it to the correct side.
I don't know if
So
I'm
it's meant
following.
to,
Hold on. So the way that this language is the new 5, correct? And the line that's being referenced is D below, so I don't know if I'm completely following. Hold on. I think that citation doesn't work with just a simple D, just because it's outside of 5.
It's,
I thought it was okay.
no, I think it's 3D.
But then
No.
there's the language that you guys, may I?
Commissioner Camargo?
The language that you all, Frankenstein, is now the new D. It's kind of a Frankenstein.
But it's not, the new language is
It's
5.
new 5.
Okay, well, okay, then it's not D, but it's 5.
It's the new 5.
Sorry.
Sure, sorry about that.
I thought I was right. I was wrong.
The language that we all just went through that includes the discontinued relations, marijuana establishment, bad faith, everything else is, I think we all agreed is the new number 5.
Yes.
But listening to Commissioner Baker, wow, you're getting a promotion. Attorney Baker's addition to reflect the right citation is right, because we're referring to the new number 6, which starts with if a host community discontinues relations with the ME may submit a request for equitable relief to the commission.
That is correct, but I know you can see the way that that's drafted with the parentheses is not correct.
So, Madam Chairman.
Sure, Attorney Baker.
So what I'm trying to cite is if you go slightly down before 6, 7, and then you get to D right now where I'm reading, I actually want to cite that there because it's, oh, I'm sorry. Yes, I'm sorry. Please ignore my last comment.
Oh, it's okay. So Attorney Baker, what should it read?
Madam Chair, if I may ask a
Yes,
question.
Enforcement Counsel Lopez.
Attorney Baker, can you read which section because I think there's some confusion on which number is which because we've made some changes to the numbers. Can you just read the provision that you want to refer to, or at least the first sentence of the provision that you're meaning to link this to?
So I think I was correct initially. I think it was 6. If a host community discontinues relations with a marijuana establishment, then a marijuana establishment may submit a request for equitable relief to the commission.
Okay, so then that would be 501-83C6,
Six.
correct?
Right.
Yep,
Yes.
that is correct.
Okay.
Thank you, Enforcement Counsel. Yes.
Perfect,
Frankenstein.
thank you.
Right. Are we, Enforcement Counsel, okay, that's addressed. Attorney Baker, please. We'll take your time because I think you're right. Are you right?
Sure. Okay, so the next section that I have would be complaints alleging non-compliance. Is that where you are, Madam Chair?
That is right. So are there any comments in this section? Commissioner Camargo.
Madam Chair, if I may.
Oh, Commissioner Camargo first and then Enforcement Counsel Lopez.
Apologies, Madam Chair. I didn't mean to interrupt, so please feel free to take in Commissioner Camargo, and I can wait.
I can see her through my peripheral. She's nodding no. So she was
Okay.
asking for you to go.
So I was just going to mention, in respect to Commissioner Camargo had mentioned wanting to make sure that we speak to the winding down of operations in terms of equitable relief. I was going to suggest that we add a new section to the equitable relief provision. So that's 183C6, and then within 6, there's another subsection C which spells out the different groups of equitable relief. It starts off with the equitable remedies being 1, an extension of a license expiration date without incurring additional prorated fees. 2, waiver of a change of location fee. And then what we can do is add a new 3 to read procedures for winding down an ME's operations at the licensed premises, followed by a new subsection 4 that finishes with other equitable relief as determined by the commission.
Commissioner Camargo, does
Yeah.
that address your concerns?
Yes, thank you. I'll take this from Kyle. You're my spirit animal right now. That's why I let you go first, because I figured that you were keeping track of the section. So thank you so much for the detail and the thoroughness right now. Yes, I definitely agree. Thank you for that. And I think the other thing that I wanted to just sort of offer, and I'm not 100% sure, but I want to offer it is a few other equitable remedies for the section C, which is 6C. And I just wanted to read them. So we know what one, and again, this is just, we can figure out if we need more. I think, Kyle, you had talked about this earlier.
Commissioner Camargo, can you drop it into the chat also so we can?
Yeah, I can cut and paste it
Okay.
from a document, yeah. But I think when we were talking earlier, Kyle, around the May 1st date and all that, which you said, let's wait till we kind of get to some of these sections to see if there was more equitable options, right? So I just want to kind of bring us back to that thought. But let me just say these out loud and I could drop it in there. 1, obviously, is extension of license expiration date. 2, waiver of a change of location fee. 3, waiver of other commission fees. I don't think this one's on here. Let me see, 3. Okay, so these are just suggestions, and this is from the public. So I'm going to offer some of these. So their recommendation here is waiver of other commission fees. This one may be hard, but I'm going to read it anyways. Refund of previous commission fees. Transfer of license and/or real property or access to an auction thereof limited to equity applicants. Technical assistance and/or grants to assist with cost of services related to change of location. And then the last one is other equitable relief as determined by the commission. So again, these are examples that folks have offered to us if we wanted to think about other. So I'll drop those really quickly into the chat. Again, they're just extra. And I want to tie it to the May 1st date because I know that we're not there yet. Not tie it, but I think we started having the conversation around that. So let me just add.
Commissioner Camargo, before you drop it into the chat,
Yep.
I'm asking for some clarity on
Yep.
what you are offering.
Asking? Mm-hmm.
So are you offering this language in agreement with it, or are you posting it in the chat so we can
Post.
review it?
Thank you. Posting so that you can review it and that we can think about, are there other equitable reliefs that we should add? So maybe it's not these, maybe it's other things, but for example, here, technical assistance and/or grants to assist with cost of services related to change of location. I don't know who would provide that. Transfer of license and/or real property or access to auction thereof limited to equity applicants. Waiver of other commission fees. And then refund of previous commission fees. Again, just examples that folks submitted. So I'm just putting it out there. I'm not, I wanted to just put it out there as a starting point if we needed to add other ones.
Commissioner Roy?
Are these financially feasible for the commission?
Probably.
In light of our
Director
budget
Potvin?
situation?
That's a good point. Director Potvin?
Thank you, Madam Chair. Thank you, Commissioner Camargo, for stating those. That is definitely, some of those options are definitely out of the box thinking, which I applaud.
Sure.
There are a couple of reactions to that. As far as reimbursements or refunding fees that have been paid in the past, that obviously would have an impact on the commission's ability to comply with the fact that it needs to remain revenue neutral. So those funds that we collect have to at least encompass our budget. So that could kind of have a historical back in time, depending on how that policy were to work out, it probably would be a good question to also ask the CFAO, especially from a state budgeting reason. There might be some restrictions around that. As far as any granting of money, as we all know, we are allotted money from the legislature. We don't have the ability to do certain things. I, again, don't want to touch too much into that. That's outside of an investigation and enforcement thing, but I would defer to the CFAO again on that. I'm just kind of reacting with some thoughts.
Yeah.
One of the things that I think is a good idea, that's maybe possible because we do have in here already is a waiver of a change of location fee. The commission does right now have policies around waivers of fees. Maybe as far as a change of ownership, which is essentially that transfer of a license, maybe there's some waiver of a transfer of license that if they are not going to be able to operate and they want to transfer the license to another licensee, to or somebody who would become the licensee because they do have an HCA, it allows them to offset their loss and also kind of recoup some of their investment. But as the other part I think I heard with that is real property. The commission doesn't have jurisdiction over real property. But the waiver of a change of ownership, which is essentially that transfer of license, could be a feasible in the sense that the working group has already talked about a waiver of a change of location fee. But just with that said, just the kind of inherent reality to that is the more waiving of fees, the less of non-tax revenue comes into the commission.
Commissioner Roy?
And I agree with your assessment because our money doesn't come to the commission, it goes to the general fund or the marijuana regulation fund. So it's not like we have a checkbook that we can issue grants or, but what about a reduction in some fees? A reduction in a renewal fee or annual renewal fees are the biggest fee.
So, Madam Chair. So I think the working group, from my recollection,
Right.
and I know it's been a long day, but it's the equitable relief options here are tailored to the situation in which they don't have an HCA. It's not so much that they can't pay their renewal fee, it's that they don't have an HCA or they don't have a compliant HCA. So the reduction of a renewal fee doesn't necessarily fix that problem. Though these items that are here allow for the equitable relief in the situation where there is not a compliant HCA or the municipality has not renewed an HCA. So it's given an equitable relief towards that one particular situation in this case.
If I may.
Commissioner Camargo?
Yes. And, as the sitting treasurer for the commission, trust me, I know that our money is tight right now. So, but again, I wanted to put it out there because it was inserted in public comment. Under number 3, where we have waiver, wait, let me see in our language, sorry.
Is it number 2, waiver of a change of location fee?
No, extension of license, waiver of change of location, other equitable relief. So what is considered, or what would we consider other equitable relief? How would we define that, or how will the public understand what that is? Is that going to go in guidance later? Because I think that's helpful, but what is it as determined by the commission? What were we thinking, or what was the thought behind that, or?
Enforcement Counsel Lopez?
Thank you, Madam Chair. Commissioner Camargo, the thought behind that is to leave some room, some opening for the commission to still be able to entertain what equitable relief should look like based on the particular circumstances presented by a scenario in which a host community has discontinued operations, or if both parties agree to end operations.
Commissioner Camargo?
Just a follow-up, so just sort of example here to walk us through it. So if I'm the operator and I'm, we're at this point and you all review it and say, okay, another equitable relief here that we can do is waive the change of ownership. I think, Kyle, to your point right now, that's really upon us to choose, right? Like we're giving ourselves, how this is written, we're giving ourselves room and space to sort of pick and choose if possible.
That's correct.
Right, okay. Okay.
So Commissioner Camargo, from the language that you dropped, are you asking us to adopt any of it?
I don't think some of them are realistic for where we're at right now.
I guess let me rephrase that. What is the request?
The request was to have the conversation.
Okay.
So that we can kind of think through what other equitable relief forms could be, if we needed to add anything else. These were examples. I think the only one that I'm sort of looking at is waiver of other commission fees. But I feel like that one is covered in other equitable relief as determined by the commission while I'm looking at now. And then technical assistance and or grants to assist with cost of services related to change of location. Again, that could be, I think, difficult. Where would that come from? So I think I'm good. I think how you explained it, Attorney Lopez and Kyle as well, under the other, to me, it's satisfactory.
Commissioner Roy, Commissioner Stebbins, do you have any thoughts on, okay, Commissioner Stebbins?
Thank you, and appreciate Commissioner Camargo dropping in those thoughts based on, the great comments that we received. I think your assessment is correct. I think there are some that we could consider doing. There are others that on the surface of it, I'm not sure we could do. I also I like the last portion, which is other equitable relief is determined by the commission.
Mm-hmm.
I think that's important because, again, I'm hoping that this is going to be a rare circumstance, but in that circumstance, I think we're putting forth a message of we're going to do our best based on that license, that marijuana establishment's individual case and what they may need from us, depending on their own situation, that at least we're sending the message we want to be that cooperative, that innovative, that out-of-the-box thinking to, again, help any license, any marijuana establishment or even an MTC, I guess we're thinking about, seek equitable remedies. So I hear you. I think it's consistent with the language that we already have in there.
Enforcement Counsel Lopez, would you mind reading 5C with your edits?
Okay, absolutely. So it would be new subsection 6, because remember our new subsection 5 is the discontinuation piece.
That's right. Thank
so
you.
It'd be 50183C6. Part C would say the commission may exercise its discretion whether to grant one or more of the following equitable remedies to a marijuana establishment. 1, extension of a license expiration date without incurring additional prorated fees. 2, waiver of a change of location fee. 3, institution of procedures for winding down an ME's operations at the licensed premises. 4, other equitable relief as determined by the commission.
Do we have consensus amongst the commissioners for that language? Commissioner Roy? Yep. All right, we have consensus. Attorney Baker, we can proceed to the next section.
Thank you, Madam Chair. So after subsection 6 there, it would be the new 7, which would read failure to submit a compliant HCA or compliant HCA waiver may constitute grounds for denial of a renewal application. Okay, and then the next one is 7. Any actions subsequently taken to deny a marijuana establishment's renewal application due to failure to produce a compliant HCA or compliant HCA waiver shall afford a marijuana establishment a right to a hearing pursuant to 935 CMR 500-500. If a marijuana establishment elects a hearing pursuant to 935 CMR 500-500, the administrative proceeding must be conducted pursuant to 801 CMR 1.01. formal rules of adjudicatory practice and procedure. B, a host community may seek intervention as a party to the hearing. The next section is subsection D.
Madam Chair,
Yes,
just make
Commissioner
sure we
Stebbins.
renumbered those last two correctly. So failure to submit a compliant HCA is now 7. Any action subsequently is 8.
All right.
Thank you, Commissioner Stebbins.
Nice catch.
Attorney Baker?
All right, so D is complaints alleging non-compliance with 935 CMR 500-180. 1, consistent with its power to enforce HCAs, the commission may, at its discretion, investigate any complaint alleging non-compliance with the requirements in the section and take enforcement action as provided in 930 CMR 500-500.
Chair.
Commissioner Roy?
Some of the feedback, we got some feedback around number 1, where it says consistent with its power to enforce HCAs, the commission may at its discretion investigate any complaint. Folks were arguing all complaints.
Can you elaborate on the reasoning why?
Because they feel like all complaints should be taken seriously by the commission.
I wonder what, if that, for our purposes, does it change? Maybe this is a question for, okay, Enforcement Counsel Lopez.
Thank you, Madam Chair. I will note that that language may at its discretion investigate any complaint. That is consistent with how our regs are currently stated for 500-300. So our complaints process does say that, that any interested person can submit a complaint regarding a violation of our regulations. Subsection 2 says that the commission may, at its discretion, investigate or decline to investigate any complaint or refer a complaint to another law enforcement or regulatory authority. So this language is consistent with the discretion that we currently do have.
Commissioner Roy?
Thank you for that. I just, in previous public meetings, even the executive director has said, we take all complaints. We evaluate all complaints at the commission. So I just want to reconcile the two from the public statement to the regs.
Enforcement Counsel Lopez.
Thank you, Madam Chair. And thank you, Commissioner Roy. That's a very important point, and we certainly want the public to understand that the Commission's Investigations and Enforcement Department takes its responsibilities very seriously when it comes to effectively monitoring compliance of those who are subject to our regulations. I will say that it's very important that we retain this discretion here because we receive many complaints and we look into those complaints, but not all of them need to be investigated. Not all of them are within our jurisdiction or present, facts that indicate a violation of our laws. So we will certainly conduct an initial inquiry to see whether this is something that should properly be investigated. But our team may conduct an inquiry and find that the matter is not does not actually speak to a violation of our regulations, or that it's actually a matter that falls within the jurisdiction of another agency. And so we do follow up on investigations that implicate our jurisdiction and that implicate an actual violation of the laws. But there is a difference between an investigation and an inquiry. And if we require every complaint to be investigated, that will take valuable discretion away from our investigations team and the expertise of our Director of Investigations in terms of assessing whether or not a complaint has been initially substantiated enough to even rise to the level of an investigation.
Commissioner Roy, good? Okay. All right,
Thank
Attorney
you.
Baker, please continue.
All right, thank you, Madam Chair. I'm on D2. Any interested person may file a complaint with the commission alleging non-compliance with the HCA requirement under 935 CMR 500-180. Nothing in this subdivision shall be construed to prevent a marijuana establishment or a host community from bringing a private breach of contract action in a court of competent jurisdiction regarding an alleged breach of specific promises mutually agreed to in the parties' HCA.
I'll stop you there, Attorney Baker, because we did receive comment about an interested person. And maybe you can answer this question for me. When we say an interested person or Enforcement Counsel Lopez, who are we speaking to? Can it be anyone who has the ability to file a complaint? Attorney Lopez.
Thank you, Madam Chair. The choice of an interested person was meant to invite anyone who has information or knowledge of a regulatory violation to be able to submit a complaint rather than restricting complainants to licensees, for example. There have been instances where the Investigations and Enforcement Department has received a complaint from someone who's not a licensee, who's not a registered qualifying patient, who's not a certifying healthcare provider, that is alleging that there is a violation of commission laws by a licensee or a certifying healthcare provider. So we want to make sure that, you know, anyone who has knowledge or who's claiming to have knowledge of a violation has the ability to bring that knowledge to the attention of the Enforcement Department.
Thank you. Okay, I don't see any other questions. Continue, please.
All right, so D3 reads, if the commission substantiates an allegation of non-compliance with an HCA regulatory requirements, then the commission may take administrative or enforcement action against a licensee or a host community, including sending a notice of deficiency, requesting additional information, or otherwise taking action as provided under 935 CMR 500.
Commissioner Roy?
So feedback from the letter we received today, certainty regarding the process for municipal fines under section, now this is 500-360, would be appreciated, including how a municipality must appropriate or allocate any such fine, as well as a process for curing and appealing alleged infractions.
Drop that into the chat.
Madam Chair.
Yes, Director Poppin.
Thank you for that. Commissioner Roy, you're referring to the letter that you said you received today, and that's going into the section 500-360?
360, but I just thought it was tangentially related.
I think there's some work in 360, if I'm not mistaken. There's some modifications in 360. Would it be appropriate to talk about it in context at that point?
I think it will help us all to talk about it at that point, just because I don't want us to conflate things as we're going. It's a lot to go through. So are you okay with that, Commissioner Roy?
Yes, there's minutes being taken today, correct? Can we put this letter into the minutes? Okay, thank you. Yes, thank you.
Okay, where were we? Attorney Baker, please continue.
We're on subsection D4. Failure by a host community to correct the non-compliant conduct may result in one or more of the following. A, issuance of sanctions pursuant to 935 CMR 500-360. B, loss of host community's good compliance standing for the purposes of 935 CMR 500-182E. C, publication of a host community's lack of good compliance standing in a form and manner determined by the commission. Or D, abstaining from consideration of any new license applications affiliated with the host community until the host community's good compliance standing is restored.
Let's pause there. Commissioner Roy, your comment, can you, well, not your comment, but from the MMA, do you mind repeating it?
Sure, I dropped it into the chat, but this is the time where we need to revisit whether we want a definition of good compliance standing, and I think we need to, and we kind of hit pause, put a pin in, do we want to, in the definition section of good, this is part of the letter as well. So I can put that as well, but we put a pin in whether or not we wanted to define good compliance standing.
You know, I didn't know we put a pin on that. I thought we moved past it
Oh, I
without
put
a
it in my head.
definition.
There was a pin up here.
I think we did this time.
We did? And
Yes.
we agreed we're not doing it?
Yes.
Oh, geez, all right, okay. So would you like me to read?
Please.
Okay. And this is the concern that I just had mentioned, the most recent one? Okay. Certainty regarding the process for municipal fines under section 500-360 would be appreciated, including how a municipality must appropriate or allocate any such fine, as well as a process for curing or appealing alleged infractions.
Enforcement Counsel Lopez.
Thank you, Madam Chair. With respect to the first part, how a municipality must appropriate or allocate any such fine, I'm not sure that the commission is the proper authority to advise the municipality on how they should allocate or appropriate a fine. So I don't have an answer for that. But with respect to the process for curing or appealing alleged infractions, I will say that as stated in this subsection on complaints alleging non-compliance, it does provide the host community with an opportunity to cure the non-compliant conduct because a notice of deficiency will be sent to the host community. They will be given an opportunity to submit a plan of correction as is the standard customary process with licensees. So that will be their opportunity to cure the alleged infraction. And with respect to fines, if sanctions are issued, it will be done pursuant to 500-360, which means it will be appealable. There will be an administrative hearing process, and they will have an opportunity to appeal that decision.
Thank you, Enforcement Counsel Lopez. Commissioner Roy, do you have any other questions? Commissioner Stebbins?
Sure, thank you, Chair. I would propose removing item C, the publication of a host community lack of good compliance standing in a form and manner determined by the commission. I suggest that for two reasons. One, we have a lot of work on our plate, and now we're going to spend time coming up with a lack of good compliance report or form. I also look at A, B, and D. Those are some measures which I think have some more critical teeth, again, for us to exact if we have to on a community that may be less than fair in their dealings. I don't want to see a commission kind of getting into you're on our bad list this week. I'm really uncomfortable with a governmental entity doing that to other governmental entities. And again, I think those other three pieces are sufficient regulatory teeth if and when we need to use them.
Commissioner Roy?
Correct me if I'm wrong. I think our thinking was that for folks that are looking to plant a flag in a municipality, having this information is helpful, that there are communities that are in good standing, that are complying with the new law. And so when they're looking at the map of yes towns, this helps them identify the ones that are good partners, if you will, versus, so that was our reasoning behind that.
That's correct.
Right.
Mm-hmm. That's it, yes. Sure, Commissioner Camargo?
This is like, I think what folks are calling sort of the public shame list. So I get the concept in terms, listen, it's good to know who's out there and who are the good players and what municipalities are supportive and what municipalities are not acting in good standing or in good faith. Commissioner Stebbins, I kind of agree with you, but I do know also what we're trying to do, and I guess I was trying to figure out the utility of it, but also operationally. It's like, how are we going to define, who's, lack of good compliance standing? Like, what does that mean? Do we have to define that? And then internally, who decides that? And what what other situations does that cause for us in the future? So
who determines good compliance?
Yeah, the publication of a host community lack of good compliance standing in a form and manner determined by the commission. Oh, I guess it's us, but I'm thinking even past the definition, it's like internally, right? So then who decides, like, are we going to bring a naughty list to the commission and we vote on it, every month? Like, how does that operationalize? I hear the concept, and it's good for, folks that are trying to get into the industry to say, hey, well, maybe this city and town are not as friendly as we thought to cannabis, but I just don't know about this one. And I think Commissioner Stebbins, I out of respect for, municipality, state government and everything else, I hear what you're saying. I'm just thinking of the utility. and how and operationally?
So I am, and you can see, I'm going through our draft regs in front of us because I believe you had to cross a certain threshold in order to get to this point. So it's not something that.
You gotta earn your way on.
Yes.
May I ask a follow-up question?
Commissioner Camargo, yes.
How did you all, and Kyle, I'm looking at you, and I know I'm assuming you're here with licensing and compliance at the same time, but how would we decide, like, what's the operational piece behind that? Like, how would we decide that? Like, how? And when, and,
Director Poppin.
is that fair?
Can you clarify again?
So what I'm understanding here is that we would create a list of municipalities. Oh, I lost my spot. Publication of a host community, lack of good compliance standing in a form and manner determined by the commission. What does that look like? Who decides? What does that look like? Who's the judge and jury?
Madam Chair, if I may.
Director Poppin, please.
Again, I think this question it's kind of two parts. So one, the delegation, whether this is going to be something that the commission is going to want to retain for you as a body to decide based on evidence from number one, number two, number three. Obviously, there's elements of this that would be delegated to investigations enforcement staff to investigate or at least follow up on it. So one is the element of delegation and who ultimately does make that kind of decision at the end. Two is establishing a process. So these policies will need processes that are built and implemented afterwards once the final rules are promulgated. So there's two pieces, and the commission has a long-standing history of taking the parameters of these rules during previous promulgations and building out those processes based on the intent and the language that you actually bring out. So when just envisioning this right now as a possibility and not something that I would commit to on behalf of investigations and enforcement or the commission as a whole, is more likely than not, it would be a complaint that would come in. It would be reviewed in a diligent way by our investigations and enforcement team. Then if it rises to a level, there would be notifications that would probably be sent back and forth from some part of our investigations and enforcement team with the municipality saying, hey, here's the issue. Can you fix it? Please fix it. And then getting those responses back. And then if it rises to a level where there's just non-compliance and no intent to fix that issue, it would rise possibly to our enforcement council staff that would seek an enforcement action. So that's a possibility where then maybe there's a recommendation to the commission, or if it's delegated to the executive director or something like that. So there's a couple of different ways this can work, but it's basically essentially two questions. Building out that process in a very thoughtful manner, and two, the delegation. Is it going to be something you want to retain, or is it something that you're going to want to delegate down for maybe administrative efficiency? Does that answer your question?
Yes.
So where have you landed? What is are you of the same position that you would like it removed? What is your?
I mean, I want to reach out across the line over there and ask Commissioner Stebbins, because you also brought it up, so.
Down the table, not across the line.
Across the table.
Like leaning back so they can communicate.
Commissioner Stebbins.
And again, appreciate the discussion. Great to hear that, it sounded like there was an intention for this to be a tool for a potential license applicant to know where they can play. I still would like to see it stricken, but before I suggest it being stricken, I think there are other opportunities for us to achieve the same goal. There might be something that we can put on the commission's zoning tracker in terms of this community currently as a whole done, having any new licenses considered or something like that. But I'll make the motion. We'll see where we are, but.
Before you make a motion, Commissioner Stebbins, I want to make sure we are understanding what you're suggesting. You're suggesting that we make this information available to the public when there is a municipality that is not in compliance or has a record of non-compliance. I want to, because that sounds essentially like what our intent was, but we might actually be aligned, but it might be phrased in a way that you're.
Again, hearing the conversation, I have a better sense of why this was included. And more importantly, what intentional goal you were trying to reach, which is somebody we don't know is a licensed applicant looking around to see what community they may want to go into. And they have our zoning tracker, which is a great tool, which we benefit from our municipalities helping us keep that updated. But thinking that might be a place where we can just put an asterisk in.
That's exactly what our thinking was in the working group.
Community might not be able to offer new licenses or negotiate new HCA's. I guess I'm trying to move away from this.
See, that is what, but I should clarify, that is what we were thinking. I think the word publication seems to be where there's we weren't saying like a newsletter goes out or we post posters everywhere. We're saying making that information available to the public. Exactly. Go ahead, Commissioner Roy.
So in the zoning, right, so we list all the towns, right? So maybe look at it from the reverse, highlight the ones that are in compliance. So we bold asterisk the ones in compliance, and the ones without anything, to your point, like if you don't want them singled out, we could look at from the reverse. We highlight the ones that are and don't asterisk the ones that aren't. That's just another way to look at it, but.
And this leaves room for that. It's that as determined by the commission is, okay, well, how are we making this information available?
Let's say Abington, right? They're in compliance. Well, Abington would be bold or asterisk, right? And we go down the line. We highlight, recognize the good, and then folks would know. Does that alleviate a little bit of your concern? So everybody's on the list. We're just highlighting the ones that comply.
Right. And again, I appreciate that clarification. And again, I don't want to see this. Again, my initial read is we're going to publish some type of big bad naughty list, big bad operator list or Santa's list. I saw A, B, and D having, again, some more teeth. And the teeth are what I want to ingrain in regulations and not necessarily what we might view or should be viewed as kind of an administrative step to just help people understand the standing of a municipality.
Commissioner Roy.
So a big component, as my group knows, is bringing sunshine to this process. And part of having the list of all the towns and maybe not highlighting the non-compliant, but highlighting the compliant is bringing sunshine around that. I'd want to even take it a step further. The ones that don't charge CIFs anymore, I'd like to have that denoted. If we're contacted by the commission is contacted by a municipality and says, we are officially notifying the commission, we no longer will charge community impact fees. I think that should be recognized in the list too. So people that are looking around. So this is just around like sunshine and open data.
But it's also around notifying communities of our ability and that we would make this available to the public.
Okay. Can I offer a suggestion?
Sure, Commissioner Stebbins.
A little bit of new language.
Okay.
Madam Chair, I move that we amend letter C to be worded as identification of a host community lack of good compliance standing in a form and manner determined by the commission. And again, I appreciate it's probably just semantics, but it's moving away from that publication.
Can you repeat it one more time?
Sure. identification of a host community, lack of good compliance standing in a form and manner determined by the commission. So we can acknowledge it anywhere in our municipal zoning tracker. Again, I think the language still leaves it up to us. I'm just trying to, I hear what you're saying. I've just been trying to move away from some expectation of publication.
Commissioner Stebbins, are you offering a motion to be voted on, or are you asking for us to sort of discuss?
I offer that as a motion. With that, just one simple word change.
Do I hear a second to that motion? Second. Okay. So we can go into a vote. Hold on one second. Commissioner Camargo?
Thank you, Madam Chair. Can we, I think we've discussed it, but we probably did it backwards. But can I just say a few things just because before I do vote on this? So I have faith in our team that we will figure out a process. And the delegation of this C will be interesting down the line in the future in terms of, is it a, are the commissioners, are the commissioners taking part in this? Again, it all depends on the process that we develop internally. Do I want to publicly shame folks that are not doing the right work? Absolutely, right? I mean, everybody wants to see the bad players come to light. But I think that this is what I'm hearing Commissioner Roy and Commissioner Concepcion sort of talk about is the positive spin on this. It's so that licensees and other folks sort of see and can get to know what communities are in compliance. What I'm concerned about is not knowing the process of, obviously there's so many things here that has to be developed, but this one I just think in the future it's going to be interesting. I think about possible lawsuits, possible things. However, I think that identifying, like I think Kyle, you said something like, let's just use Brookline for an example. Let's say Brookline hit their cap. There could be a identification that Brookline has been in compliance and they've hit their cap. So if I'm looking on this data portal, I may say, okay, oh, they're great, they're in compliance and they hit their cap. I'm not gonna go bother with going to Brookline. So I heard you guys say both things where it's like, if they're in compliance, but also so people know where the cities and towns are at. So I'm happy to amend the language. I just wanna caution us, for the future in terms of this one, because it could get very muddy, but I understand the reasoning. I think the process is really, and a delegation of this one will be interesting. And also, when we put things on here, I know that this won't happen right away. This could take a year to 2 years to develop a process and to figure out what does it mean and all that stuff. So I know this won't happen overnight. But that's my point, and I will say that, the amended language, I get it. Just making sure that we know. I'm always thinking what goes in these regs stays in these regs until either we open them up again or new commissioners come to play in the future. So, but I get it and I respect it, and I thank you.
One additional note that I will say is this cannot go into effect until we have host community agreements to review, and there are enough to make a designation or determination about a host community. Yeah. So it just by the way that it's laid out here, it would take some time. So Commissioner Stebbins has a motion on the floor. Commissioner Stebbins, can you restate your motion for the record?
Sure. Madam Chair, I move that the commission amend letter C, amend letter C to include the following language: identification of a host community, lack of good compliance standing in a form and manner determined by the commission.
Commissioner Camargo, I will do a call of the roll. Commissioner Camargo? Aye. Commissioner Roy?
Aye.
Commissioner Stebbins?
Aye.
The chair votes aye. So we can continue with that language. We're 4 agreed, 0 opposed. We have a unanimous vote. The motion passes. Okay. Attorney Baker.
That brings us to the community impact fee section. So section 4. Oh,
If I may.
Madam Chair.
Commissioner Camargo.
I wanted to just throw out a thought, and Madam Chair, I know you're going to ask me what's the purpose of it, so I'm going to say that up front. It's just a example of a possible E for this section.
Let's read through first.
Are
you going straight to E, or are you?
No. For the section that we were already in right now. So C, D.
Okay. Okay, go ahead.
Because, we just voted on the sentence, right? Again, this is just I wrote it in my notes, so I kind of want to say it out loud, but another one, let me just read here. So failure by a host community to correct the non-compliance conduct may result in one or more of the following. Example E, proposed, loss of host community ability to collect any impact fees. I wanted to just add that as a...
We should go into the community impact fee section.
Okay.
I think this is already accounted for.
Okay.
Attorney Baker.
Thank you, Madam Chair. Mercedes is drawing my attention to an area which we need to revisit to get consensus.
Okay.
Is this accurate? So I believe it's 4D, or let me see up here. C4D.
C.
What page are we on?
72. Oh, so this is the language, the option to sign the model HCA in the interim?
Yeah.
Okay, so do you mind stating for the record the language that was proposed?
Agreed. Thank you, Madam Chair. It's execute and sign an interim HCA that conforms with the model HCA to be relied on in the interim until parties come to an agreement.
Thank you. I see head nodding. There's consensus. We have consensus.
Excellent. And again, that brings us to our next section, which is the.
Hold on.
I just want to thank Council Lopez, that was her and her verbiage, so thank you.
Okay.
Thank you, Madam Chair. Madam Chair, may I ask a question, please?
Enforcement Counsel Lopez, please.
I just want to confirm, can we confirm for the record so for subsection 4, what are the options that the HCA determination notice will be providing to the parties? Because I don't think we ever stated kind of all of the options that will be in the HCA determination notice. And I think there was one suggestion that I'm not sure if that's something that the commissioners have adopted or not.
Enforcement Counsel Lopez, are you asking about D and E and the actions that were taken by the commission?
Under subsection 4, if the commission determines that an HCA does not comply, then the HCA determination notice shall provide the following: the factual basis, and then it goes into the options for the parties. The first option being correcting the noncompliance and amending. And so I don't think we've stated what are all the options that are going to be presented to the parties in that determination notice.
Got it.
I think I just, so we now have A, B, and C. A, B, C, the new D about the model HCA. We've eliminated D and E that was here. There's a new 5 that contains part of the original D, and then 5 becomes 6. Enforcement Counsel Lopez, do you mind restating your question?
Yes, so in the chat, one of the ideas that was presented was the determination notice to include 4 options. 1, amend the HCA and resubmit, which is already there, waive the HCA, proceed under an interim HCA that conforms with the model HCA, and the 4th one being a termination of the contractual relationship between the host community and the licensee, by submitting a mutual abrogation agreement executed by both parties, which would institute the wind down process under the equitable relief. That was the fourth option that was presented in the chat. And I don't think that the group decided if that is in or out.
I don't know if we've discussed it at all, to
Don't think
be
we-
frank. So who's, my fellow commissioners, is this Commissioner Camargo? Was this the wind down?
Correct. I
Okay.
don't know where the language came from though, which is very
It was
helpful.
Commissioner Roy put it into the chat.
Commissioner
So it may
Roy,
have been
okay.
just a deliberate decision not to include that option, but that's why I think we want to just state for the record, what are the options that the commission has decided will be in the HCA determination notice?
Madam Chair, can we have a minute to read it since?
Yes, Commissioner Camargo, I agree. Let's take a moment,
I mean, thank you
review it.
for putting it. I think we were talking and didn't notice it was in the chat.
Oh, and this is the mutual language. Got it. Commissioner Roy, first Commissioner Camargo, are you good to go? You've had some time?
Sure.
Okay. Commissioner Roy, is the suggestion to use this language in the entirety? So this option would institute a wind down process. So that language, all of it would be included as, okay.
Commissioner Roy, did you just write this?
Attorney Lopez.
Oh, good.
Attorney Lopez.
Is there, if I may,
Commissioner Camargo.
is there anything that we need to add in terms of timeline? Like notice or anything like that? Like 90-day notice or 180-day notice or anything?
Commissioner Camargo, are you directing it to Enforcement Council?
I guess just all of us, just a conversation. Yeah, Enforcement Council and just, I would say to the body.
Madam Chair.
Yes, Director Putnam.
Commissioner Camargo, I believe for the HCA determination notice, which also could include notice of deficiencies or request for information in a previous section, it's tied to that 90-day requirement. So a time frame, I think, is already established.
So I'll ask my fellow commissioners. I guess I'll go down the line. Commissioner Camargo, do you have any questions or comments? Do you believe that this language should be incorporated into the draft?
As of now, yes.
Commissioner Roy? Commissioner Stebbins?
Just give me a minute, Chair.
Yes, Commissioner Stebbins.
Sorry, thanks, Madam Chair. Again, as I suggested before, I struggle with our notice being more than how you can remedy the HCA determination notice that we're passing down. I think this kind of goes a little bit beyond that. So I'm not sure if I'm interested in the language. I'm just curious as whether it's something, again, I think to the point you raised, does it belong here or does it belong in the next section? I'm just thinking of what we're making a determination that the HCA is not in compliance. This goes back to my previous point. We're saying you can amend the HCA and resubmit. You can wait, go through the process of waiving the HCA. you can execute and sign an interim HCA while you're negotiating a new HCA. I think language around ending the contract relationship really shouldn't come out of a determination notice with respect to being in compliance with the HCA.
Enforcement Counsel Lopez, and then Commissioner Roy. Enforcement Counsel Lopez.
Thank you, Madam Chair. In response to Commissioner Stebbins' point, if the commissioners were to agree and want to adopt that, what the commission could do instead is in the equitable relief section, we could say if a host community discontinues relations with a marijuana establishment, comma, or if the parties mutually abrogate the HCA, comma, then a marijuana establishment may submit a request for equitable relief to the commission.
Commissioner Stebbins, if
I'm
you want.
much more comfortable with that suggestion.
Commissioner Roy.
I might be less comfortable with that suggestion because it's advertising just to the host community to walk away, where this is a mutual agreement, a mutual abrogation agreement without language, that first language proposed by Councilor Lopez. This would be executed by both parties and it's, it's mutual.
I'm sorry, Madam Chair.
Commissioner Stebbins, I see Director Poppin waving as well, but go ahead, Commissioner Stebbins.
Okay. No, I appreciate that, and I like the mutual agreement between both parties. I know Council Lopez is probably writing up her new language, is about to drop it in the chat. If not, I would encourage you to do that, because I'm intrigued by it. Again, I just don't, I'm just not seeing the relationship of it being under the HCA determination notice, not
As an option.
kind of the other piece.
Director Poppin.
Thank you, Madam Chair. Commissioner Roy, I hear your concern. We obviously don't want to advertise that that's an option in the sense of municipalities here take this option.
Yeah.
However, just from a practical reality, and again, this is obviously a policy for the commission to determine, but from a practical reality, not mentioning that situation as a possibility and what they are entitled to, seeking that equitable relief from us, if that situation happens, I could see us sending an HCA determination letter or notice, and the next question back is, well, my situation is not covered here. My situation is the municipality is not agreeing to renew my contract. And then we would have to tell them, oh, you're entitled to equitable relief, instead of capturing it in the notice already, which there's an element of this determination letter notice and a notification requirement to put the parties on quote unquote notice of what their rights are and what their options are. So I think it could be softer language without like maybe advertising it.
Overt.
Like be a little bit more gentler, possibly. But I think withholding that possibility is almost possibly doing a disservice to the person that finds himself in that position and knowing that they have a right to request equitable relief.
Commissioner Roy.
Let's flip it on its head. So, and I know this for a real life scenario. We keep talking about the municipality walking away, but I know of situations where the licensee has wanted to walk away from the municipality. I know we have jurisdictions under the license of the licensees and not the municipalities, but we can serve them notices of determination. We can serve them, we can do sanctions. Are they entitled to equitable relief? Because if a licensee says, I no longer want to be in this town, is the municipality entitled to equitable relief?
Attorney Baker.
They can go through the courts if they're looking to argue against the actions taken by the business there. That is their option.
Where the licensees can turn to us for equitable relief and the courts. Okay.
Director Poppin.
So it may be a little bit more of an open question, and it may not be as clear as how I'm probably going to describe it, so I want to be careful here. We've talked about this at several times today, is the freedom to contract. And forcing the commission being able to force a party into contracting. There's also the other side of that is forcing somebody to run a business. There's some potential issues with that, and that reverse flipping it on its head type of situation is no, you have to stay there and you have to work that business. I don't know, it provokes some problems there, but again, I want to be careful on how I phrase it, but that's just an initial thought.
And the reason I bring it up is because we've been looking at from one side of the equation, and I just wanted to explore the other side of the equation and make sure we weren't missing anything as a body.
I'm reading this language and I wonder if it goes beyond, I'm trying to be mindful of my words. The requirement of that mutual agreement before either party can step away from that relationship, the contractual relationship. Okay, Enforcement Counsel Lopez.
I think what it's saying is not that the agreement has to be executed before they can step away, but before they request equitable relief on the basis of the relationship being over.
Got it. Thank you. Thank you. Okay. Are there any other questions about this language? Commissioner Stebbins.
I like the new language. I like the suggestion that it be in it leads off subsection 6. I think it speaks to Commissioner Roy's concern about, a mutual agreement or a space for a mutual agreement. Again, I just see that suggestion being outside of the bounds of what we would be sending out in an HCA determination notice.
I have another concern that I'll voice because Enforcement Counsel Lopez, if that's the intention here, what we're saying is that an ME cannot request equitable relief unless they have a mutual agreement. Enforcement Counsel Lopez.
We're saying if the host community ends the relationship, or if both parties agree to end the relationship, in either event, the ME can seek equitable relief.
And now I do not understand the utility then, because essentially what we're saying is if the relationship ends, if there is no longer that contractual agreement, that relationship, either way, whether it's agreed to mutually or unilaterally, they can seek equitable relief. And then in that instance, I'm confused about why we would include this language. Enforcement Counsel Lopez.
I think Commissioner Roy can certainly speak to this, but I think I hear what you're saying. I believe that the original thought behind this being in the notice was to discourage the situation of a host community walking away, just walking away, pulling the rug out from underneath the licensee by saying that the options that are available are amending the HCA, waiving the HCA, proceeding under an interim HCA that conforms with the model HCA agreement, or both parties mutually agreeing that it's over versus one party saying it's over and the ME being left with very little recourse after its substantial investments in the host community. That may have been the thinking there.
I'm indifferent. If we want to include it, we can. I just, in terms of what it does.
You're saying there's no value to it because if they walk away, they still are entitled to equity.
Exactly.
Even if it's not mutually agreed upon.
Exactly. That's how I'm reading it. That's why I'm trying to understand this a little bit more. Commissioner Stebbins?
Yeah, no, thank you, Chair. I actually look at it as this new language is opening the door more for the marijuana establishment to seek equitable relief. I think the original way we had it is the host community makes the decision to discontinue, then the ME can seek equitable relief. I think we're offering a second scenario where an ME could seek equitable relief. Actually, for the benefit of the ME, I think at the end of the day, as I'm reading it, but.
I know the utility in it.
Okay, Commissioner Roy?
Yeah, just like hit me like a 2x4. Okay, so if it is, if the host community discontinues relations unilaterally versus a mutual, the one that was discontinued unilaterally may be entitled to more equitable relief because it was a unilateral decision and they didn't want it. But if it's mutually agreed upon, maybe they need less equitable relief because they agreed upon the dissolution. Whereas if it was just party walked away, we might say, well, maybe they need a higher level of equitable relief. Versus if it was mutual, maybe they need less equitable relief because it was mutually agreed upon. That's the utility I see in it.
Commissioner Camargo?
I'm just saying, it provides some protection. And in the wind down process, right? This is the scope behind it was to capture some of the wind down process.
Dictate the level of equitable relief.
Okay, all right, so I guess I'll stop and take a temperature. Commissioner Stebbins.
I'm comfortable with this new language. I'm more comfortable with it being moved down into the equitable relief section than being left above in the notice section. So I'm comfortable the way it's written and where Council Lopez suggested we go.
Commissioner Roy.
How do you feel about it? So we're not listing it as an option. We're not like, you don't want it listed as an option.
No, I think Councilor Lopez's suggestion is put it down into subsection 6. It's not what would come out in a HCA determination notice.
Attorney Baker, would you mind reading what section 6 would read with this language?
Thank you, Madam Chair. Just give me 1 second. I'm going to have Mercedes pull it up on her computer.
And Commissioner Stebbins, your suggestion is to tack it on to the end of what we've agreed to in the new in section 6.
I think what Councilor Lopez is suggesting is that she's suggesting this is the new language to kick off subsection 6.
Okay.
So where right now it reads, if a host community discontinues relationships with an ME, then an ME may submit a request for equitable relief to the commission.
Okay, yes.
She's just adding into that submission of a mutual abrogation agreement.
And Enforcement Counsel Lopez, are you able to read what that would read, how it would appear in our regulations?
Sure, and just something to keep in mind, if we don't put mutual abrogation in there, then this ability to obtain equitable relief is limited to one scenario, which is a host community unilaterally ending the relationship. But what if both parties decide, you know what, let's just cut our losses and move on, this isn't working out? We would want to be able to, the policy idea is, would that ME in that situation where they're agreeing with the host community that the relationship should be over, would they also be entitled to equitable relief? So the language would read subsection 6.
Thank you.
If a host
That's
community,
helpful. Thank
Sure.
you. That's actually, okay, go ahead.
If a host community discontinues relations with an ME or on submission of a mutual abrogation agreement executed by both a host community and an ME may submit a request for equitable relief to the commission.
Thank you. Thank you, because now I'm in agreement and I'm okay with the placement, the language, that makes sense to me. Commissioner Roy?
Me too.
Okay.
Yep.
Commissioner Camargo? Okay, that is her sign of
Consensus.
consensus. Okay. All right, we can move forward. Now, we haven't even, there's a whole new meaty topic now. So I believe we're on community impact fees. Attorney Baker.
Thank you, Madam Chair. Okay, so subsection 4, community impact fees. Up first is general requirements under A. Pursuant to MGL Chapter 94G, Section 4A and a half, the Commission is charged with establishing criteria for reviewing, certifying, and approving community impact fees. To qualify as a community impact fee, an impact fee claimed by a host community must be reasonably related. 2, on certification by the Commission, a community impact fee becomes properly due and payable unless disputed by ME consistent with 935 CMR 500 184C4A. 3, a host community may assess a community impact fee as a condition of allowing a licensed applicant or a marijuana establishment to operate or continue to operate in its community.
We'll pause there. Commissioner Roy?
I just want to highlight the letter again, and this might go back to the definition. So the MMA highlights the framework for review and approval of community impact fees continues to lack clarity and transparency necessary to create a predictable process, while the definition of, quote, reasonably related as to require, quote, enhanced need is incompatible with the existing definition in Chapter 180. Additionally, the process heavily favors the licensee, giving significantly more time for the licensee to pay out its impact fees and unnecessarily limit a host community timeline. Now, the bottom half we will address as we move on, but I just want to go back to the enhanced need and reasonably related, and if we as a body are good with the definition that our working group came up with.
Okay, I will read into the record what Chapter 180 outlines for community impact fee. The community impact fee shall A, be reasonably related to the cost imposed upon the municipality by the operation of the marijuana establishment or medical marijuana treatment center as documented pursuant to subparagraph 3. The amount to not more than 3% of the gross sales of the marijuana establishment or medical marijuana treatment center. C, not be effective after the marijuana establishment or medical marijuana treatment center's 8th year of operation. D, commence on the date the marijuana establishment or medical marijuana treatment center is granted a final license by the Commission. And E, not mandate a certain percentage of total or gross sales as a community impact fee. Commissioner Roy, the comment you stated that you relayed says that our draft regulations do not align with that definition of community impact fee?
Yeah, I think they, if I understand this right, as to require, we added enhanced need, and they're saying that the term enhanced need is incompatible with the existing definition you just read.
Okay. We can continue unless there's more comments or questions, or if you wanted to, if there was a suggestion that you had.
I just want to make sure that the body is okay with the word enhanced need that the working group came up with for the reasonably related definition. And if we need to look at that, re-examine that definition, or are we good?
I think we can get to that, the actual definition. We've gotten to the term, but not the definite, like what we've laid out as being reasonably related yet. So Attorney Baker, please continue.
Thank you, Madam Chair. I am right now in community impact fee, so it's 4A3. A host community may assess a community impact fee as a condition of allowing a licensed applicant or a marijuana establishment to operate or continue to operate in its community. A host community may also opt not to assess a community impact fee.
Madam Chair.
Yes, Commissioner Simmons.
Again, I apologize, this is a little more semantics, but I think for highlighting the importance of that option, not to assess the community impact fee. We know a number of communities that do not do it currently. I would like to suggest making that number 4 and having it be a standalone number instead of kind of having it buried under the may assess the CIF. Just to highlight what I think is a remarkable step that some communities have already taken, and just make it a new number 4. If, again, I know it's there, but It's just a question of
Stand out.
whether we want to pull it out and highlight it as a standalone measure.
Are there any legal implications to that? So I'll look at our enforcement counsel, your director of licensing. I don't have any objection to it. I just want to see if there's any thoughts or if there might be something we're missing internally. Okay. Our Commissioner Roy, are you? All right, we have consensus. So the number 4 would read, Commissioner Stebbins, do you mind reading 4 and then 5? So what?
Sure.
Okay, thank you.
So the new number 4 would be a host community may also opt not to assess a CIF. The new number 5 begins with a host community shall ensure that the initial invoice period of claimed impact fees.
Blah, blah, blah.
Got it. Okay.
Away Mike's thunder.
Do you guys have that? It's clear? Okay, all right. Attorney Baker, please proceed.
I'm sorry.
Yes. Commissioner Camargo?
Yeah, thank you. Did we have some, and I could be confused, but I'm going to put it out there. Did we have some comment around the 1-year period from DOR versus 8 months or fiscal year? Is that this one?
I think that's down further.
It's down.
Or further? Okay, disregard my comment.
Attorney Baker, please.
Thank you, Madam Chair. So this was originally 4, it's now 5. A host community shall ensure that the initial invoice period of a claimed impact fees covers a 1-year period that starts from the date the commission grants a marijuana establishment a final license. A host community shall further ensure that all subsequent 1-year invoice periods are consistent with the anniversary of a marijuana establishment's final license date. The commission will not certify any impact fees attributable to dates outside of the applicable invoice period. Next section, which is now 6, a host community seeking to assess a community impact fees shall transmit an itemized invoice to a marijuana establishment in a form and manner determined by the commission, documenting claimed impact fees arising from the preceding year of a marijuana establishment's operations. Subsection A, sunshine requirement. A host community shall ensure that impact fee invoices include a specific description of how the claimed impact fees were spent, including each line item for each good or service charge, stating its cost, purpose, and relation to the marijuana establishment's operations. B, a host community shall transmit its impact fee invoice to a marijuana establishment no later than 1 month after the anniversary of the date the marijuana establishment received the final license from the commission. A host community's failure to transmit the impact fee invoice to a marijuana establishment within the prescribed time shall result in a forfeiture of any community impact fee for the applicable year of operations. C, a host community shall ensure that the impact fee invoice is restricted to the license numbers operating from the licensed premises alleged to have impacted the community. For CMOs, a host community shall transmit an impact fee invoice to a marijuana establishment and an MTC.
Okay, let's pause there. Commissioner Roy?
Yeah, again, I'm going to read from this letter. The draft regulations create a framework of the process the CCC will undertake when reviewing the community impact fees, as well as the, quote, sunshine requirement for host communities to itemize each cost, but fails to require a similar spotlight on the CCC's review, offering no predictability as to what cost may be in fact recognizable. Without clarity in definition and transparency in the system, the CCC and municipalities are likely to continue to be bogged down by the process as municipalities see what sticks and the CCC continually makes determinations under a shroud.
Commissioner Roy, do you have a recommendation?
I don't. I just like a legal opinion on this.
Oh, okay. Are you asking, I guess, who are you?
Since Kyle, you're intimately involved with the process, they're questioning the process. So I'll read it again. Okay, I'm going to read it again. They're questioning the process. So the draft regulations create a framework of the process the CCC will undertake when reviewing the community impact fees, as well as the sunshine requirement for host communities to itemize each cost. This is what they're asking. but fails to require a similar spotlight on the CCC's review, offering no predictability as to what costs may in fact be recognizable without clarity and definition and transparency in the system. The CCC and municipalities are likely to continue to be bogged down by the process as municipalities see what sticks and the CCC continually makes determinations under a shroud, which that's a little bit like pejorative that we make it under a shroud, I will say that. But so they're questioning the process of how we make determinations, which we're statutorily authorized to do.
So Director Poppin, you now have a copy. Do you mind telling Director Poppin where he can find that language in the hard copy?
Sure, B, second paragraph under B.
Okay. And Commissioner Roy, your question is?
Do they have any validity on this? That's
okay. Is that Director Poppin, please? Yeah. And I see our acting general counsel Carter as well. So.
Well, Madam Chair, if I may recommend, if Acting General Counsel is on the screen, I'll defer to him first if he wants to go first.
Okay, Acting General Counsel Carter, please provide your comments.
Yes. If you don't mind, I would like to put the option out there for Commissioner Roy. If she would like to receive legal advice confidentially, we certainly can meet offline as well. So I did just want to put that option on the table before I move forward.
So I think no one else wants that answer, just me.
I think I'm not completely clear about the question that you're asking, if I'm honest. So can you paraphrase the question?
Okay.
Your
this
question
is
if we have a process?
This is my baby, the sunshine requirement. So they're kind of taking aim at what I, advocated for. So it's not, I'm not advocating for anything. I'm just, for the record. So the sunshine requirement for host communities is requiring them to itemize each cost. And I guess what they're saying is, but it fails to require a similar spotlight on the CCC's review. But I don't agree with that because they're gonna get a determination. We have the right to strike, so they will get a determination. I guess in predictability, well, nobody can predict because we don't know until these all come in. So I'm trying to refute this. I'm not trying to advocate for it. I just wanted it highlighted because the perception is this body could be just advocating for licensees, but we need to be fair and hear the concerns of the municipalities. I'm trying to be fair and listening to the concerns of the municipalities as well.
Commissioner Camargo?
Yes, Commissioner Roy, I think that Andrew has a question on the table for you, and I welcome, if you don't mind, unless you want to go in private, but if you don't mind, I would like to hear it as well.
Yeah, so I don't need to go private. Thank you, Commissioner Camargo.
Acting General Counsel Carter.
Yes, if I may, Madam Chair. Commissioner Roy, thank you for the question, and I do appreciate your elaboration as well. Obviously, the commission has to operate under the open meeting law. The other legal requirement that we have to operate under is the public records law. So the sort of us showing our work is certainly something that we do have to disclose publicly. So I certainly believe that our transparency obligations in those regards may satisfy some of the concerns that have been identified. But that would just be sort of my initial reaction.
Commissioner Stebbins?
Sure. And I appreciate the point that the MMA folks are making. And I'm looking at it as we're under community impact fees, general requirements, a general requirement to this point of the process is asking the host community to, under the sunshine requirement, ensure that the impact fee invoices include a specific, we're essentially telling them the information that we're looking for. And if I'm hearing it correctly, we still haven't got down to what our review and certifications of community impact fees might be. So I hear what they're saying. I think where we have this is just a general requirement of making sure the community impact fee is assessed and reviewed and paid. It's got to start with, you got to give us essentially an invoice, and we're kind of detailing how we want that invoice to look. I think that was the crux of what you were trying to do.
Yeah.
But I think we'll get to some more clarity about our review of it, our transparency of our review of it, to Attorney Carter's point.
I agree. Commissioner Roy, that's good. Okay, Attorney Baker, please continue.
Thank you, Madam Chair. So we are currently on 4A7, which is formerly 6. Within 30 calendar days of receiving a host community's invoice of claimed impact fees, a marijuana establishment shall submit the invoice and any supporting documentation, if applicable, to the commission in a form and manner determined by the commission. 8, a marijuana establishment that has agreed to pay a community impact fee under its HCA shall annually pay any undisputed community impact fee no later than 8 months from the date of receiving a host community's invoice of claimed impact fees. This subdivision shall not be construed to require a marijuana establishment to pay a community impact fee if a marijuana establishment's payment obligation is the subject of a non-frivolous legal dispute, either before the commission or a court of competent jurisdiction.
Okay, I'll pause you there. Commissioner Camargo.
Thank you. If I can have a moment, because I have some notes on this. I'm actually want to go back to number 6, within 30-day calendar, within 30 calendar days of receiving a host.
Receiving a host community invoice of claim impact fees. A marijuana establishment shall submit invoice and any supporting documentation, if applicable, commission in a form and manner determined by the commission. So just these are notes to myself. I'm going to say them out loud because this is just sort of what I was thinking. Can operators submit argument as to why the asserted community impact fees are not reasonably related to the actual cost imposed on the municipality by the operator? That was a question that I had, and I think it allows both sides to tell their story. I guess it's a question. It's a question about this section. Within 30-day calendars. Can operators submit argument as to why the asserted community impact fees are not reasonably related to the actual cost imposed on the municipality by the operator?
Commissioner Camargo, are you asking if there's an opportunity for licensees to
Yes.
dispute a claimed community impact fee?
Correct.
I believe that is accounted for in this section. We're just not there yet.
Okay. So that may answer my question to this. Thank you.
Are there any other questions before we continue? Commissioner Stebbins?
Is we're looking at the new number 8. I'm trying to go back and find it. I thought there were some comments that we received from our counterpart at
I put it in the
DOR.
chat. I just put it in the chat.
Commissioner Stebbins, are you asking for some background in terms of why that 8 months is there for marijuana establishments?
Yeah, I have a question around how you might have landed on the 8 months. At the same time, I'm looking at the language, again, the feedback we got from our counterparts at DOR about what makes, what their recommendation would be.
I believe DOR's, and I'm paraphrasing, correct me if I'm wrong, their question was around why it wasn't the same time frame. So host communities had one timeline to give essentially the receipt, and then MEs had 8 months here to pay the imposed community impact. Is that your question? I just want to make sure that I'm understanding you correctly.
Yeah, thank you. I appreciate trying to just gain some clarity again, how we landed on the 8 months, and then how we might review DOR's comments and what they're suggesting.
Okay, hold on one moment. I have those comments.
I put it in the chat.
Okay. First, I will let Commissioner Commissioner Roy, do you mind reading it into the record?
No, yes, I don't mind. I'll read into the record, but the intent around the 8 months, and Kyle, correct me if I'm wrong, Director Potvin, is that the statute reads they no later than 8 months. So that was the window. No, the statute doesn't read that?
Wait, let's pause. So Director Potvin.
Oh, you want me to read this?
No. I just before, I know he's ready to provide the explanation. Maybe let's just let him provide the explanation. So please explain to the commission why and how we landed on that 8-month period.
Thank you, Madam Chair. And I think originally, so it's twofold. One, when we were looking at the payment of the CIF and how it's tied to the final license date, we were doing an analysis based on provisional license dates and the fact that it would be part of the renewal application instead of a separate process, because the statute requires that it be tied to the final license, which would not correspond with the actual renewal. So that was a misconception, but the rationale behind it is going off that misconception was that they were going to be able to tie into the next provisional license renewal, which doesn't make sense anymore. However, the second aspect of it was to allow licensees more an abundance of time and to be able to pay that community impact fees in installments or give them more time to make sure that they could account for it versus the normal 30 business days, 60 business days, 90 days that are usually part of typical business transactions. But that's where the 8 months came from. So it's kind of it is a misconception or a mistake in the original analysis when we were working it out, because it's tied to not the provisional license date or the renewal. It's the renewal of a final license, which is completely different. But that's a requirement in statute.
So I have the comment here. The recommendation we received was to replace that language, so the language under subsection 7 here, with the end of the current fiscal year or with 90 days, whichever is later. And the rationale behind that is that it's not workable as it relates to communities predicting when revenues will come in. Is that correct, Commissioner Stebbins? Was that the comment you were referencing from the Department of Revenue?
It is. It is.
And I don't, so Commissioner Roy, you started, I stopped you.
No, because I misspoke, but Director Potvin just explained it so eloquently. So thank you for that. And yeah, I'm good.
Okay, Director Potvin, in light of that recommendation, do you have any thoughts on that? So changing the 8 months to the end of the current fiscal year or with 90 days, whichever is later?
Some thoughts are, because this will need to be a separate and distinct process from our regular annual renewal, it's already going to be a 2-part process. So obviously there was some good faith by the working group and good intentions to give licensees as much time as possible. However, reading the public comment, having the conversation with the Department of Revenue, myself and Enforcement Counsel Lopez and Director Giancola, their rationale does make sense from a municipal finance perspective on predictability of being able to file their budgets and be able to predict the income and the revenue that they will be able to get and when they will be able to get it. There was significant rationales behind that, and again, municipal finance law not being my bag, I can't really do it justice, but it was the rationale that they provide here. It does seem reasonable.
And is that reasonable internally as well?
So I guess it's still a policy decision for the commission.
I understand that.
So, but with that being said, is it feasible so at this point in the stage of this, when it comes internally to the internal process that's proposed, we've already certified the amount. We've already put the municipality and the licensee on notice of what we certified as a community impact fee. This is just letting them know, the licensee know when they need to pay it by, and also putting the municipality on notice of when they should expect it by. So is it reasonable within our process at this point? I do believe so. I don't see any process issues on our end because at this point, we are actually kind of out of the mix.
Commissioner Roy?
Can you explain to me, so I understand the end of the current fiscal year, right? So that the fiscal year ends the end of June? Okay. Or with 90 days, what does that mean? Like, when is the 90 days? I'm confused by, or with 90 days, whichever is later. When does the 90 days fall? I don't understand what he's saying.
So it would be within 90 days of notification of our determination of what we certified as a community impact fee.
Oh, okay, I see. So after the determination, they either have 90 days or till the end of June.
So two different scenarios is one, if we made our determination June 1st, they would have 90 days. If we made our determination on January 1st, they would have until the end of June.
Whichever is later.
Exactly.
And no, thank you.
Commissioner Stebbins?
Thank you, Chair. I appreciate that. I think this change is helpful. In a bigger, broader perspective, these are costs that aren't being challenged, if I'm correct. Because this just talks about paying CIFs under the HCA that are not subject to any dispute, not frivolous legal dispute. So they're paying something that it looks like they've agreed to pay, or they agree with the amount and the purpose.
Or they agree with the determination.
We're saying, or they agree with the determination. You know, obviously, I think we want to have healthy relationships between our host communities and our marijuana establishments. So as quickly as a licensee or an ME may be able to make a community whole, I would encourage, but I think the language here, and maybe it wasn't submitted correctly, but I think you picked up on it, Director Poppin, is the end of the current fiscal year or within 90 days, whichever is later. I think they're just a little bit of a typo in their proposed language.
Okay. With that being said, first, Commissioner Camargo, did you have any questions or thoughts?
I don't right now.
Okay.
Thank you.
Okay, so let's, do we have consensus on replacing the term 8 months with the term the end of the current fiscal year or with 90 days or within 90 days, comma, whichever is later, comma. I must have made a mess, I came home. Do we, I'll look at my fellow commissioners, Commissioner Camargo, Commissioner Roy, Commissioner Stebbins.
Asking you a question now because of what Director Poppin said. She'll pay any undisputed CIF no later than the end of the current fiscal year or within 90 days. But I'm not sure the rest of that sentence is.
Oh, I see. Oh, Enforcement Counsel Lopez.
Thank you, Madam Chair. I did provide some proposed language in the chat for a new subsection 8 for the commissioners to consider.
Okay, so that new proposed language reads, a marijuana establishment that has agreed to pay a community impact fee under its HCA shall annually pay any undisclosed community impact fee no later than the end of the current fiscal year or within 90 days of the date of the Commission's community impact fee certification. This subdivision shall not be construed to require a marijuana establishment to pay a CIF if a marijuana establishment's payment obligation is the subject of a non-frivolous legal dispute, either before the Commission or court of competent jurisdiction. Okay, it looks, Rebecca, did you, Enforcement Counsel Lopez, was there a quick edit that just happened, or did I?
She added that whichever is later.
Yep, I added in that clause from DOR, my apologies.
Okay, I'll restate it. So the new proposed language, we're at 935 CMR 500.180.4A8. A marijuana establishment that has agreed to pay a CIF under its HCA shall annually pay any undisputed CIF no later than the end of the current fiscal year or within 90 days of the date of the Commission CIF certification, whichever is later. This subdivision shall not be construed to require a marijuana establishment to pay a CIF if a marijuana establishment's payment obligation is the subject of a non-frivolous legal dispute either before the Commission or a court of competent jurisdiction. That is the new proposed language. Do we have consensus on that language? Okay. Director Poppin.
Madam Chair, may I ask for a 5-minute recess?
Yes, you may.
Thank you.
So, okay, it's 5:12. What's the simplest way to do this? It's kind of, let's 5:20. Is that too long? That's probably too long.
5 minutes.
That's fine.
Okay, well, all right, let's say 5:18. So we'll recess until 5:18. Do I hear a motion?
So moved.
Motion by Commissioner Stebbins. Do I have a second? Second from Commissioner Camargo. Do we'll call the roll. Commissioner Camargo. Commissioner Roy. Aye. Commissioner Stebbins.
Aye.
Chair votes aye. We have 4 in favor, none opposed. We are recessed until 5:18. I just shaved a minute, didn't I? Okay, we are back from recess. It is now 5:20. I believe this is a good time to put a pin in things. And so we can have a chance to get some rest, come back clear. So I want to sort of manage expectations for tomorrow and then Thursday. We are stopping today on page 73. We'll pick this up at prohibited practices. The goal tomorrow will be to conclude host community agreements, and that includes circling back to that date language so that we can just wrap that up and then go into municipal equity. Tomorrow's HCA's, municipal equity, and then on Thursday, we go into agent suitability, and then a review of the entire draft to finalize. We will be finalizing on Thursday. That is the goal. Thursday might be a long day, but I'm hoping that tomorrow we can get through HCA's, and then when we get to municipal equity, I don't believe we need to go line by line. There was not a large amount of our public comments were geared towards host community agreements. So for tomorrow, I might just ask if there are commissioners that have questions or issues that they want to raise. We'll go to those sections. Okay. Are there any questions on anything that I've stated thus far? All right, it's 5:22. Commissioner Camargo?
Yeah, thank you. So Thursday, we're completely virtual.
Yes.
And we'll go 10 to...
Until we get it done.
Okay, 10 till we get it done.
10 to get it done. It might go way past 5, but at least you can.
Right, we're
home.
Right, we're home. Okay, so I want to just kind of clarify that.
Sorry.
Go.
That's my question.
Okay. I know there's a couple of things that we've put a couple of pins on here and there. I don't know if our team is going to kind of look at that and sort of bring us back to what those pins are. I, for myself, want to bring back the equity participant definition and sort of introduce that. Andrew had created some language today. Andrew had mentioned yesterday that he would look at it. So I'll maybe have it tomorrow. Maybe what I'll do is either send it or give it to us in the morning just to sort of look at and kind of have the conversation.
That's helpful.
I know that we have a pin on the portion around the chiefs of police and chief of public health in terms of conditions or that section in term, at least for myself, I know we put a pin in it.
I know you can see my mind. I'm going back and forth just to picturing the section in my head.
I could tell you the section. I mean, I could send it all to.
I'm just saying what popped. That's the that's still an HCA.
Yes, it's still HCA, correct.
Okay.
So HCA. And I also have I think the conversation we got to was, if we leave it in, I wanted to propose some language for conditions.
Yes.
But I think we haven't decided whether we leave it in or take it out, but either way, I have some language for that.
I'll pause there because Acting General Counsel has just posed a question to you, Commissioner Camargo.
Okay.
He asked if you wanted to introduce the language now since you are in open session, or if you wanted to wait until tomorrow.
Oh, I could, yeah.
Okay.
So, okay. And let me just get my list.
I might pause
Yeah.
because
I don't have to introduce it today.
Wait, what are you introducing?
it's language around
The definition.
the definition.
Yeah.
I think I'll ask for you to pause and introduce it tomorrow.
Yeah.
Just because,
I'm fine with that.
okay, so we
I'm
can.
completely fine with that.
Okay,
Also, I'm happy to, I guess I can't email it to all of us, but tomorrow morning I could send it, right? Or introduce in the chat, sure, that's fine. So then the other thing, obviously, the May 1st date. And then I had a pending question in HCA, and I think Rebecca, Attorney Lopez answered it, but I want clarification on it as well, and it's around HCA's and both parties, municipalities and operators, and it impacts community impact fees. If they are in agreement in terms of their contract, is there something that we can put together, a simple form or something, blah, blah, blah. So I can talk about that again tomorrow. I think she had said that per the law, we have to review every HCA. So I just want to get some clarification on that again. I still want
She
to.
did. She
Yeah.
stated that on the record. So your question is whether or not they can opt out of the review.
Correct.
And the response that Enforcement Counsel Lopez, and I'm paraphrasing, and you can correct me if I'm wrong,
Yeah.
was that it was a statutory requirement.
Yep. I may put it, and Attorney Lopez, I may ask for private counsel tomorrow for a couple of minutes, because I understand, but I still want to understand, and I may want to just talk to you offline for a minute. So that's my pending question, and then, so that's it, so that's what I have. So just kind of like, so you know where I'm at.
That's good, and that's helpful. So, and that is all a part of the HCA component. So before we move into municipal equity, we will just make sure we circle back and have those issues resolved. Are there any other questions from Commissioner Stebbins, Commissioner Commissioner Royce, please?
No,
Commissioner
just-
Stebbins, please.
Just closing thoughts, and I appreciate what Commissioner Camargo was talking about, because I've equally bothered Enforcement Counsel Lopez on a waiver question and worked on language, but not only on HCA's, but also where we might have an opportunity to think out of the box in a regulatory sense around our review of community impact fees. So I'm looking forward to that discussion. And again, just want to thank all three of my colleagues and our team. I'm sorry if I didn't do that yesterday, but thank our entire team and my three colleagues for the sausage making and meeting work we went through today, and excited for more tomorrow and now more Thursday.
Okay.
Can't get enough of Ray.
And according to our calendar, our notice was for 9 o'clock tomorrow.
9:30, I believe it.
9 o'clock, it's 9 o'clock on the commission calendar. Acting General Counsel Carter, do you mind clarifying the start time for tomorrow, if it was 9 or 9:30?
I can pull up the notice, 1 second.
Oh, 9:30 on Thursday.
Sorry.
In the meeting update. I read it today.
You know, I wanted the 9.
Yeah.
Cheerleader.
9 a.m.
I mean, we got a lot of work to do. I'll bring you guys coffee again.
It's not the coffee, it's getting
It's the
through.
traffic, you can eliminate that.
Listen, I know, it took me 2 hours to get here.
Oh, Lord, okay, all right. With that being said, Commissioner Stebbins, do I have a motion to adjourn today's meeting until tomorrow at 9 a.m.?
So moved.
Commissioner Camargo, do I have a second?
I'll second that.
Okay, we'll do a call of the roll. Commissioner Camargo.
And I just want to say thank you so much to the team and my colleagues. This is really difficult, and for what it's worth, we're working through it. So I just want to say thank you to everybody.
Commissioner Roy.
And I also want to thank everyone. This is an easy process, but everyone has brought value to this process. It is very much appreciated. So thank you.
Commissioner Stebbins.
Again, thanks to everybody, our incredible team, my colleagues, and to our audience member, Dave O'Brien, for sticking with us the entire time. And I'll vote aye as well.
I'll ditto those comments. Thank you to the team who's here with us every step of the way and then some. And I will see you all in the morning. Thank you. And with that, we are adjourned. Oh, the chair votes aye. We have 4 in favor, none opposed. We are adjourned until tomorrow at 9.